Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are turning our attention to a trial that happened out of Ohio. It is against Ruth Miller. And this one hits a little bit close to home because I grew up just a little bit north of where this happened. So we have a full day for you. So get comfortable, settle in, and let's get started. All right. Good morning, everybody. Welcome in. Welcome in. As I said at the top, this one is going to be a little bit personal for me because I did grow up next to an Amish farm, and I went to school up until 6th grade with an Amish boy named Wilmer, and this happened just south of Canton. So we will get into it. We have a full day ahead for you. But let me welcome in the folks that are coming in. Shannon, good morning to you. Kimbers, good vibes only. Good to see you both. Linda, good morning, good morning. Welcome in. Good vibes, saying hello to everybody. Tammy, Snap, hello. How are you? Camilla, good morning to you both. Let's see. We have Brenda coming in. Brat, good morning to you. Crazy Mary Fitz, great to see you. Kaylee and Heidi, hello. Welcome in, both of you. Hey, Green-Eyed Cat, great to see you. Let's see. Let me scroll up a little bit here. Hellrider, good morning. How are you doing? Sweet Vampy, good morning. Hey, William, how are you? Let's see. Let me scroll up a little bit here. Get closer to where we actually went live. Iowa Backyard Cam. Yes, this took place in Ohio. Just south of Canton, Ohio. I'll geolocate us in a second. Hey, Rev Ben, how are you? Welcome in. Cindy Davidson, welcome. Let's all hit the like button as Iowa Backyard says checks to make sure. This is a good time to make sure you guys hit the like button. Anna, good morning to you. Thank you for joining us. Hey, Alex the Dane Mom, great to see you. Yes, Heidi, the description is always a great preparation. Thank you for that. I'll read the description as we get started. Fanny, how are you? Good morning. Selena K, hello, hello. Welcome in. Aussie Gardner, great to see you. Hey, Skrubnik, how are you? Benishi, good morning. Is this the review? It's going to be the trial as well. The trial already happened, so we're catching up actually. Angelique, how are you? Good morning. All right. So, yeah, the trial happened a little bit earlier this year in March. So I'm going to read our description. All right, on August 24th, 2025, what began as a family outing to Atwood Lake ended in tragedy. Prosecutors allege Ruth Miller, an Amish mother from Ohio, threw her 4-year-old son, Vincen Miller, into the lake where he drowned. During the same incident, her husband, Marcus, also drowned. Authorities further allege that Ruth then drove a golf cart carrying her 3 older children toward the water before they escaped. They were all teenagers, so they were able to escape. So Miller was charged with aggravated, felonious assault, child endangerment, and DV. Rather than disputing what happened, the central issue in the case is Ruth Miller's mental state at the time of the incident. She did enter a plea of not guilty by reason of insanity, according to court testimony. Well, we'll get to that. We'll get to all of that. So that's kind of the backstory. And I want to start by geolocating us for those that do not know where this is. All right, so this is deep in the heart of Amish country. So this is the lake in question, but it is, as you see, there's Canton just a little bit to the north. There's Canton, and then you've got Akron up here, and Pittsburgh is over here, so that's Pennsylvania. So this is deep in the heart of Amish country. Of course, Cleveland is up here, a little bit north. And then as we zoom out a little bit, for you that do not know the United States, this is Ohio, which is considered the Midwest, but is very close to the eastern seaboard of the United States. All right, so that kind of geolocates us. So this is the lake in question that this happened. All right, so this is the lake in which it happened. All right, so just a little backstory here before we get started. So, what actually is Amish, right? What is Amish? All right, so I'm just going to read from a Wikipedia page, and then I'm going to actually go to a page that I found, Amish country, and this is the Ohio Amish country. I'm going to show you this website as well. Well, actually, let me pull this up while I read from it. Let's see here. I can go ahead and pull this up while we read a little bit about it and give you guys a little bit of a background here. All right. All right, so Amish, or also known as Pennsylvania German, they go by a couple different names. Formerly Old Order of Amish are a group of Christian church fellowships from the Swiss and Alsace origins, which is France. They maintain a degree of separation from surrounding populations. They have been described by scholars as ethno-religious, combining ethnicity and Christian denomination. So they are closely related to Mennonites, and they are known for their simple living, plain dress, Christian passivity, being passive, pacifism, and slowness to adopt many conveniences of modern technology. Now, again, growing up next to an Amish farm, I actually have a photo that I want to show you guys. Let me just hold on a sec. I can attest to their simpler ways of life. So, as I said, this one is close to home to me, probably the closest feed that I will do for you guys, other than having my friends and family actually on a stream. All right, let me show you this. They do not have cars. They travel in horse and buggy. They are very tight-knit community. So here's little Squeegee growing up next to an Amish farm. So they began in Switzerland in 1693. Right, and then they have eventually come over to the United States. They're about 350,000 throughout about 30 states, and I believe the place where the Millers came from, they're from Holmes County, which is just a little bit north and west of where this lake was. And let me see here. Holmes County holds the highest concentration of Amish in the world. It's the heart of the official Holmes County Tourist Bureau region. It has about 37,000 residents, making it part of the second largest Amish community globally. So this is where Ruth Miller was from. Now, unfortunately, I cannot. Trying to cruise around this website, and I'm unable to actually show you all of this website. So unfortunately cannot scroll through here. They make fantastic furniture. Excuse me, I've bought furniture from Amish folks, and it's fantastic. The neighbor that I grew up next to, one time their barn, they had a couple barns. They were dairy farmers, and they had a couple barns. Barn burned down, and within like a week, it was built. It was built up again. It was amazing how the community just all comes together, and if one person is in trouble, they gather together very quickly and take care of each other. The average family has 8 to 9 children. I remember Wilmer. He had I don't know. I think he was the oldest, and that was he. Yeah, he had like five or six siblings. Some households have multiple generations. Average income is below the federal poverty level. Health insurance and education beyond Amish 8th grade are forbidden by the religion. My friend left in 6th grade. He did not go on to 7th grade. So I can attest to that. All right. So with all that being said, that's kind of the backdrop. So what happened obviously is horrific. So we're going to get to body cam first, and then we're going to get to some news, and then we're going to get to some hearings. All right, hold on a sec. All right. So let us settle in. We've got a full day ahead for you guys. Hey, Treasure Hog, Victoria, welcome in. Good to see you both. Grizzly Grandma, hello. Oh Sugars, Christine, Tammy and KS. Nether 3 Paws Fox, thank you for joining us. Shelly Beans, good to see you. Crazy Mary Fitz, you think apple butter? Kimbers, the furniture is gorgeous. Yep, it's solid. It is solid. Built to last, that is for sure. Tammy, you have a lot of Amish in Kansas. Hey, Beach Mom. Well, in 30 states, Amish are located in 30 states, 350,000 roughly in 30 states. All right. So here's the body cam of what happened that day, August 23rd of 2025. And the audio will kick in like 30 seconds, so don't worry if the audio is not, let me just double check. But the audio will kick in a little bit. Darlene, how are you? Hey, Dragonfly Girl. Darlene, it's me. Welcome in. Great to see you both. All right, so this is August 23rd at 11:38. So this happened overnight. I believe the little 4-year-old and the husband happened overnight. And then when she was trying to drive her 3 teenagers into the lake, that's when people tried to stop her. So this is law enforcement showing up. Here we go with some audio.
I gave him to God.
You gave him to God?
Yes.
What do you mean by that?
I threw him in the lake, and I gave him to God. And people are going to tell me I am crazy, but he is real, and he loves you. He really does love you. He loves you. And I doubted him. I doubted him so many times, but I am to tell you he is coming soon. He is coming very soon. Prepare your hearts. The end is close. And I'm for sure supposed to tell you that he does love you. Okay?
Ma'am, can you explain to me what happened? Who did you throw in the water?
I gave my son to God.
Your son?
Yes.
Where's your husband?
He went for a walk this morning.
And you haven't seen him since?
He didn't ever come back. And we went to the boat and his clothes were there. And God told me he's in the lake and a fish swallowed him. And you're actually supposed to go look for him in the bottom of the lake. And you will find the fish. And you will find my husband. And then you will believe. But ye of little faith that did not believe before seeing.
Okay.
So send people down to the bottom of the lake looking for a fish that has my husband.
How old's your son that's in the lake?
4. He's sweet. I love him. I gave him.
Okay. 7/9/40 Central. We're out with the mother. She is advising that she threw her 4-year-old son in the lake to give him to God. Affirm.
So do you believe?
Awesome.
They are there. And you'll find them. And you'll find them. Please don't. I know it sounds crazy. It does. It truly does. I saw miracles. I doubted him. And then pain came back to me. My husband and I both doubted him. Pain came back to me.
I need to know where your husband's at.
He's at the bottom of the lake in a fish.
He's in a fish.
Yes.
There's no fish large enough on an Atwood to swallow your husband.
He's at the bottom of the lake in a fish.
Okay.
I thought your husband went for a walk.
Yeah, and then we came to the boat, and his clothes were laying on the boat.
Okay.
Tan pants and cream shirt and flip-flops.
Do you have a cell phone?
It's in the camper.
It's in the camper. Where's your camper at?
I think it's,
Area 3?
I think so. Yeah. It's like a tannish camper.
It's a tannish camper. You don't know what lot number it is?
No.
'Cause we really need to verify your husband's still with us.
Oh, okay.
Okay.
Well, he's actually just go out in the bottom of the lake.
Well, I can't go in the bottom of the lake. So
Do you have scuba divers?
Yeah, we're going to have to call divers in to go to the
Okay,
bottom of the lake.
please do.
And you're saying
Get the best ones there are, because this is a miracle from God, and you will see. You will see.
you're saying your 4-year-old son's down there too?
He's with God.
Where's his body at?
I don't know.
Where did you throw him in the water at?
Off of the dock at the causeway.
Where the bike was today?
Where the boat was?
Yeah, where the boat. Please believe me. I know.
When there's supposed to be ones coming out there.
I think there was one.
Does anybody have a glass of water?
We can get you water.
Please.
What's up?
Thank you.
We're right now we're gonna walk up to the squad, okay? That's what we're going to do. We're gonna put you in the back of the squad.
You will find my husband.
Okay, but you're gonna sit down in the back of the squad for us, okay?
Can I actually just sit with my children and have water?
Yeah, we can bring your children over.
I would love a glass of water.
Let's go up in this squad over
Well,
here.
my children are here.
We'll bring them over
bring
in
'em
a
over.
minute. Let me go check you out.
Yeah, we're gonna get it.
Kyle went to go get you one.
You guys send the dive team over that way then?
Yeah, we're gonna have.
They're supposed to bring one in over.
Which dock is that so I can tell my dispatch?
That's cluster dock, the center cluster dock.
Center
Or
cluster.
on the causeway. The causeway center cluster dock.
Causeway Center Cluster Dock. 7/9/40 Central. You said it's the Causeway Center Dock, right?
Causeway center.
Causeway Center Dock. 7/9/40 Central. The mother is advising that her boat is located if you just want to log at the Causeway Center Dock, and that's where she threw the child in the water. She's also now saying that the husband's in the water. If you just want to log that and notify the dive team, the Rangers are heading over that way right now.
somewhere where it's not too hard on my knee.
So your knee won't hurt you. Please trust me.
Okay.
It won't hurt you.
Okay.
It won't hurt you. You're fine. You're fine.
Okay.
You're fine. God, please show this woman that it is true what I'm telling you. People are doubting me. And it's getting harder for me to stay strong. Please show her that it is true what I'm telling you. That there is a fish in the bottom of the lake with my husband. Please let her take me to sit with my children under the tree that you have created. Please, Lord.
Hey, let's go.
You guys just want to bring her over to that one?
Yeah, we'll take her.
Okay. So we can be closer to the rest of everybody else.
Paris, have a seat right here and we'll go get your children as soon as they're done.
No, I want to go
Right here.
What are the kids saying now?
I don't know if they've asked them if there's a little brother and dad or not. I don't know if they have.
Okay.
That's it. At this point.
The miracles are true. And these we doubted too, but they are true. They are. And it's amazing. I can't tell you enough. Do you remember when Jesus was on the cross?
Yeah, I remember.
And he put his arms out and he said, "Forgive them, for they know not
Yeah,
what
you
they
told me
do."
that already.
Yes. They didn't know. They didn't know.
Okay. All right.
You are to trust. It's all about trust. It's hard because he does things in mysterious ways.
Sure.
And it's hard because we want to just believe our earthly ways. It is hard. Is part of you happy? And is part of you happy? Yes.
Go ahead. That's clear.
All right, so if you read what I just dropped, hey, P. Cooper, how are you? Welcome in. Thank you for joining us. So if you read what I just dropped, so around 1 a.m. on August 23rd, Marcus and Ruth went to the dock and jumped into the water. After returning to the campgrounds, Marcus told Ruth he was going back to the lake. So what happened, let me just back up a little bit. The couple came from Holmes County to Atwood Lake, and I showed you where those locations were earlier. The couple believed God was speaking to them and were carrying out tasks to prove their faith. So at 1 a.m. on August 23rd, the couple went to the dock and jumped into the water. After returning to the campgrounds, Marcus told Ruth he was going back to the lake. At approximately 8:30, Ruth placed Vincen, who's the 4-year-old, on a golf cart, returned to the dock, and that's when she drowned him. She then, at 10:30, she drove the golf cart into the lake with her 3 teenagers, 15-year-old daughter and twin 18-year-old sons. The teenagers got out of the water on their own and they were not injured. So this happened approximately around 8:30 in the morning. So first they went in by themselves, just the couple. Then she went back with Vincen at 8:30, and then at 10:30, that's when she tried to drown her 3 teenagers. All right, so now we're going to get to a press conference. Let's see what this is about. So hopefully that helps you guys with the backstory a little bit.
So this call began at about 10:39 a.m. on Saturday, which is August 23rd. 911 received a call of a golf cart that had gone into Atwood Lake. And at the time that we received the call, people didn't realize what it was. It looked as though it could have been an unintentional event. It could have just been an accident, but it was a woman and 3 children on that golf cart. There were actually people, according to witnesses, chasing the golf cart through the grass, yelling at her to hit the brakes because they thought it was, careening out of control. We later find out that that's not the case. As the first witnesses arrived on scene, the golf cart had flipped off the edge of a stone wall, which I'll show you here in a few minutes, and landed in the lake. And it was fully submerged, but it was easily visible. The kids, who were 15 and 18, got out of the vehicle and stood on top of it, and then witnesses thereby helped the woman out of the lake. The first witness that arrives to help is asking the woman, does she need help up? And he tries to help, and she suggests to him not to help her, to just pray for her. And that was the first statement that suggested this was more than an accident at that lake. From there, they did pull her out of the water, and rangers were immediately dispatched to the calls, and upon them arriving on scene, they heard some of the same concerning type statements. There was a pretty immediate statement made that she had given her son to the Lord. Now keep in mind, she's there with a 15-year-old daughter and 2 18-year-old sons, and nobody knows what son she's talking about. There's no other child there. And they tried to discern and tried to comfort her. She actually attempted to flee for a minute. She was not rational at that moment. She attempted to flee and hide, and was quickly gathered up and brought back to the scene. They were all taken kind of over to the Atwood Welcome Center, where the rangers began speaking with the children and speaking with the woman, and none of it was just making a lot of sense. There was just a lot of statements that, as we continued to try to put them together, were not rational. Deputies were dispatched to the call about 10:53. I didn't get advised myself until about 11:41, and at this point they're starting to put it together, and they realize there's a problem. We may have a 4-year-old child missing. That's a statement coming from the mother and then confirmed by the teenage kids that there's a 4-year-old son missing, and that the husband and father is missing. Now I will tell you, as we all hear that, you can imagine what we're hoping is, we're hoping she's just sick, and that the father's got this 4-year-old somewhere in the campground. Both of them are missing, and that's the hope that everybody's trying to gather information for. When I'm contacted, I ask dispatch detectives. In the room with me is Detective Captain Adam Fisher, who was in charge of the case, or is in charge of the case, and other detectives responded, and they're actually on scene on something right now. So we begin searching and trying to delineate her statement. Now, there was a lot of confusion initially about where these parents were, where the father was, where the 4-year-old was, and then she began to express more that she had thrown the child in the water to give that child to God. But we didn't know where in the water. It's a big lake. It's a lot of places. We didn't know if it was there where the cart had taken place. If you could bring up the first slide. This is a big picture prepared for us by our friends over here at Muskingum Watershed. And the main portion of the lake, when you come in, before you enter the actual park, there's a big marina here and a restaurant. It's pretty well known. And we'll leave this up later if people want to come up and take close-up photos, whatever you want. But she actually drove this golf cart right between these two buildings, and it hit a stone wall there that makes a barrier of the water, and it flips into the water. That's how the call starts. And to be honest with you, it was reported as an accident. That's how the call came into 911. It's an accident. Later on, through some discussions, we learned that the individuals had a pontoon boat that belonged to a family company, and it was on an area that we call the Causeway, or is called the Causeway, and it's labeled there as dock. As statements come out, she suggests that she had thrown the 4-year-old in the water off the dock to give to God. Initially, divers were dispatched to that dock area. Nothing was found in the sides of the dock where the boat was. Divers also were working where the golf cart went in. And then at the very top of the picture, you're going to see a circle that says kayak launch. The only thing that took place at that kayak launch was just prior to the golf cart going into the water. The mother and the children were witnessed huddling very closely, heads touching, praying very intently next to the water by the kayak launch. So much so that it actually scared some witnesses. They thought they were crying, they were emotional, and they didn't know what was going on. That was before the crash or anything. So as the search goes on throughout the day and we're checking bodies of water, we learn about this praying incident at the kayak launch. So we had divers in there as well. That's a very shallow area. It was easy. It was an area that we didn't need to do very much at. But I bring it up because I know the social media community was talking about searching at the kayak. It solely took place because they were praying there, and it was described as a concerning moment, and we decided to check that water. The actual incident that we're going to discuss here only took place where the golf cart crashed, and then the rest of it at the dock. Captain Fisher, when he was dispatched, I asked him to go directly to the hospital. So you'll notice that there's some time delay before we get involved, and because she was uncooperative, a decision was made to have her taken to the hospital for evaluation. Her statements were radical. She had run from them and hid in some weeds and was easily captured. Her statements were bouncing around, so they felt the need to get her some medical help. Captain Fisher went straight to the hospital before coming to the scene, and he did his first interview with her at 12:20 that day. It's been one of the most difficult cases placing the statements together, and I want to word this carefully because I don't believe the mother's ever lied to us. But the statements not made sense a lot, and then in a second interview it made a little more sense, and then we were able to add pieces from the 3 children. We were able to kind of paint a picture. But she's been relatively truthful with us, and she has indicated every time she's been spoken to that she put the 4-year-old in the water to give to God. Now, in her statement, what she says is that she and her husband went to this dock and they jumped in the water because God was speaking to them and telling them to do things. Things to prove their worthiness to God, to show their faith as complete, and they didn't do very well in those. Some of them were bizarre, some of them were just swimming exercises. The most bizarre was that God told her to allow herself to be swallowed by a fish. As bizarre as that sounds. And I tell you that statement not to make fun, but I tell you that statement so you can have a picture of how difficult it was to communicate with her. It just wasn't making a lot of sense. They get up out of the water after a while, and they decide it's silly, and they decide to walk back to where they were staying in a family company-owned RV, which was over in this area. We intentionally not pointing out where their camper was, but it was over in that area. So they walked all the way back. When the husband got back to the house, according to the wife, he felt very disappointed in himself because he didn't do very good in his task because he didn't have enough faith, and he turned and immediately said, "I'm going back to the lake to swim to the sandbar." Now, the sandbar, I'm not a lake expert, guys, but the sandbar is way over here somewhere, and he's on this little dock. His brother had told us he could swim, but he wasn't a strong swimmer. And She said he left their RV again at about 5:30 in the morning after getting right back home. Keep in mind, he hasn't been asleep at night, and he's heading back there. For the longest time, we weren't sure if that was true. We didn't know if we could believe her statement. But the following day, we did run into a witness that put him alone at that dock, wearing the clothes that he left behind at the dock at 6:30 a.m. So it's kind of bizarre, but at 1:15, him and his wife go there. They do these tasks. They walk back. Then he walks back alone. We have a good independent witness that says, yes, I definitely saw him here. He was wearing these clothes, and he wasn't doing anything odd, but he was at the dock by himself. That's at about 6:30 a.m. Saturday morning. Keep in mind now, we're at about 4 hours before the crash. So we're about 4 hours before the crash. She does not see him again. Sometime just after 8 a.m., and this statement from both her children and other independent witnesses, she is seen loading up the 4-year-old on a golf cart near their RV and taking off very erratically. Everybody that will comment, or any witness that you encounter that saw her driving, will tell you she was driving very dangerously. She flipped the cart at one time. She was seen on 2 wheels another time. Of course, she was praying by the kayak. And she left. The children saw her leave with the 4-year-old. And then a while later, she came back. She states that she went to the dock and that she threw the 4-year-old in because that's what she needed to do as an offering to God. She drives back to her camper. She picks up the 15-year-old daughter, drives her back to the dock, and makes her get in the lake, and leaves. She drives back one more time, gets her 18-year-old sons, or twins. They come back, and she makes them jump in the lake to do some tasks, and they do. They all survive. They climb out of the lake, and at one point, according to the children, she makes them all lay down on the dock with their hands in the water to pray for their little brother and father because they were gone and had gone to heaven. We have divers now focused in a couple of areas, but our main concern is the dock. It's pitch black underwater. I'm sure you've all experienced swimming in a lake like that. So it's all by feel. It's all by sonar. But at 6:03 p.m., divers located the 4-year-old only about 10 feet off the dock, and at that time he was on the bottom of the lake. We continued searching till about 9:30 p.m. and we had to end the search due to darkness. At 9:44 p.m., Captain Fisher went back to the hospital for a second interview with the mother, and she was able to provide some slightly additional information, which I've already given to you, which was about the husband leaving on his own at 5:30. We resumed the search at 7 o'clock a.m. on Saturday, and the immediate focus is we're going to go much farther out because we understand now that he thinks he's going to swim to the sandbar. We had some concern as to whether or not he jumped in the lake to try to rescue the 4-year-old so he would be close, but now we believe he's on a mission to swim, so he's further out. So the boats start working further out with sonar, trying to locate anything. They did identify a signal or a blip under the water that they thought was suspicious, and at 8:29 a.m. they located the male 53 yards off the end of the dock on the bottom of the lake. And the divers are both telling me in both cases that the bodies were completely rested on the bottom of the lake. For us, obviously the recovery efforts end, but for us, the search warrant continues. About 1:49 p.m., Judge Elizabeth Tamakis here of our Common Pleas Court signs the search warrant, and the guys are going in there. And if you're wondering what we're looking for, we don't have any idea. We're looking for a weapon. We're looking for notes to explain it. That's the kind of stuff we're looking for. Honestly, nothing was found or taken. Photographs, there was a Bible open, and stuff like that. But we found nothing that directly mapped out, what was going to take place that day or anything like that.
Well, I guess that's it for that press conference. All right. Yeah, Tosh, I was just going to respond to you and Heidi. I'm really surprised that they have a camper, which is motorized, obviously. They have a golf cart, which is obviously motorized. They have cell phones, which goes against what I grew up understanding. But I just did a quick Google search. I guess some more progressive groups or specific business owners may use motorized vehicles under strict rules. So they said it was family owned. They said a motor or business owned was a business. I think he said the camper was under a business. So here's Amish 365. Do the Amish ever drive cars or trucks or vans? All right, hold on. One of the ways the old order Amish stay tethered to their simpler, slower pace is by refusing to use automobiles. Notice the word is refuse to own, not use. There is a distinct difference in the two terms. Amish fear that owning automobiles would tear apart the fabric of family and community life in much the same way as it has for non-Amish family. Suburbs now spread out thin, pancake batter, hot griddle far from cities. People are disconnected. Neighbors don't know each other. By refusing to own cars, besides saving a ton of gas and insurance, the Amish are making a statement about community and connection. Churches stay close-knit geographically because everyone needs to live close to one another when a buggy is your main mode of transport. Like many technologies, however, the Amish have made compromises to adapt to the changing world around them. So the reason they will ride in cars, the reality is that to attend a wedding or funeral far away, horse and buggy is impractical or impossible. Oh my gosh, it's had so many pop-ups. So the Amish will hire non-Amish drivers to take them places out of range for their horse-drawn buggies. This can get pretty expensive. Okay, buses or vans. Airplane travel is generally not permitted. Air travel. So I'm trying to figure out why they had a camper, but they said it was a business. I've seen many Amish passengers on Greyhounds over the years, and 15-passenger vans are also popular. All right, I guess the Amish business ownership of cars. Okay, here we go. Remember, because I'm pretty sure that they said, or she said, or somebody said that it was a business. The camper was part of a family business. So the Amish will also draw a distinction between owning a car for business and home life. Some Amish churches may look the other way if a vehicle is owned for the purpose of business. The Amish are very entrepreneurial and capitalist church, and they don't like to be put at a disadvantage. All right, this is from a Michigan NPR report. Like most, it doesn't drive a car. He does have a horse and buggy, but he only uses it when he goes to church. His helper in the shop grew up in a very strict Amish sect in Tennessee that would not allow Amish families to hire a driver. All right, so I guess that camper was family owned, and I guess that's how they decided that it was okay for them. So the Amish draw the distinction between owning a car and using a car. Owning would undermine Amish cultural cornerstones of community and church. Simply using a car or riding in a car driven by a non-Amish driver is considered compromise that allows the Amish to function more efficiently in the 21st century world. So that's what I was like, wait, you guys had a camper and then driving a golf cart? So All right, so here's a couple news clips, and then we'll get to some hearings. So again, this took place just south of Canton, Ohio, which is northeastern
Well, a
part
mother
of
is now facing charges after driving a golf cart in
northeastern section of Ohio, close to Pennsylvania, which also has a very large population of Amish community. Okay, so here's a news clip. Let's check this out.
after driving a golf cart into a Tuscarawas County lake with kids on board and allegedly drowning her husband and 4-year-old child. Ruth Miller is charged with 2 counts of murder, 2 counts of domestic violence, and a count of endangering children. Now, officials say she believed she was following, quote, directives from God when she allegedly drove that cart with her 3 older children on it into Atwood Lake. That's where divers found the bodies of her husband and son. Miller is still hospitalized this afternoon.
Hey, Winnie, how are you? Welcome in. Well, I said at the top of the stream, this hits close to home for me because I grew up just a little bit north of here. So I grew up next to an Amish farm, and I still have friends and family in the area. So yeah, it's one of those stories. When I saw this happen last year, I'm like, oh boy, where did this happen? And then I saw where it happened. I'm like, I've never been to this lake, but
I want to tell you tonight about
I've never been to the actual lake itself, but it is located in northeastern Ohio, just south of Canton. All right, and they're from Holmes County, which is just a little bit west of where this happened.
mother who's in jail right now after allegedly throwing her 4-year-old son into Atwood Lake where he drowned. Ruth Miller is charged with aggravated murder, domestic violence, and endangering children. All of those charges are connected to the death of her son and another incident with her 3 older children who were on a golf cart with her when she allegedly drove that cart into the lake. Those children did survive, but Miller's husband was also found dead in the lake. Detectives, however, believe that to be an accidental drowning. Miller, who's been in the care of mental health professionals, will be back in court on Friday.
All right, so that's those are some news clips. Now let's get to this is September 8th. This is September 8th of 2025. Remember, this happened August 23rd. It's August 23rd. So now we're going to go to September 8th and see where we go. See where this takes us. Anthony, how are you? Welcome in. Just a girl in Cali. How did she get her husband? If you did you hear the? She says that the couple went to the lake around 1 a.m. because they were trying to prove their worth, and then they went back to their camper, and then Marcus, the husband, said he wanted to go back to the lake, and he swam to a sandbar. Now, again, this is what Ruth is saying. We're not 100% sure that we can believe her because clearly she's got something going on. But according to her, Marcus said, "I want to go back to the lake," and he swam to a sandbar, and then that's how we know what happened to him. I mean, we don't honestly, we really don't know what exactly happened to him, other than he, was it 53 yards? I think they said they found him 53 yards out. So to me, it sounds like, yeah, he probably swam, got tired, or something happened. So, all right. So here's a hearing from September 8th.
Everyone may be seated. I appreciate that. We can all be seated. And we are now proceeding in the case titled The State of Ohio versus Ruth Miller. It is case number 2025 CR 090285. And we are here today for an arraignment. Ms. Miller, my name is Michael Ernest. I am what's called a common pleas court judge. Your case is one that was randomly assigned to my courtroom. And for an arraignment, there are three things that I do in every arraignment, and that is I address your right to counsel. I'm going to read to you something called an indictment, and I'm going to address the issue of bail as well. And starting in this matter, I would note, though, for the record, that in this case, notices of appearance have been filed on your behalf. Seated at counsel table is Attorney Ian Friedman, as well as Madeline Grant. The state of Ohio is represented as well at this table. To your left, my right, is Attorney Ryan Steyer. He is our county prosecutor in Tuscarawas County. Tuscarawas County is handling this case. Adam Fisher is down at the end of the table. He is the tester. He's here as a representative from the state. Ms. Miller, from this point forward, there's never going to be a time where you are going to be in the courtroom alone. There's not. Every time we ever have a hearing, anything that we do in this case, I am going to be coordinating with Attorney Friedman and Attorney Grant. I think they have others as well. The bottom line is you're always going to be represented going forward throughout these proceedings. You're here today because the Tuscarawas County grand jury met and concluded that they should return an indictment against you. Now, an indictment is a charging document that comes about after the grand jury meets with the prosecutor, hears evidence from the prosecution standpoint, and concludes that there is at least probable cause to charge someone with a felony crime. It's a right that all Ohioans have. And in this case, essentially think of them as like a check on the government. They got to make sure that there's at least probable cause before someone has to answer to a felony crime. Ms. Miller, in this case, the grand jury returned an indictment that consists of 7 counts. I'm going to read through those. Count 1 of the indictment is the offense of aggravated murder. It is what's called an unclassified felony in violation of revised code section 2903.01C and 2929.02A of the revised code. It provides here that on or about August the 23rd, 2025, here in Tuscarawas County, that the grand jury found that there was probable cause to believe that Ruth R. Miller did purposefully cause the death of a child victim designated as child victim 1, who was under the age of 13 years of age at the time of the commission of the offense. And they go on to specify that the birth date for the child is October the 12th of 2020. Count 2, murder. It's also an unclassified felony under 2903.02B, 2903.02D, and 2929.02D of the code sections from which they cite. The grand jury again concluded that there was probable cause to believe that you, the defendant in this matter, on or about August the 23rd of 2025, unlawfully did cause the death of child victim 1 as a proximate result of the offender committing or attempting to commit an offense of violence that is a felony of the first or second degree, known as felonious assault, under 2903.11A1 of the revised code. Count 3. It's an offense known as felonious assault. It's a felony of the second degree under 2903.11A1, 2903.11D1A. Again, the grand jury concluded that there was probable cause to believe that you, the defendant, on or about August the 23rd of 2025, unlawfully did knowingly cause serious physical harm to child victim 1. Count 4. It's an offense known as endangering children. It's a misdemeanor of the first degree under revised code section 2919.22A E2A, the revised code. The grand jury concluded that the defendant, on or about August the 23rd of 2025, unlawfully was a parent, guardian, custodian, person having custody or control, person in local parentis of a child under 18 years of age who did create a substantial risk to the health or safety of a child victim, in this case is designated child victim 2, by violating a duty of care, protection, or support. Count 5. Domestic violence, a misdemeanor of the first degree under 2919.25A D2 of the revised code. It says here that on or about August the 23rd of 2025, that you unlawfully did knowingly cause or attempt to cause physical harm to child victim 2, a family or household member. Count 6. Domestic violence, a misdemeanor of the first degree under 2919.25A D2. Again, the grand jury concluded that you, the defendant, on or about August the 23rd of 2025, unlawfully did knowingly cause or attempt to cause physical harm to victim 3, a family or household member. Count 7. Domestic violence, a misdemeanor of the first degree under 2919.25A D2. Again, the relevant date, August the 23rd of 2025. Grand jury concluded that there was probable cause to believe that you unlawfully did knowingly cause or attempt to cause physical harm to child victim 4, a family or household member. Those are all of the counts of the indictment, Ms. Miller. I have the original indictment in front of me. A copy of this indictment should have been provided to you at least 24 hours in advance of this hearing. Did you in fact receive a copy of this indictment 24 hours in advance of this hearing?
Yes.
Okay. Ms. Miller, from this point on, I'm going to be directing my attention to your attorneys. I believe Attorney Friedman?
Yes, Your Honor. Thank you.
My question to you then is, does there need to be any further reading of the indictment, the penalty sections that apply, the statutes under which your client has been charged, the various constitutional and statutory privileges that apply, as well as possible pleas?
There does not need to be a reading.
Thank you. And those will be indicated as waived. I'm also aware, Ms. Miller, that your attorneys earlier had filed on your behalf, as required by law, if someone intends to do this, a notice of the defendant's plea of not guilty by reason of insanity. I'm going to turn to Attorney Friedman just to confirm that's in fact the plea that should be entered in this case.
That is in fact the plea that we are entering by right at this time.
Okay, and that's what will be done. I will enter a plea then on your behalf of not guilty by reason of insanity. And the next issue that we would typically be addressing at this time is the issue of bail. I always hear from the state first. I would certainly allow your attorneys to be heard on that issue. I always start with the state, and after I hear from the state, I'll hear from your counsel. Brian.
Thank you, Your Honor. This morning we did file a motion to deny bail under revised code 2937-222, and we would ask that that be set for an evidentiary hearing. Further, in that filing, we moved for a no contact order with regard to the surviving victims here. That was imposed at the municipal court. We would ask that that be imposed until further considered at the evidentiary hearing.
Attorney Friedman, do you wish to be heard?
I do. Thank you, Your Honor. Your Honor, I am in receipt of the motion to deny bail and motion for no contact order. I would also concur that a evidentiary hearing need to be heard. I would ask by defense motion that hearing be continued so that we have adequate time to prepare for it.
Thank you. Thank you. Ms. Miller, by law, based upon the request that has been made by the state, I'm going to hold you in the Tuscarawas County Jail without bail. I typically would have to have a hearing within 3 days, but your attorneys made it clear to me beforehand that they intend to challenge that motion, but they need some time to prepare for it. I intend to give them that time to do that, so I'm not going to set it within those 3 days based upon your attorney's request. But at the conclusion of this hearing, coordinate with your attorneys, with the state of Ohio, to make sure that they have the adequate amount of time that they need to secure witnesses to be here at that hearing. So we're going to take care of that, but we're going to make sure that we set it as soon as possibly can. So I am going to have you remanded back to the jail where you will be held. I'm going to have the hearing, and then I'll make a decision as to whether or not I agree with the state, or I agree with your counsel, and set what I believe to make what I believe is the appropriate decision. The state of Ohio's request is, I believe, certainly a reasonable one to not have contact with those surviving alleged victims in this matter. As I'm not setting any bail at this point in time, I guess I'm going to turn to your attorneys. Do you foresee any objection to having her wanting to have contact with them until we are able to actually have bail set?
No, I think that that should be made part of the evidentiary hearing as well. So I think that issue should be held in abeyance until we have that hearing.
Brian, your thoughts on the matter? As I'm not setting any bail at this point, other than no bail.
I think it would be prudent at this point, and I would urge the court to implement immediately a no contact order with regard to the children. She does have phone privileges at the jail, and so there is some potential for contact, and I think that needs to be prohibited.
Let me just ask you, Brian, is there some other avenue other than usually as a term of a bail, I would say you can't have contact with the victim because I'm not setting any bail. Is there some other avenue from which this could be addressed?
Your Honor, I think anytime you are putting on an entry as it relates to bail, I think anytime you do that, you have the inherent authority to set restrictions. If the court were to impose immediately a no contact order, either directly or indirectly with her children, and if we were later to learn that there was an infraction in that regard, we could bring that to the attention of the court, and the jail could take corrective measures.
Okay. Let's do this. Ms. Miller, I think you probably can gather that this is not something the state wants you to do, is to have contact with any alleged victim. I'm going to take the matter under advisement. I want to double check a couple of things on that point. But as of right now, you're going to be remanded back to the jail where you will be held until we have the essentially what we call a no bail hearing. And from there, I'll be able to set forth specific orders as to what the bail is or isn't going to be in this case. Anything further from the state?
No, Your Honor. Thank you.
From the defense counsel?
No, Your Honor. Thank you.
All right. Thank you, everyone. And from there, I will issue in writing what is taking place here today. It's going to be shared with your attorneys, Ms. Miller, and can then share it with you. All right. Good.
I don't think that's an issue. Discussion.
Yeah. Let's talk. We can talk about. I think I know what you're asking, and we can address it after. If there's nothing further, then the arraignment is concluded, and I have to bring it back to the jail.
So I've had discussions with psychiatrists and therapists and lay people and general people, like the difference between a religious belief and the difference between insanity or a mental, incapacity. It's interesting, what does make that difference? When somebody believes so strongly in something that causes them to cross that line of hurting somebody else to the point of, taking somebody else's life, and you're doing it, for your belief, for your faith,
We entered a plea.
Whatever the case may be, it's interesting. Do we hold those people accountable? Do we put them in institutions where they maybe can be rehabilitated after a while? And court watcher Denisha, I thought, you brought a good point up because we were kind of talking about Lori. I'm like, there's similarities between Lori and Ruth, but I do agree with you. Yeah, Lori was definitely about greed. She was all about power. I'm not seeing that. I mean, we don't know that much about Ruth, but I'm not seeing that she did this for greed or for power from what she's saying. She just did it because she was trying to prove their worth to her, based on her beliefs. So Lori, I think, from what we were able to, figure out from her, was that she was doing it for the power of it, the greed, and Ruth doesn't seem to be doing that. So, all right. So this is her attorney speaking after they entered the plea.
Not guilty by reason of insanity today, because based upon the facts of this case, it's very evident that it is fitting. This case would not have happened but for a mental defect that would have prevented Ms. Miller from appreciating the wrongfulness of her conduct.
What happened on that day in your estimation?
Well, there clearly was a serious mental disease that she faced. It was evident to the responding officers, the first responders, and unfortunately it was a tragedy that happened that day. Again, clearly would not have happened but for.
If she is found not guilty by reason of insanity, what happens?
Well, that would be up to the judge, but there would be, it's not as people generally think, that if someone's found not guilty by reason of insanity, they're just released to the street. They're released to the custody of a lockdown hospital. They are held until a court is convinced that they've been rehabilitated, they are safety to themselves and to the community. So it still is a long term of supervision and work.
Did she not admit to doing that?
Well, I don't think that this is an issue of a whodunit. I think everyone recognizes the fact that that she did do it, but that's just one part of it. That's the act. The big question in this case is the why it was done, and that's what this whole case is going to be about, is the why. How did this happen?
I know you cannot say everything she said, but has she shared with you her feelings about what happened on the 23rd?
Well, she's obviously devastated by what occurred. This is not something by any stretch of the imagination where we could think that someone would wake up and destroy not just their life but the life of their child. I mean, something is wrong, and that's what we're getting to the bottom of now. But obviously she's devastated with what's happened. She is, her family is, everyone is.
Has the family and the Amish community, are they supporting her through this? I know they tried to help her and her husband.
Yeah, so what we have received is support from family and from community members who have known her entire life. What happened on August 23rd, that person is not the person that they know. That's the person that they all believe was the victim of a mental health episode. And so they're supportive of her and want to know also how could this have happened, and look at her as a victim of mental health. We all know that mental health is a tremendous issue in the community, and we saw it here clear as day, and we saw it in its worst form as to what could happen to someone facing a mental health issue, and certainly unchecked.
Can you speak to what may have precipitated her mental episode as you might describe it?
What do you mean, what may have precipitated it?
Why on that day did she go out, admittedly, and toss her child into the lake?
Yeah, so I think what we have, and I think you've seen them, I know your station has seen them also and posted them, the body cams from the first responders. We see in real time, we saw raw footage of what was going on in her mind and what she was reacting to and so forth. I think this case, what you're going to see in this case is one centered around mental health, and you're going to see the input of many different experts in many different fields who are going to be talking about that exact question that you just posed. So I think what we're going to need on this is time to really figure it out, and just making a quick statement would be nothing beyond speculation.
Did the judge just set the bond hearing? Can you tell us when that is?
Yeah, so we did just set the bond hearing. That's going to be September 25th at 1 o'clock. And what you should expect at that hearing is going to be not just your kind of typical argument of, why someone should be out, but evidence that addresses the factors that the court's going to consider. So I would expect at that hearing, as evidenced by the motion that will be filed here momentarily, that evidence will be put on certainly by the defense. We'll be calling family members of Ruth Miller's. We'll be calling members of the Tuscarawas County Sheriff's Department, and also mental health professionals from the Cleveland Clinic.
Thank you.
Can you give us your name again, please?
Yeah, Ian Friedman and Madeline Grant, both counsel for Ruth Miller.
Ian, will you be seeking some kind of bond?
We will, yes. We will be seeking a bond, yes.
You don't have a specified amount yet?
No, not yet.
Okay. You will be trying to arrange for a release at the conclusion of the hearing?
We will.
And what can you tell us, and I understand there's confidentiality in play, but do we have any information of what medical treatment she may be getting for her condition at this point?
Yeah, so that at this point has to remain confidential.
Okay.
But I think through the course of these hearings, again, because they're based on mental health issues, you'll be having some of your questions answered in the courtroom.
And are you able to tell us any kind of motions you may be making on obtaining medical treatment for her?
So with the not guilty by reason of insanity, one should expect that different professionals will be now visiting with Ruth, both for the state and the defense, and rendering opinions in the case. From there, we'll be filing responsive pleadings.
And then what about the issue whether she's competent to stand trial and assist her in her defense? I think that's separate from an NGRI, right?
Yeah, you're exactly right. So that is separate, and the issue of competency may still be raised in the coming days.
Okay, so that's a separate issue, and you may raise that, but you just haven't yet so far.
Correct.
Okay.
Did her family try to help her seek any mental counseling or guidance before the incident?
So I don't want to make a comment on that. Again, I think that's one of the issues that will be coming out in the courtroom. All right.
Did you have a chance to consult your client before today?
Oh, we've been preparing for this with the assistance of our client, Ruth Miller. That simply is letting her know what's going on and so forth. But this is a big process. It's overwhelming for her. And so we're just trying to make sure that that she understands it and that her needs are being taken care of. Because she's sitting in a jail cell. She's lost a child as a result of this. So a lot of this is making sure that she's taken care of.
Has the law enforcement, the prosecutor's office, have they treated your client fairly?
They have. So I have to give kudos to the Tuscarawas County Prosecutor's Office and the Sheriff's Department for their professionalism. We've been working well with them, and I think everyone's going to remain focused on what's important in this case, and that is the mental state of Ruth Miller at the time that she lost her child.
Since her release from the hospital, has she had, a come-to moment where she hit her the realization that what she did and that she lost a child?
I think the magnitude of this is so great that that's going to take some time. I think this is all a process, and the realization today is going to look very different from what it may a day or even a week from now. I mean, this is a nightmare that no parent ever wants to face, and made worse by the fact that she was there. She was present for this. She was part of this. Whether or not she was mentally stable at the time and so forth, regardless of that, she recognizes the fact that she was there, and this is crushing to her.
How long was she in the hospital again?
A few days.
A few days after her arrest?
Correct.
Okay.
Correct. So.
Are you able to tell us anything about that stay?
No. Okay. Not at this time.
Yeah. Can you say which hospital?
Yeah, you'll see subpoenas. Excuse me, these bugs are coming out. Subpoenas will be issued here shortly, by tomorrow, actually, and you'll see who's being subpoenaed, and then I think 2 and 2 will be put together. I don't have any problem saying it was the Cleveland Clinic system, but specifics and treatment providers and so forth, those will be listed out by way of subpoena. All right. Thanks, everybody.
Did you have any other updates on the other kids that were involved with the golf cart, how they're doing at all?
Yeah, I don't want to make any comments on the kids. Everyone's struggling right now with what's going on. Thank you for asking, though.
And you're very well known in the area, but are you able to talk about how you were retained in this case?
No. All I'll say is that we, Attorney Grant and I are on board, and we will see this through to the very end.
Thank you.
All right. Thanks, everybody. Thank you.
Yeah, just when she come. Yeah, the one question was: has there been a aha moment, a come to God moment? Is she able to realize what actually happened? I mean, she took the life of her 4-year-old, and then also her husband. I mean, she didn't take the life of her husband. Doesn't seem like. Again, we don't know 100%. For sure, but she lost her husband on top of it, All right, let me put myself over here. So hopefully she'll get some help, and be a better person for it. I mean, I don't know. I mean, she's got to spend some time in either jail or facility. So, all right. So this is her bond hearing that they were talking about.
Thank you. We are now recording in the case entitled The State of Ohio versus Ruth A. Miller. The case number is 2025 CR 090285. The basis for which we are here today, just taking a step back, we previously had an arraignment in this matter, and at the time of the arraignment, it was back on September 8th of 2025. At that time, at the time in which we were going to discuss bail, the state of Ohio had made a request that Ms. Miller be held without bail, as is provided for in Ohio under revised code section 2937.222, which time the court planned to have Ms. Miller held and schedule a hearing within 3 days. After there was some consultation with counsel, actually September 29th is the date that was arrived at. Bring us here today. Ruth Miller is in the courtroom. She is seated at counsel table. She is there with her attorneys in this matter, Ian Friedman and Madeline Grant. The state of Ohio is represented by our county prosecutor, Ryan Steyer. At this hearing today, Ms. Miller, what's going to happen is, after that request is made by the state, the burden is going to be on the state to try and convince me by what is considered what is called clear and convincing evidence of the following. There essentially are 3 areas that they will be touching upon. One of them is the question is whether the proof is evident or the presumption great that the accused committed the offense with which the accused is charged. 2, whether the accused poses a substantial risk of serious physical harm to any person or to the community. and whether no release conditions will reasonably assure the safety of that person and the community. At this hearing, and your attorneys are aware of this, they know that they have the opportunity to present evidence as well. They'll just go second, that's all. So shortly I'll have the state begin. My statement, I guess my comments are to the room in general. It's obviously a case that has gathered some attention. It's a case in which, based upon my prior experience, tensions can run high when there are allegations involving a death, particularly when it's a death of a child. For everyone, if there are any outbursts, if there's any disruptions, you'll be asked to leave. This is my warning to you. My advice to you is to let the attorneys do their jobs. If there are any outbursts, the security knows they'll be asked to leave. There will be no recording, video or audio of these proceedings unless you're with the media. They followed the format of getting permission from me beforehand to do this. If you are not with the media, you cannot record these proceedings. With that, Brian, I'll begin with, do you have any form of an opening statement that you wish to make? Again, you don't have to, I'm just simply offering.
Only, Your Honor, that I think after we present our evidence today, you'll see that this is not a whodunit or what did she do. That the proof will certainly be evident, the presumption great, that Ruth Miller admitted to and committed the crime of aggravated murder with regard to her 4-year-old son. That she was a risk that day to herself and others, including her surviving children. And so, again, this will not be a whodunit or what did she do. This will be a case about whether there are any release conditions that can reasonably assure this court of the safety of the community, and particularly not only her children, but herself. And I would suggest that at the culmination of the evidence, there will be no evidence that can provide any reasonable assurance. This isn't a case where an ankle monitor is going to give that court assurance, or that there's any other secured facility other than where she's being held now at this point that can give the court that kind of assurance. And so that's why, Your Honor, we've moved the court as such. We are asking that Ms. Miller be held without bail, and that we would renew our request that no contact orders be imposed with regard to her surviving children. Thank you.
Thank you, Your Honor. Your Honor, thank you for hearing our statement, and I appreciate the state's position. I respectfully disagree when we look to the wording of the statute. And I'd like to really break this down as to how we are viewing the statute, Revised Code Section 2937.222. Your Honor just stated the factors that you must consider when making a determination today. And I point to subsection 1, the proof is evident or the presumption great that the accused committed the offense with which the accused is charged. And I think it's easy to just gloss over that, and as our colleague stated a moment ago, just accept that this is not a whodunit case. But to a degree, that I think is just the start of the query. The second part of the query has to be really focused in on the word committed in this case, because I would submit, Your Honor, that if you just look at the common law definition of committed, that by Merriam-Webster, I went right to the basics as to what commit is. It's to carry into action deliberately. There has to be that sort of mental state that goes with the commission of any sort of act. And as we all know, going all the way back to our years of initial formal training as lawyers, we were taught to look at the mens rea and the actus reus. And in this case, I would agree with the prosecutor that the actus reus, the act, in fact, was carried out. We're not here today to dispute who that was, so that's something that I think can be taken by note. The mens rea, however, and that the intention or knowledge of wrongdoing that constitutes part of the crime, I think is still in question. And without the mens rea, technically, if we look at the statute, subsection 1, one has to question whether or not the definition of committed can be met. The court accepted the plea of not guilty by reason of insanity pursuant to revised code section 2901.01A14 at the last appearance, calling into question whether or not Ms. Miller could appreciate the wrongfulness of her conduct, and puts into question what her mental state was, whether or not she could form the appropriate mens rea in order to complete the commission of the offense. And so today is going to be spent, Your Honor, talking about what that mental state was at the time. It is our assertion, Your Honor, that while the act is there, the mental state is not, and therefore the commission cannot be fully determined for purposes of subsection 1. As to the risk of serious physical harm to any person or the community, it needing to be a substantial risk of harm, and not just simply based upon what the conduct was, but whether or not there is any, pursuant to 3, any release conditions that could reasonably assure the safety of that person and community. And I believe that the testimony today will have to be that after the incident on August 23rd, when Ms. Miller was taken into custody and then was confined to a mental health facility, which was a lockdown facility. It was monitored by professionals there with security staff, that there were no concerns for her safety or anyone else's safety. And so I would submit that at the end of the testimony here today, that there would be a combination of release conditions that could ensure Ms. Miller's safety, the safety of others, until this matter has been completed before Your Honor with final trial in this matter. So with that, I thank the court for the ability to provide opening statement. We are prepared to proceed. We have 4 witnesses, although I know 2 of them will be called by the state. I would just ask that the 2 witnesses not being called by the state, both Sheriff Orvis Campbell and Ranger Lucas Pace, be allowed to be examined subject as if on cross-examination for purposes of the dynamic between the witness and counsel, and also for purposes of expedition.
Okay. Any concern with those questions?
Your Honor, I guess the way that this hearing was conducted is really at your discretion. The rules of evidence don't have direct application today. I think it's only fair that if you're going to call a witness, you call them as on direct, unless there's some element of surprise, which I don't think there is in this case.
All right. Ryan, because the rules of evidence don't apply here, I am going to allow them to be treated as if on cross-examination, if nothing else, just to expedite the proceeding. Before we move in, I did have one last question, and that is, I take your silence from both sides that there are no objections, but on the letter I had written any objection to proceeding today on that outstanding
Not from the state.
Ian, I've written a letter regarding the question of competency is outstanding in this matter, and concern with proceeding with this bail hearing today in light of the fact that the evaluation has not been completed yet.
No, I think because this is based solely on the facts of the case that don't really implicate competency issues, so we're fine with it.
Just want to be sure. All right, then with that, the state of Ohio, we call its first witness.
Okay, I'll call Ranger Rick Anderson.
Yeah, make your way up through here. It's a bit of a maze in here today. We're good. There you go. Should I address you as an officer or Ranger Anderson? Ranger. Okay. Then Ranger Anderson, you have a seat. Please raise your hand. Ranger Anderson, do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth? If so, please indicate by stating either I swear or I affirm.
Okay, and can you start by telling us your name?
My name is Richard Anderson.
Okay, and what is your occupation?
I'm a ranger with the Muskingum Watershed Conservancy District.
Okay. And for how long have you been employed in that capacity?
23 years.
Okay. And for how long have you been a certified peace officer in Ohio?
23 years.
Okay. Were you working on August 23rd of this year?
I was.
Okay. And did you have occasion to respond to a call regarding a golf cart that had run into the lake?
I did.
Okay. Do you recall where you were when you received that call?
I was in a nearby cottage area.
Okay. Do you recall about what time that was?
I want to say about 10:30. 10:35 a.m.
So if I were to tell you that the 911 call came in at 10:37 a.m., is that about what time that would have been?
Yes, sir.
Okay. And what information did you have at that point in time before you were dispatched, or as you were dispatched?
I believe I was advised that by Central Dispatch out of Tuscarawas County that a report of a golf cart accident with a possible injury at the Atwood West Miller.
Okay. Did you directly respond to that area?
I did.
Okay. And what did you find when you got there?
I entered the parking area of the marina. At that point, I was unable to locate the accident. In a short time, I was directed towards the lake from the parking area. As I approached the lake, I observed another officer talking to Mrs. Miller and her 3 children who were sitting on a bench near the lake.
Okay. And who was that other officer?
Officer Lucas Pace.
Okay. You said you were approached by him?
No, I approached them.
You approached them?
I approached them.
Okay. And what did you observe when you got that?
He was talking to them. Mrs. Miller and her 3 children were sitting on a bench near the lake, and they were wet. Their clothes were wet.
Okay. And did you hear them saying anything?
There was a conversation about occupants on the golf cart. Initially, she began to talk about having a husband and a son and a child in the water. And we had to clarify at that point, were they on the golf cart? And eventually she clarified that they were not on the golf cart, but they were in the lake. So at that point I contacted the Tuscarawas County Sheriff's Department via telephone, and I advised them what I had and that I needed assistance. Because at that point we believed that they were in the lake someplace. We just didn't know where.
And the lady who was sitting on that bench with her, did you say 3 children?
Yes.
In the courtroom today?
She is.
Okay. Is she lady sitting here beside Mr. Friedman to the left?
She is.
Okay. What happened next?
As I said, I was talking to the Tuscarawas County Sheriff's Department on the telephone, and I walked a little bit away from where Officer Pace was speaking with Mrs. Miller, and there was other people in there. I needed a little space so I could hear, and I could talk to them. When the conversation ended with the Sheriff's Department, at that point, Mrs. Miller and her children had gotten up to the bench and that they were sitting on, and they began to walk from near the shoreline where they were on the bench towards the buildings at the West Marina up over a grass area. I was told by Officer Pace that they were going to take us to where the husband and child were. They weren't for a short period of time. He told me that he would go get his cruiser because he was going to pick him up in a car and take him to that area, wherever that area was, but we didn't know at that point. So I followed him. Eventually we got beyond the buildings up in the parking lot. On the other side of the parking lot, there's a trail system that goes through the park.
So you followed them, you're on foot?
I'm on foot. I'm on foot, and I'm following them, and they're walking along together. And at that point, somewhere in there,
Now, are they just casually walking together?
They're holding hands, and they're walking, and they're talking, perhaps praying, maybe singing. They're a little bit from me, and I can't really tell exactly what they're doing, but they're together.
And your information from Ranger Pace was that they were going to show where you might be looking for the spot.
Yes. So once
where was Ranger Pace?
He was retrieving his vehicle. The idea was that he would get his cruiser, and we'd put him in the cruiser, and that they would go to that location. So I'm following on foot. Like I said, they're a little bit ahead of me. They get to a certain point there on the parking lot, and they disperse, and they take off running, including Mrs. Miller, onto a trail. This was a very short period of time, and Mrs. Miller went down to her hands and knees. And at that point, I believed I would be able to get to her and get a hold of her so that we didn't do this. She sprang up to her hand, up from her hands and knees.
No, I'm sorry, is this already after she took off running?
Yes. She took off running, and then it didn't last long. And she went down to her hands and knees, and she sprang back up to her feet and took off running hard. At that point, she came to a couple on bikes. It was an Amish couple on bikes. She said something to the woman. The woman gave her the bike. She took off on the bike. At that point, I contacted Officer Pace, and I advised him what had happened, and they could pick me up. He picked me up.
When she took off on the bike, did she take off in a direction opposite you?
The direction which we were both going when this happened, she continued in that direction. Once Officer Pace picked me up, I got into the vehicle. We drove into the park because we went outside the park. We drove into the park. We didn't see her. We located the children in a camp area called B, which is inside. We got the children in the car. They told us that they would take us, lead us to where the boat was docked. So we went there. When we arrived there, we found the bike that Mrs. Miller had been riding, and we looked the boat over, we looked the dock area over. We couldn't find Mrs. Miller, so we got back into the vehicle and we drove back through the park. We got to an area where the trail system picked back up. I told Officer Pace I would get out and walk that area. I found Mrs. Miller face down in very high grass. The grass is approximately chest high along a trail. At that point, I advised her to get up. She was reluctant to get up. I looked towards the trail and I saw the tops of two male heads that were on the trail, and I asked them to come over to help me. Well, they came over. When she saw them, she got up. From that point, we walked back to the activity center, which is the park office.
I want to come back to a lot of that, but I want to play now for you. You indicated that you had called the sheriff's office. Do you remember a Deputy Caden Edwards being the initial responder from the sheriff's office?
Yes.
Okay. And we can have Detective Fisher authenticate this a little better later, but this involves the body-worn camera of him where you were involved. So I want to get to that point here on his body cam. about 8 minutes and 47 seconds into this body cam file, but the clock on the camera is at 11:18 a.m. You know what? I pulled up the wrong file. I apologize. We're 8 minutes, 49 seconds into his body-worn camera footage here, and I'm just going to hit play. Seems like we're muted, Your Honor, and I'm sorry?
It looks like on the bottom right.
Into the lake down at the marina. Okay. Sidewalk down by where the.
Is this another one of them right here?
Now that is Deputy Edwards' body cam footage. Is that you walking on the dock?
It is.
Okay. So at what point is that in terms of what you already explained to us?
That would be as you saw there earlier, if you pull that back, you'll see a bike sitting there. Okay, that's the bike that she retrieved from a couple on the trail. When we arrived there, being that we saw the bike, we had hoped to find her there. We did not.
Okay. Now, do you know, is this the dock that is later known to be the dock where the Millers kept their pontoon?
It is.
Okay. Okay. And so you responded there with Ranger Biggs?
I did.
In his vehicle?
I did.
Okay. And that's when Deputy Edwards approached you?
Yes.
All right, so can you catch me up on what's going on? We're at my dispatch. We're so confused.
Mom evidently drove the golf cart into the lake down at the marina.
Okay.
Sidewalk down by where the ground dock is. Said God there, as I've been here to do things.
Yeah, so when I first got here, a bystander was saying that he saw him praying with the kid, saying that it was time for her husband to go and stuff like that. It seems like she's got some.
She said her husband, her youngest son, drowned this morning. So we need to locate her husband and son.
Yeah.
Now, the bike that she was on is this bike. And I don't know if it's here or not. But the golf course, the marina, the husband, we don't know where he's at in the 4-year or whatever. Was alleged to have drowned this morning.
And the dad.
Oh, your word. Yeah.
Okay. Okay.
So who is that's with you at this point?
One of the children.
10 minutes in.
That's one of the children.
Okay. One of the two 18-year-old boys?
Yes, sir.
Okay. Do you know where the other two were at the time?
In the patrol vehicle.
Okay. And tell us how you found them.
They were going through the campground. They were running through the campground in the area D camp area of Atwood Lake.
Okay. Was that shortly before you arrived at the dock here?
It was.
Okay. And you arrived at the dock, you find the bike that she had commandeered, as you explained, and the second 18-year-old boy.
Yes.
touching care of you right now. You understand that? How old are you? Are you 18? Well, I really not take custody. I'm just going to take care of you right now. But I'm taking custody of your sister right now, okay? You understand that? No, Are you sure? That's not you. That's not in here. Would your dad and little brother be out at Area 3? Where's your dad and little brother? In the water? Why do you think they're in the water? Because that's where they are. Yeah. Well, we didn't find your mom. Where do you think she might be?
Probably over by the trail somewhere. I'm not sure.
Over by Area 3? You know where Area 3 is?
I do not. I'm not for you guys.
On the outside areas? Yeah, we'll go back out there and check.
Okay. 7940 Central.
Okay. Now, I know that's from Officer Edwards' body cam footage. Does that seem accurate as you remember it that day?
It does.
Okay. Can you estimate for how long it had been between when Ruth took off running and you lost her until this moment?
Only an estimate. I would say 30 minutes.
Now, I'm going to pull up a second clip from Officer Edwards' body cam footage. Start this one about a minute in. Now that last clip began at about 11:18 a.m. on the clock of the body cam. The 911 call came in about 10:37 a.m. And at this point on the body cam, the clock is at 11:38 a.m. Do you remember, and is that you depicted there with Ruth Miller and then two other gentlemen?
It is.
Okay. And so do you recognize that scene then?
I do.
Okay. Now, how much time had passed before you found Ruth lying face down in high grass until this event right here?
Once I located her, she got up when the two men beside her came into the grass. She saw them and she got up.
Did she initially respond to your request to get up?
She did not.
Okay.
She did not. When I first located her, she was laying on her stomach with her arms underneath her in the high grass. I told her, I said, get up, Ruth, we need to go. And she did not want to. And when I saw the tops of two male heads on the trail, I asked for help from them. And they came over and she saw them. She stood up and we walked directly to where you see us.
And can that high grass be visualized in this still shot here at 1 minute, 13 seconds into this clip?
It can.
Where is that?
It's just above your cursor there, right in there.
All right. Off to the center right of the graph.
Yeah, there's a trail system that goes through from the outside areas through there into the park.
Okay. Now, so with the assistance of these two individuals, do you know if these two individuals knew Ruth?
I have no idea.
Okay. And with their assistance, she did get up?
She responded, yes, she got up.
Okay. Was she saying anything to you or otherwise?
She talked about, she advised me that she didn't believe that I was one with God. during the walk from the trail back over to where we're at right now. She had issues. She talked about fidelity issues. I'll break that down. She advised me that reports of fidelity, and basically she said that I wasn't one with God.
Okay. Did she make any remarks between when you found her and this moment in terms of her lost husband or son?
She did not.
Okay. You were present initially when you responded, and she was making some remarks along those lines about her. Did you hear those about her?
We asked her, as you can see in the video, about the location of her son and her husband, and what she said in the video.
Okay. We'll just go ahead and play from her then.
I gave him to God.
You gave him to God?
Yes. I threw him in the lake and I gave him to God. And people are going to tell me I'm crazy, but he is real. And he loves you. He really does love you. He loves you. And I doubted him. I doubted him so many times. But I am to tell you, he is coming soon. He is coming very soon. Prepare your hearts. The end is close. And I'm for sure supposed to tell you that he does love you. Okay?
Ma'am, can you explain to me what happened? Who did you throw in the water?
I gave my son to God.
Your son?
Yes.
Where's your husband?
He went for a walk this morning.
And you haven't seen him
He
since?
didn't ever come back. And we went to the boat and his clothes were there. And God told me he's in the lake and a fish swallowed him. And you're actually supposed to go look for him in the bottom of the lake. And you will find the fish. And you will find my husband. And then you will believe. But ye of your little faith that did not believe before seeing. So send people down to the bottom of the lake looking for a fish.
How old's your son that's in the lake?
He's sweet. I gave him.
Okay. 7940 Central. We're out with the mother. She is advising that she threw her 4-year-old son in the lake to give him to God. A firm.
They are there.
And this is Ranger Pace coming into the picture?
It is.
I need to know where your husband is.
He's at the bottom of the lake in a fish.
He's in a fish. There's no fish large enough on an Atwood to swallow your husband.
He's at the bottom of the lake in a fish.
I thought your husband went for a walk.
Yeah, and then we came to the boat, and his clothes were laying in the boat.
Okay.
Tan pants and cream shirt and flip-flops.
Do you have a cell phone?
It's in the camper.
It's in the camper. Where did your camper at?
I think it's,
Area 3?
I think so. Yeah. It's like a tanish camper.
It's a tannish camper. You don't know what lot number it is? Well, we really need to verify your husband's still with us.
Oh, okay.
Okay.
Well, he's actually just go out in the bottom of the lake.
Well, I can't go to the bottom of the lake. So if
Do you
we
have
need,
scuba divers?
yeah, we're going to have to call divers in to go to the bottom of the lake.
Please do.
And you're saying
Get the best ones there are. Because this is a miracle from God. You will see. You will Yes.
You're saying your 4-year-old son's down there too?
He's with God.
Where's his body at? Where did you throw him in the water at?
Off of the dock back there. All the way.
Where the bike was today? Where the boat was?
Yeah. I know.
When they're supposed to be once. I think it was once.
Does anybody have a glass of water?
We can get you water.
Please.
So, we're right now we're gonna walk up to the squad, okay? That's what we're going to do. We're gonna put you in the back of the squad.
You will find my husband.
Okay, but you want to sit down in the back of the squad for us, okay?
Can I actually just sit with my children? Yeah, and have water.
Yeah, we can bring the children over.
Let's go in this one over here. We'll bring them.
Now, were you there? She was eventually taken to the squad or the ambulance that was on the scene?
Yes.
And that ambulance was initially called out right after the golf cart went in the water, right?
Yes.
Tell us a little bit about how you and others were able to get her into the ambulance to the hospital.
Well, if you play this forward, she'll go over there and she'll sit down on the ground near a tree, and she was there for a short period of time for children, and it was decided that she needed to get into the squad, and during the time when I came upon her on the trail in the weeds, she wasn't really interested in getting up and going, so we had to pick her up and put her on the gurney if she wouldn't get on herself.
And as I understand it, the investigation was shortly after this handed over to the sheriff's office. Is that right?
Yes.
Okay. And other than your initial response, and then I guess Ruth and kids running from you and you finding them and getting her into the squad, did you have any other involvement in this matter?
No.
Now, you weren't wearing a body cam at the time, were you?
No, I wasn't.
Okay. Did you have body cam at the time?
I did not. I had one. It was taken out of service, and I hadn't received the new one.
Okay. I have no further questions.
Thank you.
Ranger Anderson, good afternoon. My name is Ian Friedman, and I represent Mrs. Miller. I've got just a few questions. I don't anticipate it'll take that long. You've described the scope of your investigation. It was limited once Ms. Miller was in the back of the squad car.
She's put into an ambulance.
Into an ambulance, I think, with honors. Okay. And so after this matter was turned over to the Tuscarawas County Sheriffs and other law enforcement, you didn't have any other investigatory roles in this? Thank you. I want to focus with you during this question on Mrs. Miller's mental state during your interactions with her, okay? And my question is, what sort of training and experience do you have with individuals suffering from mental health diseases, mental health ailments?
Only what would be consistent with a police officer in the state of Ohio. I have no special training.
Okay. Have you been involved in a situation before where it rose to the level of what you observed in this case, specifically the mental state that Mrs. Miller was clearly suffering at the time of your interactions with her?
I've never had another incident like this. As far as her mental capacity, I don't have the training to be able to tell you what the capacity of what position other people were in over the years that we interacted with. So I really can't answer that.
Thank you. One of the things that you learned during the course of your interaction that day, your presence that day, was that Mrs. Miller operated a golf cart, correct?
Yes.
All right. And that golf cart was utilized to, Mrs. Miller was driving it, went to pick up her daughter, went to pick up the sons. Do you recall that?
Well, that's roughly as I understood it, yes, as I understood it.
Okay. And did you come to understand that Mrs. Miller had actually crashed that golf cart?
As I understand it, yes.
Okay, and what did you understand about her operation, the crashing of that golf cart?
I was advised that she was the driver of the golf cart. The golf cart had gone into the lake near the docks at the Western Lake.
Okay. And did it crash into a wall?
No, sir. It went over the rocks and into the water.
Into the water. Now, how long after you first encountered Mrs. Miller did she tell you what she believed happened, specifically that her son was in the lake?
Well, initially, we got the call that it was a golf cart accident, and when I arrived there and I made it to the lake, she was there with her children, and at first, my thought was that perhaps they were on the golf cart with her and her children. But within a few minutes, she stated no, that they weren't on the golf cart. That everybody who was on the golf cart that went into the water with her at that point was accounted for. So at that point, we knew that they were not on the golf cart, but she said they were in the lake.
And so right away, Mrs. Miller was letting you know that they, being her son and husband, were in the lake.
Yes.
Okay. And she did not deviate from that during your encounters with her that afternoon of the 23rd, correct?
Yeah.
And she was adamant with you, and I think Ranger Lucas, is it Lucas?
Luke Pace.
I'm sorry?
Luke Pace.
Luke Pace, I'm sorry. With Ranger Pace, she was adamant that a large fish had eaten her husband, correct?
Yes.
And did she ever deviate from that?
No.
Now, which ranger was it that called out for assistance by the Tuscarora Sheriff's Department?
That would be me.
That would be you. All right. And what was your basis for calling out to them?
The belief that there were people in the lake.
Now, did you notify anyone that there were issues of any mental health that may be present?
No, I advised regular dispatch what she was telling us to try to give them a better understanding of the situation. I did not say that I thought there was some type of issue like that. I just advised them what I was hearing, what I was seeing, and what, why I needed help.
Because your goal primarily, obviously at the time, was safety of the child and of the husband. Your mission was to find them.
Yes.
But as you sit here today and you think back upon the situation, as I'm sure you've done many times, in anticipation of your testimony, did you believe that at the time Mrs. Miller was suffering from some sort of mental health issue that afternoon?
I didn't know.
Okay. All right, now you talked about on direct that Mrs. Miller and the children began to walk away. And they were holding hands?
Because I believe yes, they were following us.
And they also were praying intently at some point, correct?
praying, singing, talking, something. They were a distance from me. I couldn't tell exactly. There was some interaction, something was going on.
And did the children run or just Mrs. Miller?
Everybody there.
Everyone there. And the question that I have for you as it relates to Mrs. Miller, why did she run away from you at that time?
Don't know.
All right, so there was no questioning of her as to why she ran once she was brought into custody? If I were to suggest to you that Mrs. Miller ran away to, in her mind, meet up with Marcus and Vincent in heaven, you would have no way to know if that was true or not. Did she run? Well, you had said you didn't know. So if I were to suggest to you she ran to pray or to go to heaven herself, you had no way to know one way or the other. Did you identify the two gentlemen that assisted you in taking Mrs. Miller from the shrubbery?
No.
Do you know if any of your colleagues did? So that as of today, do we know who those two individuals are?
Not that.
In your opinion, and again, we don't know exactly what was going on in her head, and I understand that would be an excessive expectation. Was Mrs. Miller acting rationally in your interactions with her?
To say that she was rational, I didn't know Mrs. Miller. I never met Mrs. Miller to the best of my knowledge before this. I meet a lot of people every year working for the Searcy District. I'm not familiar with how Mrs. Miller normally behaves and the things Mrs. Miller normally says. So I really can't answer that.
That's fair. But some of the things, I'm not going to get into all of them here at today's hearing, but some of the things that were being discussed about the fish and being reunited with the husband and son, with God and so forth, did that seem out of the ordinary or unusual or something that you could process logically?
Her level of religious devotion, what that means to her, what it means to me, I don't. She was talking about these things, and I just don't.
That's fair. And then, not knowing, would that also hold true if I were to say to you, do you know, or did you formulate an opinion as to whether or not she was sane at the time of the incident? Would the answer be the same, you don't know?
Yeah, I don't.
And last question that I have for you, we had heard on the video a moment ago, the audio as well, Mrs. Miller saying, I gave my son to God. You heard that?
I did.
All right. Do you know if in Ruth's mind she believed that her son was still alive and with God and that she would be reunited with her son?
I don't know what she's got.
All right. That's all I have. Thank you, Judge. Thank you, Major. I appreciate it.
Nothing for me. Okay. Thank you.
Call Detective Fisher.
Thank you. Fisher, can you make your way around there? Go on to navigate. Detective Fisher. Do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth? If so, please indicate by stating either I swear or I affirm.
I swear.
And tell us your name and occupation.
Adam Fisher. I am a detective with the Tuscarawas County Sheriff's Office.
Okay. For how long have you been employed in that capacity?
I've been a detective for the last 8 years.
For how long have you been a certified law enforcement officer?
19 years.
And can you give us some idea of the training and education you received prior to becoming a law enforcement officer?
Kind of in conjunction with, I have a couple of degrees in criminal justice. I went through the police academy. I also have a master's degree in forensic psychology.
I have done a number of advanced trainings as life has gone on in the law enforcement realm. So there's a number of things there.
Okay. And any special training in the law enforcement realm beyond the college education as it relates to mental health issues?
Yes. So in law enforcement, we have training which we call CIT, or Crisis Intervention Team, and that training specifically is positioned around handling or dealing with individuals in some type of mental health crisis for any wide range of varieties.
Okay. And have you undergone that CIT training?
I have.
Okay. Have you trained in connection with that CIT training?
I have.
Okay. Now, on August 23rd of this year, we heard testimony that the Rangers were dispatched to a golf cart in the water. You were here for all that testimony. When did you learn of this situation and how?
So August 23rd was a Saturday. I typically work Monday through Friday with the position that I currently hold at the sheriff's office. So it was a little bit before noon. I want to say 11:50, 11:51-ish. I actually received a call on my cell phone from the sheriff. And he had questioned, hey, do you know what's going on? Have you heard what's going on? Something to that effect. That's not an uncommon call for me to receive on the weekend. It's not uncommon for me to communicate with the sheriff on the weekend. And at that point, I did not know what he was speaking of. So he filled me in just a few of the details. That we had a golf cart that had crashed into Atwood Lake, that there was a suggestion of at least 2 missing people. There was potentially some question about some mental health crisis that may have been occurring, and that he thought that some people needed some assistance.
Okay. Do you remember what was said that gave you some concern about this being a mental health crisis?
There was the communication about Ruth suggesting that she had thrown her 4-year-old son into the lake to give him to God. There was also the suggestion that Marcus was at the bottom of the lake in the belly of a fish.
And it's about the time you get the call that she's being transported or about to be transported to Union Hospital, is that right?
Yes, that's correct.
Okay. And so, when you get that call, what is your first, what's your next move?
So, for purposes of probably too much detail, as soon as I get the call, I had to change clothes because it was a Saturday. I was doing work around the house. So by the time I changed clothes, just a matter of minutes, I had gotten into my patrol vehicle from the sheriff's office and immediately called the sheriff back to let him know that I was on my way, and determined that it was probably in the best interest of the case and for a matter of time's sake for me to respond directly to Union Hospital to meet Ruth there.
And what was your purpose of doing
that? Honestly, to attempt to gather some information. Do we in fact have 2 missing individuals? Are they in fact in the lake? Or is this a case of an individual who has experienced some type of mental health crisis and is not speaking of anything that is reality currently? And that would obviously, those details would determine our later response.
Did you respond directly to Union Hospital?
I did.
Tell us about that.
So when I arrived at Union Hospital, they're familiar with me, so and to see me on a Saturday was a little concerning to them, I believe. So I walked into the emergency room. I was immediately buzzed back to the treatment rooms that are in the emergency room. And there are 2 specific rooms within Union Hospital in which individuals who have some type of mental health issue, mental health crisis, have been pink slipped, some type of incident that way. They're specifically housed in one of these 2 rooms. And that's because the rooms themselves can be locked, and the contents of the rooms can be controlled so that there's no idea or there's no ability for somebody to grab some kind of equipment and use it then as a weapon. So I made my way towards those 2 rooms, presuming that that's where we were going to likely end up. Before I even got around the corner, I could hear a female voice singing very loudly. It appeared to be some kind of religious songs, hymns, something to that effect. So Ruth was definitely able to be heard long before I could see her. As soon as I rounded the corner, I did witness Ruth on the ambulance cot, and it was just a few moments then that she was transferred from that cot and placed onto the hospital bed in that room that I was first initially responding to.
Okay. And were you able to engage in a conversation with her?
I was. So upon meeting Ruth for the first time again, it was difficult to make a connection initially because of her loud singing, and she was not really listening to anything else that was going on there. She also had the sheet of the bed covered across her face, and she refused after several requests to remove that sheet from her face, saying that we needed to contact her husband Marcus and that the two of them would share their story together.
Was she making statements about Marcus and his whereabouts?
She was. She continually would say that Marcus was at the bottom of the lake, that he had been swallowed by a fish, and that that's where we would find him.
Okay. Before that, did she make a statement that Marcus would be at their home in Millersburg?
There was a suggestion. I don't recall if it was before that particular statement or after, but there was a statement made that Marcus would be at the home. Ruth also provided a cell phone number for Marcus, suggesting that we should call him and that he would answer, and that he would be able to tell us what had happened and respond to assist her.
Do you know, did anybody attempt to make that phone call to that phone number that she gave?
Yes, there were multiple attempts made. Both dispatch and I personally attempted to make a phone call to that phone number.
Okay.
It went unanswered and to voicemail.
Okay. And this is while you were at Union Hospital upon your initial response to the situation?
Yes.
When she gave that information about Marcus possibly being at the house waiting on her, their home in Millersburg, did you dispatch anyone to verify or falsify that?
I did. So as you can imagine, there's a team of detectives, right? It's not just me, and the others were out and or responding out to assist with this incident. So at the time that some of those comments were made, Detective Cole Morris and Detective Sergeant Ed Jones were requested to go to Millersburg and essentially check the house, see if we could find any activity there, and to gather any other details that we might be able to find.
Okay. And then you've been assigned the lead detective in this investigation, correct?
Yes.
Did you have a chance to talk with Detectives Jones and Morris about how that went for them?
Yes.
How that went?
Yeah, so they, the two of them were able to respond to the Miller residence. While in the area, they also made contact with the bishop, Mervyn Miller, and there was some conversation that was had with the bishop as well as checking the home. There was no activity inside the home. Nobody was located there. Everything appeared to be orderly. Nothing really appeared to be out of place. I say those things because in a number of different incidents that we may investigate, things can be disheveled. Things could be overturned. Things that would suggest that maybe there was some kind of crime there. So those are the things that we can look for. And none of those things were there. Everything appeared to be normal. Speaking with Bishop Miller, I know that he told Sergeant Jones that he believed that Ruth had been experiencing some mental health issues, and he spoke of an incident on the Thursday prior to this, so that would have been August 21st. And in that incident where he and a couple others had an intervention of sorts at Ruth and Marcus's home, he felt that they were misinterpreting passages of the Bible, and they were taking things too far. So they had this intervention. The group of them had come over and had a conversation with Ruth and Marcus about their beliefs.
Is it fair to say that stemmed from a concern about her mental health?
Yes.
Now, so Your initial response was to the hospital. She mentioned that her husband would be at the home waiting for her. You dispatched detectives to go out and look into that. So you're not getting this informational feedback real time at this point. You're still at the hospital, right?
Correct.
Okay. And you're just getting briefings of what happened on the scene as well.
Correct.
Okay. So were you able then to engage with Ruth about what had happened? And if so, what did she tell you?
So yes, some of the conversations with Ruth at this point were a little disjointed. Some of them were like bits and pieces almost, and had to put them back together to make it make sense. And she spoke of Marcus and him being at the bottom of the lake in the belly of a fish. She also spoke of 4-year-old Vincent and how she had thrown Vincent into the lake to give him to God. Ruth said that prior to that incident, at some point, she was asked by God if she was willing to give her husband and children to him, and she had made a promise to him previously about that. So when she and Vincent were on the dock, God spoke to her and told her to throw Vincent into the lake, and she did. She described watching Vincent go under the water and pop back up, and at that moment, God spoke to her, questioning why she was still looking for Vincent after she had given him to God. And said at that point, she turned around and walked away.
Okay. That's her account of what happened.
It is.
And that's what she told you at Union Hospital when you responded?
Yes.
At that point in time, had she mentioned that she was concerned that her husband was missing after having left that morning? Or was that later?
You know, the conversation about being concerned about him missing, I believe, happened in a later conversation. I'm not sure that we had that exact conversation the first time.
But she specifically told you that she threw Vincent off the dock as some, what she thought was an inspiration from God.
Yes.
What she said.
Yes.
And that she watched him drown.
Essentially, yes.
What did you do? What happened next?
During part of my conversation, when I was asking Ruth initially or we were communicating about the number from Marcus, Ruth had started to give me a phone number and then she stopped and she went back. And so I inquired as to what that phone number was, and it was actually a phone number for her father. So I excused myself from her room for a period of time, and I actually spoke with Ruth's father on the phone in an attempt again to gather any kind of information. Did they know the whereabouts of Marcus or Vincent? Had they seen him recently or them recently? Could her father provide any kind of insight on her? Is this some type of mental crisis or mental snap that has occurred, or are these individuals in fact missing? And during that conversation, Ruth's father was shocked about the phone call, if I can say that, and did not have any idea where Marcus or Vincent may have been. They should have, according to him, been with Ruth and they together at Atwood, and that was the last that he had known.
And then anything else before you left the hospital?
No, I was continuing to try to get as much information as possible, but at that point, I almost feel like the law enforcement and the medical world collided, and they were attempting to treat Ruth for whatever it was that they felt necessary. They had given her some medications at that point, and she was not able to answer any more questions that I had.
So what did you do when you left?
So when I left there, I responded from the hospital directly to Atwood, and I made contact with the units that were there on scene.
And was there some concern about where to look for these bodies?
There was. So there was some suggestion of what is labeled as the Causeway Dock, simply a name that Atwood has given the dock area where the Miller boat is docked and where this incident had taken place. Or there's another kayak area or a kayak dock closer to the Welcome Center. So as we were going through and talking to some witnesses, there was a witness who had observed Mrs. Miller and her children at the kayak dock, and they were described as what appeared that they were praying. And so that was an area of concern. There was definitely the Causeway Dock where a lot of these incidents had described or have been described to have taken place, so that was an area of concern as well.
When you arrived back out on scene, were there divers exploring the lake?
There were, yes. And initially they had focused their efforts around the Causeway Dock or at the Causeway Dock. If you look or can picture a dock in particular just kind of going straight out, and the boats are docked on both the left and right side. When I had gotten there, the divers were looking on both that left and right side. They had moved some boats and they were looking under where those boats may be.
At some point, did you, I guess, want some clarification from Ruth as to where specifically she would have?
I did. So obviously the Causeway Dock had been explored, the left and the right, under where those boats would be by the divers. We had then moved the divers to the position of the kayak area, the kayak launch, and they had checked that area, and we were really kind of running out of ideas, so to speak, at this point. We weren't finding anything, which seems to be a good thing, but it's also, there's a lot of suggestion that he may be here. So we needed to make sure that we weren't in fact going to find Vincen and or Marcus. I had made a call at that point in time, so some hours had passed, and I had made a call back to Union Hospital and said or made the suggestion that I wanted to take Ruth from the hospital, that I wanted to take her with me, I wanted to transport her back to Atwood. And I wanted her to really give us some clarification, like where did these incidents happen, point to me where Vincen went in the water, those kind of things. And as you can imagine, the hospital was not readily agreeable to that, and there was some red tape to get through. So in the meantime, while we were exchanging some phone calls back and forth between me and the hospital, I was notified by one of the Cleveland Clinic police officers that Ruth had drawn a map of where exactly she had placed Vincen in the water.
Did you somehow get an image of that map?
I did. So almost immediately after it was drawn, I received a text message, a picture of the map, and then later I received the actual physical copy of the map that Ruth had drawn.
Okay. And can you just describe what that map depicted?
Sure. So again, if I can take you back to that mental image of the dock, just going straight out, the boats on the left and right side. If we were to just go straight out at the end of the dock, there was a dot, a significant black dot, like it was scribbled in a circle. And that was the indication from Ruth as to where she had thrown Vincen in the water on that particular day.
What, are we talking about the Causeway Dock or just the kayak?
Sorry, we are talking about the Causeway Dock. And it was specified there also that it was the Causeway Dock.
Tell us about the search efforts after that.
With that map in mind and the information that Ruth had drawn us and indicated specifically where she had thrown Vincen into the water, divers were requested to go back to the Causeway Dock and focus their efforts on in front of, or at the end of that dock, which I later learned that they had not done prior to that request. And when they focused their efforts, it was a very short time when they then located the body of 4-year-old Vincen Miller about 10 feet off of the end of that dock, on the bottom of the lake.
Do you know approximately what time that would have been?
I want to say roughly around 6:30 p.m.
Okay. about 6:03, I think. Is that any reason to disagree with that?
Nope, it was a 6-3 and a 0. Yep, backwards.
All right. And then you later that evening went up to the hospital again to interview her, is that right?
I did. So 6:03 p.m., you think August 23rd, it stays daylight longer than it does now. So we continued to have the divers search the area for Marcus. As long as we could, the nighttime hours fell, and we decided that it was probably in the best interest of everybody to call off any remaining searches until the next morning. As you could probably imagine, there's still something in my gut, though. We're still haven't located somebody else that was talked about at this time, so I felt the need to respond back to Union Hospital and speak with Ruth again to see if I could gather any more information from her regarding Marcus or his location. So after we had called off the search for the evening, I responded back to Union Hospital. Ruth was still in the same room that she had been in previously. She appeared to be much more coherent at this time. I introduced myself to her, requested if she would speak with me, and she agreed. Because of the information that I have now, right? Before it was, do we really have somebody who's missing? Do we have a mental health crisis? Is there something going on? Versus now, we've located a body right where she said she threw him in the lake. I read her Miranda rights, something that we read people and make sure that they understand what's happening, and she did agree to speak with me at that point, and she walked me right back through this incident again. So we talked about how the day had begun, how the night prior to that had happened. Ruth said that she and the family had arrived at Atwood on Friday. Afternoon, early evening, they had unloaded some stuff from their truck, and the family had gone on the pontoon boat. She said they had a great time. They were cruising around the upper end, something that she described, the upper end of the lake, and the kids were fishing. She said it got dark, but that she and Marcus didn't want to end the fishing trip early or the fun that the kids were having, so they actually didn't get back to the camper until about 10 p.m. that evening. She said Marcus went to bed, and the kids stayed up and they watched TV. At about midnight, somewhere around midnight, Ruth said that she and Marcus were awoken by God. That they began to pray and read the Bible, and the two made the decision that they were going to go back to the boat. She said she grabbed a blanket and a Bible, her Bible, and they walked out the door. Now there's the golf cart there that you've heard us talk about before, and she said they were going to drive the golf cart to the boat. However, the neighboring camper, the neighbor was right outside, Chad Engstrom, and she had asked him, I believe actually it was Marcus that had asked, one of them had asked him if Chad would take them to the dock. So there was some discussion as to where the location of the dock was, and then ultimately Chad takes them there. Ruth said that she and Marcus, once they get to the boat, realized that they had forgotten the keys to the boat. So they began to pray again and to experience these different tests of God or from God. They were asked to get into the water, and it's dark. Ruth says that she and Marcus were both nervous about getting in the water initially. But they got in the water. They were to float on their backs at one point. And Marcus began to sink during this, so he swam back to the dock. He was then supposed to be able to pull Ruth from the water onto the dock, and after 3 failed attempts, she had to swim to the back of the boat and climb out using the ladder there. She said that Marcus did not, or let's first say that he started to sink because of his lack of faith, and that he was not able to pull her out of the water because he did not ask God for any strength to do that. There was also a discussion that Marcus was to swim to the sandbar at Atwood Lake, and To give you any kind of direction exactly where a sandbar is, I can't do that. I'm not sure that there is one at Atwood Lake. But Marcus was to swim out.
Are we still talking about her account of what happened between midnight, 1 in the morning?
Yes, this is her account still. So they're down and they're doing all of these tests. Marcus was to swim to the sandbar and didn't make it. He gave up in the middle of that and came back to the dock. And then Ruth, was supposed to walk on water. Because of her hesitation and again, her questioning, so to speak, of God when she went to walk on water, she fell right in. She was not able to complete that task. Eventually, they're both out of the water and they're on the dock, and Ruth says that at that point she was wrapped in a blanket and she had asked Marcus just to suffocate her. And when I explored that a little farther, she obviously said that Marcus would not suffocate her and made some suggestion that he had spoke of suffocating her in the past. Again, presumably from some kind of feuds that they may have had in their relationship. When we get to this point, Ruth and Marcus decide that they're going to walk back to the camper. It's just about 5 a.m. according to her account. She says that Marcus had water in his ears and a headache, and she wasn't feeling the best either. And on their walk back to the camper, they had convinced themselves that the things that they were doing were crazy, but this is not reality. And they were laughing and in a good mood by the time they got back, but shortly after getting back to the camper, they changed their thought process and said, no, that was reality. These are the things that we should be doing. And Marcus felt that he had failed God, that he had failed these attempts. And he told Ruth that he was going to go for a walk, and then he was going to swim to the sandbar. And he left the camper at this point, roughly about 6, a little after, 5:30, 6 a.m., and Ruth had never seen him again at that point.
That's what Ruth told you?
Yes.
Okay. Backing up just a little bit, you said that Ruth said that she or her husband had asked a neighboring camper to take them from their campsite to the dock.
Yes.
Were you ever able, or was anybody able to corroborate that by talking to that neighboring camper?
Yes, so there was an interview completed with Chad Engstrom, and he confirmed essentially the same story, that he was asked at about midnight, 1 a.m. to take Ruth and her husband to their dock, the Causeway dock. Initially, he said it was a little weird to him that that request was made. There was that discussion about where was the dock located, but he didn't necessarily find it a big deal because he was going to some relative's camper in that area of the Causeway dock, and it was on his way. So he did provide the ride to Ruth and Marcus.
So she says that she and her husband Marcus were out there for some time. They came back, but that Marcus left on foot again to go. She says that he said that he was going to swim to the sandbar.
Yes.
And she said that happened about 5 or 5:30 in the morning.
Yeah, there was a little bit of gray area as to the time that they got back to the camper and then the time that Marcus left. But it was soon after they had gotten to the camper that Marcus then turned around.
Did she say what happened next from her perspective?
So Marcus leaves, and she said that she laid down for a little bit and was awoken about the time that the sun rose. And Marcus still was not home. So she went out to search for him and pray that his faith remained strong and that he'd be able to complete any of the tasks that were given to him. As she was walking out the door, she said 4-year-old Vincen had asked to go along. So she took him along with her and proceeded to drive to the Causeway dock. About the time that they were at the Causeway dock is when she received the communication from God, reminding her of the promise that she had previously made to him, and that she was directed to throw Vincen into the water to give him to God. Ruth said that she proceeded to the end of the dock and she threw Vincen into the water as instructed.
Did she give an account that she was concerned about her husband because she had seen his clothes left on the pontoon at the dock?
She spoke very briefly about his clothes on the pontoon and that they were the same clothes that he had been wearing when he had left the house. So the suggestion that she believed then was he was in the water.
Do you know, did initial responding officers observe clothes on the pontoon boat?
They did. So remember when I spoke of the boats themselves being moved away from that dock for the divers to look under them. When they were moved, there was the discussion that some clothing was on the pontoon.
Particularly sandals, brown pants, and a tan shirt, I believe.
Yeah, I think it was described by her as when we spoke later about it, tan pants, a cream color shirt, and sandals, but yes.
So she gave the account of going out to the dock, or come with Vincen.
Yes.
Did she say that happened in the golf cart?
They had driven the golf cart to the Causeway dock, yes.
About throwing Vincen off the dock.
Yes.
Watching him drown. What did she say happened next?
Immediately after throwing Vincen into the water, watching him pop back up, receiving that question from God, turning around and walking away, she proceeded back to the campsite and retrieved 15-year-old Amber. She had driven Amber back to that same dock, the Causeway dock, and had told Amber that she needed to give herself to God and she needed to run off the end of that dock and jump in the lake, to which Amber did. Immediately after Amber had entered the water, she turned around and went back to the campsite again and retrieved both her 18-year-old sons, Jordan and Joel, bringing them to the Causeway dock and instructing them to do the same, give themselves to God and jump off the end of the dock into the lake. And they did.
They all swam to safety, right?
Yes. At some point, Ruth also jumped off the end of the dock to give herself to God. And then the family came back together on the dock, where they proceeded to put their hands in the water and pray over Marcus and Vincen prior to getting back on the golf cart and leaving the area and heading towards the marina. Ruth said that as they were on their way back, I believe the initial thought was to go back to the campsite. However, Ruth tells me that she missed the road to the campsite and they proceeded traveling down the main roadway there, which ultimately will eventually lead to the marina. And after missing the road to the campsite, she was instructed by God, or she heard that direction from God again, to continue towards the lighthouse. For those that are familiar or not familiar with Atwood, there's the marina and then there's the lighthouse bistro with an actual replica of a lighthouse there. So that was the area that she was going to. Right as she's entering the area of the lighthouse, the marina in that area, she says that she again heard a statement from God that said something to the effect of, "Don't get off the pedal." And so she proceeded to have her foot on the gas pedal of the golf cart, drive down into the lake with her 3 remaining children on the golf cart with her.
Now, I think in the body cam footage, Deputy Edwards had made some comment about a husband and wife on a bicycle, and I think they were later interviewed as well.
They were. I believe their last name is Ryman. So Mr. and Mrs. Ryman were in the area of the marina, the Lighthouse Bistro, and they actually witnessed Ruth Miller with the golf cart and her remaining 3 children. And I believe their term that they said was careening out of control. Their initial thought was that something had happened mechanically to the golf cart, that the brakes were out, or that there was some kind of failure that Ruth was not able to control the golf cart. However, soon realized that it was very intentional. So they witnessed her drive through the lighthouse and the marina and down through the grass and over the wall into the water.
They in fact say that as they're riding their bikes through the campground at that point in time, that they first saw the family praying near the kayak dock?
They did. So this was the same people that had seen the Miller family praying at the kayak dock. The kayak launch, I believe is what it's called.
Okay. And from there, as they're on their bike ride, they see the golf cart with all 4 of them in it race by them?
Yes.
And then they saw it careen into the...
Correct.
Now, in terms of Marcus Miller's last known whereabouts, we know what Ruth's account was. Was there any witness that was able to corroborate any of that in terms of him being at the dock early in the morning?
There was. So again, in the business that I'm in, we obviously want to know stories or make sure that things make sense. And Ruth said that she had last seen Marcus roughly around the 5:30 mark when he was leaving the camper, and that she had never seen him again, but then later admits that she purposely threw Vincen into the lake. So there was some question as to what happened to Marcus and where is he. We were able to make contact with another individual, Marcus Raber, who describes that he saw an Amish individual around the Causeway dock around 6:30 in the morning of August 23rd. And he remembered specifically that it was 6:30 because there was a sailboat that was docked in that area, and he had taken a picture on his cell phone of the sailboat, and the timestamp of that picture was 6:30. What initially had grabbed his attention is that he knows Marcus's brother, Robert, and he thought that it was initially Robert that was out there and he was going to go speak to him, and as the two got closer, he soon figured out that it was not Robert and he did not know Marcus, but was able to describe him in the exact same clothing that was located on the pontoon boat.
Now, the surviving children, 15-year-old daughter and 2 18-year-old twin boys.
Yes.
I think other officers spoke to them at the scene, and they were later interviewed at the Child Advocacy Center.
Yes.
Last week.
Yes.
Were you there for that?
I was.
Okay. Tell us about those interviews.
Jordan and Joel, 18, males, and I think much like a male demeanor, so to speak, they were very reserved in their interviews or their conversation that we had with them. They both described that they worked for the family company and they liked hunting and fishing. When asked specifically about the details of the events surrounding the August 23rd incident, Joel would not say anything, provided no details. Please excuse me if I have been confused. I'm a twin myself. You think I should know that. But Joel would not provide any details. Simply just remaining silent. He spoke of seeing his mom one time after that incident, and that he thought that she was fine during that incident. Jordan, much the same. Again, not describing a whole lot of detail about the incident except suggesting that he thought that maybe his mom had at some point seen a doctor for something and could potentially be taking some type of medication. When asked what he would tell her if he had to see her again, he again did not provide any details. He said something to the effect of, "I'm not sure what I would tell her." Neither of those boys suggested that anybody had told them to say anything specific in their interviews, alluding to that they had a conversation with their uncle who simply just said, "Be careful what you say." Amber was visibly emotional and distraught through the interview. She spoke of, when we got to the point of asking about the Atwood incident, she spoke of the incident, and when she talked about mom leaving with Vincen, she broke down crying and repeatedly saying, she didn't need to do it, she didn't need to do it, she didn't need to do it. She then went on to speak of mom struggling at times with being mentally stable, that mom would have her good days and her bad days. That on her bad days, she was described to be not sleep very well and to be sad. She talked of mom praying, and it was in talking of God, and it was different this time, the moments before leaving with Vincen. And she said that she believed that because Dad hadn't returned from his swim, that Mom was frantic. She described her as frantic, that she was upset and she was frantic, and that she left the camper. She said something else that caught her odd was initially Vincen had asked to go with Mom to look for Dad, and Mom told him no, which is something that Mom doesn't often do with Vincen. But then after a very short time, she said yes to go with her. And so she left with Vincen, returning a short time later and telling her, "Come with me, come quick, come now." And Amber went with Ruth. And during that travel, their travel to the dock, Amber said that Ruth told her that she had thrown Vincen in the water. And again, at this point in the interview, Amber broke down again, saying she didn't need to do it. She's a good mom. She didn't need to do it.
It's fair to say that Amber wasn't nearly as guarded as the boys.
Yes.
And is what Amber said from her perspective corroborative of Ruth's account of what happened?
Yes.
Did you get the sense that any of these three children were traumatized by the circumstances in their life?
Yes. And I think that was extremely evident by the interviews of the children at Noah's home. First by Joel just simply shutting down and not answering any more questions when the word Atwood was even mentioned. And then Amber's response, her emotional response throughout the entire incident.
It's clear that they all still love their mom.
Yes.
Are you familiar with, so I think Ruth was taken medically to Union Hospital given the circumstances.
Yes.
She was at Union Hospital for a couple of days, and I think that the hospital pink slipped her to another hospital.
Yes, did it.
Okay. Where she was for another several days. Before she was brought back to our county for an arrest warrant.
Correct.
Okay. Since she's been in our county jail, can you tell us how things have gone for Ruth Miller?
Sure. There have been no complaints from staff or inmates about Ruth. She has been, I guess you could describe her as the model inmate. She doesn't complain. She is not the subject of any formal discipline. She was initially segregated or separated from the entire population of the jail. We first do that based on that mental health history, based on a few of the criteria when she comes in. There was also, obviously she's going to be housed in general population, she's going to be housed with other females, and presumably other females could potentially have children, and that could result in some heated emotion or escalated emotion and some potential for violence. So that was just kind of being weighed out. At her own request, Ruth was eventually transferred to the female pod, or the general population of the female pod, when there was space. So that recently happened, probably about 2 weeks ago, and since that time there again have been no complaints.
And no reported mental health crises on her behalf?
No.
And no complaints by her about her medical treatment?
Correct, no complaints.
I have no further questions, Sean.
Okay, thank you. Ian?
Just so everyone knows too, after this witness, there are 2 more witnesses. We'll probably take a brief recess.
So I was actually going to say, based upon the testimony so far, I'm not going to call Ranger Lucas Pace, so as a courtesy, would the court like me to notify him so that he's not sitting in the hall? Okay. This actually makes a difference. So. Detective, good afternoon. We've met, so.
Yes, sir.
My questions for you, I'm going to ask a few out of order just based upon your direct examination.
Sure.
If at any time that we're conversing through this examination you don't understand something I ask or just need clarification, please just ask me to do so, okay?
Yes, sir.
Now, you brought up early on when you were talking about your training, you brought up the word crisis in relation to mental health crisis. And what does that mean to you? What do you define as a mental health crisis?
A mental health crisis can be any number of things. There obviously is going to be probably a very specific definition that you might be looking for, but it can be somebody who is overwhelmed in any moment, and their responses or perceived responses occur because of some kind of lack of reality, lack of perception, really just a response to being overwhelmed at any point in time can be any of that.
In your dealings with Mrs. Miller, how would you describe her reality?
The word that I used earlier, and I think that it really hits home with this, was disheveled. Like her reality at the point was disheveled. Her reality at the point was really based on the foundation of religion and God and the things that He was telling her to do.
The discussion that you were having with her during the first and second interview,
Was that a kind of a reality different from yours, being in a normal state of mind at that time?
Yes, sir.
Now, one of the issues that you brought up on direct was Mrs. Miller asking you to make contact with her husband, Marcus, after we know at this point, and I'd said he had already gone out into the lake and had passed, right?
Oh, correct.
And
I would object to the characterization in that
I'm sorry, maybe I just
when
phrased
he
it
made
wrong.
that statement, we did not know at that point the whereabouts of either Marcus or Vincent.
That's fair. I'll redraw the question. Yeah, sorry, for the first question. So, when Mrs. Miller asked you to contact Marcus, she suggested that he may be at home. Is that correct?
She did at some point, yes.
Okay. And she had you, or suggested that you call his cell phone as well?
Correct.
All right. And was there anything about that interaction that you deemed to, or chalked up to her just trying to be deceitful to you?
No, not necessarily. At that point, I think the details of all of the incidents were in question, and so it was really just trying to determine what the truth was, not that she was necessarily trying to be deceitful.
Might it have been that what you were being told by Mrs. Miller, in her reality, she believed what she was saying?
Might have been, sure.
Now, I told you I'm going to skip around just for a moment, and then I'll get into some semblance of order with you. You had heard the testimony before you about Mrs. Miller trying to run away from the Rangers. Do you recall that?
Yes.
Okay. And did you ever address with her why she ran from the Rangers?
No, because if I'm being honest with you, at the time that I had my first conversation with her, I had not had any contact with any Rangers, nor did I know that she had ran. And the second conversation, again, there was no discussion of that interaction with her having with the Rangers.
Okay. So as you sit here today, you don't know what her purpose in running away from the Rangers was on August 23rd?
Correct.
And just, did Ruth believe on August 23rd, at the time that you went to speak with her? I think she had said to you that, or it alluded to the fact that she may see her child and husband again?
Yes.
Okay. And if I were to suggest to you that she believed that her husband and child were still alive when you spoke, you would not have an opinion one way or the other?
Your Honor, I guess I would object to the extent that the questions call for speculation as to the mental state of Ruth Miller or anyone. We only know what she told us in terms of what she believed and was that delusional or not. That's something that goes to speculation as to mental state, and she's going to be examined. She's in the process of being examined by a forensic psychologist to weigh in on that as it relates to competency and sanity. But in terms of a witness who was not inside her mind at the time, I think it calls for speculation.
Thank you, Your Honor. So, Your Honor, Section 1 on the bond issue deals with the word commit, and we talked in opening statement as to both the act and the mental state being at play. And I had stated at the time, Your Honor, in introduction of what we intended to do here today, that I would be focused on the mental state, because without it, she could not have committed the crime. Hence, that is the reason why the NGRI was put into play. So mental state is an issue when the issue of no bond is raised. It may not be in other instances or if a bond had been set, but here under this statute, when we break down the word commit, mental state does come into play.
All right. I'm going to overrule the objection. Maybe for reasons slightly different than what Ian has stated here, but I do believe that the statute does contemplate a consideration of the accused mental condition, and I'm going to allow it.
Thank you, Aaron. So I'll come back to that question in a minute. And detective, and is that detective, captain, detective?
Wait, whichever you prefer.
Or what do you prefer? You burn it.
There's a lot there, so I shortened it to one. Captain is great.
Captain, very good. So Captain Fisher, you've got 19 years of experience, I believe, before being a detective, or 19 in total? 19
in total.
And your experience with mental health matters, you seem to indicate you had training beyond that which one would just receive from the academy. Specifically, you've got certification or training in forensic psychology.
Yes.
Okay. What other training do you have as it relates to mental health matters within law enforcement and mental health crises?
So the degree in forensic psychology, the crisis intervention team training, hostage negotiator. I am one of our only hostage negotiators here in the county. And then just continuous presentations that I give myself, teachings and others that I receive as to any type of mental health issue or crisis within the county.
And do you have experience with matters where pleas of not guilty by reason of insanity or the mental state of a defendant as to whether it constitutes an NGRI? Have you dealt with those sorts of cases before?
Not specifically, no.
Okay. So this case here in the state of Ohio versus Ruth Miller is the first case which you've been involved with that the issue of whether or not she was not guilty by reason of insanity is central. This will be the first time.
Yeah.
Now, obviously, prior to August 23rd, 2025, you did not know the family or have any understanding of the Miller family, correct?
That's correct.
And by all accounts, through your investigation, Mrs. Miller was deemed to be a good mom to her 4 children.
Right from their mouths, yes.
And you received no other evidence that would contradict that?
No.
And just to get this out of the way, and while she's not been charged with it, I just want to make sure that you have determined that Mrs. Miller was not responsible for her husband Marcus Miller's death.
That's correct.
Can you tell me, Captain, please describe your attempts through your investigation or by way of your investigation to understand Ruth Miller's mental health history?
So the mental health history was first brought to us by her own family, suggesting that Ruth had been experiencing some kind of struggles with mental health for approximately the past 6 months. As you're aware, the Amish community addresses mental health and things like that a little differently than us as English. So the documentation or anything like that is generally non-existent. So the family saying that there was some struggles there, the family suggesting that she was seeing a doctor, potentially taking some medication. They could not provide any other information as to who that doctor was or what medication it would be for any further follow-up, and they were described to be, the Miller family was described to be very private, and that not even their own family would know that information.
And were you able to make any determinations as to how Ruth Miller's mental history played into the incident of August 23rd, 2025?
So the discussions that were had surrounding the previous 6 months of some mental health history were some conversations about misinterpreting of the Bible, some misinterpretation there, some believing that God was coming back very soon to get your affairs in order, and that the family and the bishop and others had had these interventions to talk to Ruth and ultimately Marcus and redirect them on a path that was more appropriate. So I think the conversations about the religious aspects of her mental health issues and then the statements made by her the day of the incident saying that God had told her or directed her to do things really coincides with that. So that was the same thing that she had been experiencing.
And in fact, the family and the bishop were actually very worried about Ruth's mental well-being, and Marcus's for that matter, when they did an intervention just days before being present at Atwood Lake.
Correct.
Yet they felt that perhaps a change of scenery, that going to Atwood Lake might be good for them.
Yes, and that was actually a conversation that Robert had had. Robert is Marcus's brother. Robert had had. He was involved in one of that latest intervention, and described that Marcus was a workaholic, and that that's all they ever did was work. So that may be a different change of scenery, someplace different, a place to relax, to relieve some stress may be helpful.
So, with your interview of the 3 children, it was described, I believe, by the daughter, perhaps, that her mom was frantic when she came to the campground. Is that right?
Yes.
Okay. And did you seek any clarification on what that meant?
So not when they came to the campground, but it was the day that Marcus had left in the morning, so on the 23rd, that she had awoken and that she said that her mom appeared frantic. And when there was further discussion about that, Amber clarified that she wasn't sure, but she felt that it was because her mom had not seen her dad and didn't know where she was. The fact that he was, quote unquote, missing.
And as it related, you had said during direct examination that initially, when Vincent wanted to go with Mrs. Miller, she said no.
Yes, according to Amber, that was something that had caught her attention, was that Ruth had told him no initially.
And as it relates to time, this would have been moments before Vincent was put in the lake?
Yes.
And so what we know, at least from what was told you, that Ruth was not intending on taking Vincent, at least initially, but only after, do you know how much time passed before she decided to take him?
I don't. The way it would be perceived by me, or the way that it was suggested, was that Vincent had asked to go, Ruth told him no, and then decided to take him back. So whatever we can make that period of time, it did not seem very significant at all.
Okay. Did you ever receive any evidence to suggest that she had asked Vincent to go?
No.
That Mrs. Miller had asked Vincent to go to the lake with her?
No, other than her own testimony saying that she had put him in the golf cart and transported him down there. That was the only other conversation.
So I want to talk to you for a moment about whether your investigation revealed that Mrs. Miller believed that her child was actually dead when she placed the child in the lake. Okay? And so my question to you is this. You spoke to Amber, and Amber told you that her mom believed that the child, that being Vincent, would actually come back out of the water if they had enough faith in God. And for all you know, Mrs. Miller truly believed that.
Correct.
Because her reality may have been very different from yours or mine or any of the other first responders that day.
I would object, Your Honor. I think we're going down the lines of, for all you know, that's complete speculation. We really need someone who's an expert forensic psychologist to explore those issues. So in terms of the testimony should be limited to what he knows, not for what, for all we know, this could be the case.
Brian, I recognize that Adam is not an expert. I'll give the weight that I would use. I understand if there were others who may be confused by that. Right. I understand your point, but I recognize he has limits. That's the what he knows, and I'll use the weight it is. It's very limited.
Thank you. I'm sorry to interrupt you. I thought you were... Did your investigation also reveal that Ruth believed that her husband, Marcus, would reappear somewhere?
Yes.
Okay, tell us about that.
In one brief conversation or one brief statement that Ruth had made, she suggested that they were going to the lighthouse I spoke with the lighthouse and the marina that they were going to the lighthouse because she was told by God to go there and she would see Vincen and Marcus again.
And it was suggested, was it not, by Amber, that her mom was mentally unstable?
Yes.
And did you seek clarity on what that meant?
Amber used the statement of struggling with mental stability, I think is how she put it. And she just said that Amber noticed that her mom would have good days and bad days, and that on the bad days she would sleep a lot and was very sad. That was, and again at 15, I think that was probably the extent of what she knows.
Sure. And it was described to you by Amber that on that day, August 23rd, that her mom was acting different than normal.
Yes.
Now, did you speak to the Rangers as part of your investigation?
Just in passing, quite honestly. My focus was on Ruth and then locating Vincen and Marcus. And there was a team of detectives that are out there. So, others have spoken and had conversations with them as well. I did not feel that it was necessary at that point for me to.
Now, as the lead detective, you're responsible for this case, right? All right. And are you familiar with Caden Edwards?
Yes.
Okay, who is that?
Caden is a deputy with our office.
Okay. And it is true that Caden opined, based upon his involvement in this case, that Mrs. Miller was, quote, not in her correct state of mind.
Yes.
Okay. Did you talk to Deputy Edwards about his basis for that statement?
Yes. So the conversation that he and I had, Caden is a newer deputy here. So he and I talk frequently as life goes on or as he interacts with people on calls. And so when we spoke about this particular thing, he spoke of my words, Ruth's disjointed statements about the Marcus being in the belly of a fish on the bottom of the lake, and things that to him did not make sense.
Now, I believe, well, if you could answer this for me, who determined that there needed to be a mental health evaluation of Ruth Miller on that day?
I can't answer that. So I know that collectively I think that was the push to put Ruth in the back of the squad to have her evaluated. The formal decision for a mental evaluation was done by Cleveland Clinic Union Hospital.
Now, kind of pivoting here for a moment to the golf cart, which you're aware of, the driving the golf cart. Did you look into, or as part of your investigation, that deal with the operation of the golf cart?
Yes.
And do you agree with the descriptions that have been given and throughout your reports and others that Mrs. Miller operated the golf cart erratically?
Yes.
At any point, did Mrs. Miller crash that golf cart any other part of the grounds other than just going up the dock?
Yes. So there was a conversation and a description that Ruth was observed to be operating the golf cart erratically, that at one point she had even tipped the golf cart over on its side. She had gone back to the camper to retrieve her 18-year-old sons to get them to come back and help her lift the golf cart back up, which they did, and then she proceeded to drive that golf cart.
Did she ever hit any other obstacles that day with the golf cart?
Not that I can recall.
Now, were you involved in the gathering or execution of the search warrant on August 24th?
Yes.
Okay. And can you tell me what your involvement was with the search warrants? And there will be just some specific questions, not so much as to probable cause on a search warrant, but solely as to two pieces of evidence that were there.
Sure. So the search warrant itself was sought after by me, simply as a matter of procedure. Let's just make sure that there's nothing else in this camper that's going to give us any kind of insight into the case. So the search warrant was obtained. Our process throughout the sheriff's office, for a matter of efficiency, is there were 2 detectives that were already on scene. So the search warrant was signed, a phone call is made to say the search warrant has been granted, and they entered the camper, proceeded to complete an inventory, take photographs, document the things that were there. While that was happening, I responded to Atwood, and I arrived at the tail end of that execution of the search warrant.
Now, there were different tents, I believe, that were searched. One being 10, and I'd like to refer to tent 1 and tent 3.
So the tents that you are describing are tents with numbers on them. So anytime that we execute a search warrant, if we find something of interest, we will tenant with that number to then photograph it, draw some attention to it, photograph it, and then be able to label it accurately on that inventory that you're likely looking at.
Thank you. And what I'd like to talk to you about is there was a Bible that was found, that was located as part of the search.
Yes.
And that Bible was not taken, but it was merely photographed, right?
Correct.
I just don't have it yet, or if it has been given out, I apologize, I have not seen it yet. Is there a photograph of the Bible in the open position?
Certainly.
So that we were able to determine what may have been viewed last in that Bible?
Yes.
Okay. And do you recall what that was?
I don't.
That's okay. The other thing that I'd like to bring your attention to is tent 3, which were described as over-the-counter supplements. Do you recall that?
Yes.
All right. Those were not taken into evidence either, they were just photographed.
Correct.
Do we know what those supplements were, or why they were being taken?
No, I do not know why they were being taken, what they were. To tell you that off the top of my head, the answer is no. It is documented specifically what those were.
Okay. Now, during your 2 interviews of Ruth, you would agree with me that the statements that she made to you were unclear at times?
Yes.
And an example of that lack of clarity would be Ruth telling you that they were in the water, they being presumably a reference to Vincent and her husband, but in heaven, correct?
Yes.
And prior to that, would you agree with the assertion that Ruth began talking to law enforcement immediately at Atwood Lake when approached?
Yes.
She never tried to deny that the son or husband were in the water, correct?
Correct.
She was clear that she did throw Vincent in the lake, correct?
Yes.
But after that, when being questioned, Ruth spent a lot of time trying to emphasize, her reaction to that was that she was emphasizing that God is real.
Yes.
And that she gave her son to God because it was a test from God.
Correct.
Now, what is the word, based upon your training and as it was used in this investigation, what does the word irrational mean to you?
Irrational to me would mean not in a normal, and that's a little response also, but not a normal way of thinking, not a common way of thinking.
And I think that you had stated, or did you state, I should ask, that it was due to her behavior and her irrational thought process that Ruth was pink slipped to the Cleveland Clinic?
Yes.
Okay. And do you know who saw the pink slip at the Cleveland Clinic?
I don't.
Did you talk to any of the medical staff at the Cleveland Clinic about their treatment or determinations of Ruth Miller?
So my initial response to Cleveland Clinic, I had a very brief discussion with the doctor. I informed him of our response, the fact that there were 2 missing individuals, a few of the things that Ruth was saying, and I simply made a request to speak with Ruth before they offered her any type of treatment so that I could try to get any information. Specifically asking determinations of medical procedures or treatment is frowned upon at any kind of hospital. There have been search warrants submitted to Cleveland Clinic, so we have those official records. However, the conversations don't generally happen to us specifically.
Thank you. Now, Captain, you had spoken on direct examination about the sheet that was over Mrs. Miller's face at the hospital. It is true that Mrs. Miller kept the sheet on her face and would keep the sheet on her face until she was reconnected with her husband.
Yes, she made that statement.
All right, and she made that statement to you.
Yes.
All right. And the reason that she was going to keep the sheet on her face, or withdraw the question. She stated further to you that at some point they, and that presumed to be Marcus, she and Marcus would tell their story.
Yes.
And did you ask her to clarify that statement or give any further detail on that statement?
There was a question, to something of the sort of what does that mean, where is he? And she could not provide an answer any different than what she had already provided.
Now, you had spoken on direct examination about the bishop or family members talking about Mrs. Miller's difficulty sleeping. Recall that?
The difficulty sleeping conversation came from Amber. Yes.
From Amber, I apologize. So what did you do as part of your investigation to determine whether or not there was any validity to that statement and how it may have affected Ruth Miller's mental state on August 23rd?
I don't know that there was anything else to do at that point with Ruth being in custody at the jail and represented by you. I don't know that it's appropriate to have that conversation with her. So I think just the statement from Amber alone is what it is.
Did you talk to any of the family members, go back to them and talk about what their experience was with Mrs. Miller and whether she was suffering from sleep deprivation?
Yeah.
Now, as it relates to the tests in the water with Marcus, so the tests with Mrs. Miller and Mr. Miller, Marcus, it was communicated to you that any failures to these tests were due to doubts in God.
Yes.
By Mrs. Miller, correct?
Yes.
And I would like to talk about an instance where it was communicated to you, I believe, that Mrs. Miller tried to actually walk on water.
Yes.
Do you remember that?
Yes.
Okay. What was told you and where was that?
It was in the hospital room, and it came directly from Ruth. That she was explaining that one of her tests from God was to walk on water, and that she hesitated, and that her doubt in God, the hesitation, is what caused her the inability to walk on water.
Now, we do know, at least based upon what she said, let me say, no one saw her trying to walk on water, correct?
Correct.
And you were also told by Mrs. Miller that when she did try to walk on the water, she was actually wearing her clothes, correct?
Correct.
And because she was wearing the clothes, once she went under the water, it was difficult to swim because of the weight on the clothes.
Yes.
Now, you had brought up the sheriff, Sheriff Orvis Campbell, calling you I believe on Saturday.
Yeah.
And not getting into necessarily what the job, duties were and so forth. But my question to you is, were you present for his press conference that followed the arrest of Mrs. Miller?
I was.
Okay. And Sheriff Campbell was very involved in this investigation as well, correct?
Yes.
And you and he had communicated back and forth as to findings in this case?
Correct.
And it was described by the sheriff that Ruth Miller, or he opined that there was a detachment from reality. Okay, I'm not asking you as to what he said. Do you recall that?
I did.
Okay. Do you agree that the evidence in this case that was gathered pointed to a detachment from reality by Mrs. Miller.
Thank you.
And Sheriff Campbell had also opined during this very press conference that the investigation pointed to the fact that Mrs. Miller was delusional on August 23rd, 2025. Do you recall that?
I do.
And do you agree with Sheriff Campbell that Mrs. Miller, or that the investigation evidences that Mrs. Miller was delusional on August 23rd, 2025?
I do.
And Sheriff Campbell had also talked about the fact that what had been conveyed to law enforcement, so I assume you, since you did the interviews, by Mrs. Miller had panned out to be truthful. Specifically, what was described about Marcus, his actions, what he was wearing, and so forth.
Yes.
And was there anything during your investigation that revealed at any time that Mrs. Miller was being untruthful with you or attempting to deceive you?
No.
Now, there's some other factors that we have to address here today. You obviously did a background check on Mrs. Miller.
Yes.
And that revealed no prior criminal history.
Correct.
We talked earlier on about her being a good mother. There were no reports from anyone, negative reports from anyone related to ill treatment of any of the children prior to August 23rd, 2025.
Correct.
All right. Now, looking through your records, you, Captain, determined that Ruth Miller was experiencing a mental health crisis as she cannot provide clear information, correct?
Correct.
And what was, when you said she was experiencing a mental health crisis, as it relates to Ruth Miller, what were you trying to say in that? What was the mental health crisis that you were referring to in the report?
You know, I think it just goes back to the word that you said. There was a detachment from reality. There was some delusional thinking, which obviously, led to the unfortunate events of that day.
You're familiar with the term malingering?
Yes.
Okay. And what does that mean to you?
Malingering is something that's like persistent or continuing.
Did you ever perceive any of what Mrs. Miller told you or the way that she was telling you? Did you ever determine that to be suspect or suspicious or an attempt to deceive you? Anything that was not genuine?
No.
Now, you talked about on direct interview 2, and you had said that Mrs. Miller seemed to be much more coherent than the other.
On the second one, yes.
Yes. All right. And Mrs. Miller did not change any of her facts from interview 1 to interview 2, but she did add some facts to interview 2, correct?
Correct.
And what Ruth added to you was that she was actually talking to God on August 23rd. So she was actually having a conversation with God.
Correct.
And she had elaborated to you that God, her words were, quote, he wanted us to do something, and that happened before midnight coming into the critical day.
Yes.
And she had told you, Captain, that she had been witness to miracles lately.
Yes.
Okay. Did you ask her to clarify what that meant and what miracles she may have observed?
You know, I recall having that conversation, but I don't recall what her response was.
As far as approximation of time, how long before the incident? When I use the word incident, I'm speaking of August 23rd, 2025. Do you know how long it was before that she was witnessing these miracles?
I don't.
And in fact, not only did Mrs. Miller talk about Marcus and the fish, but she also added during the second interview that God had asked her to get swallowed by a fish.
She did.
And did you have her give you any further detail on that, or were you at this point just noting what she was saying?
So I was noting what she was saying. She did explain in this particular instance that God had asked her to be swallowed by a fish, that she, again, had some hesitation, did not want that to happen, made a statement that if God wanted her to, that she would.
Right. So she actually was willing, as she told you, she was actually willing if God wanted her to be swallowed by a fish.
Yes.
And there was nothing about that you took as her being trying to be dishonest or just disingenuous in any way?
No.
As far as physically is concerned, well, I can't say necessarily physically. The question that I have for you is, Mrs. Miller had also described to you that her head had hurt and was full of water. Do you remember that?
Yes.
Okay. Can you tell us about that statement, please?
She had made that statement after talking about the test that God was giving she and Marcus on the dock, and after they had been in the water, that's when she had said that after they had removed themselves from the water and were walking back to the camper, that's when her head was full of water and her head hurt.
Now, during your act, you had talked about the child coming back up above the water.
Yeah.
And was there any sort of discussion about Ruth trying to reach out to the child?
So the first conversation she spoke of looking at him, being questioned by God, turning and walking away. The second conversation, she said that she attempted to reach down for Vincent and could not, so turned and walked away.
All right, so do you know, did you ask her, did she tell you what the reason was to reach out to Vincent?
No.
Okay, so as to whether or not it was to bring Vincent in or to make sure that Vincent was actually going to God, we don't know today.
Correct.
Now, you talked about the Lighthouse Bistro during your exam. There actually was a little more to the Lighthouse Bistro because, tell me if you recall this, Mrs. Miller had stated that she was going to the Lighthouse Bistro to find Marcus and Vincent, correct?
Yeah, I believe I spoke on that too. She had recalled, or she had said that God had spoken to her and told her that that's where she would find them.
And do you know when that was and whether that was before she had taken Vincent from the campground or whether it was after he was in the lake?
My perception throughout the conversation was that after he was in the lake.
Okay. So after he was in the lake, she reported to you that she went to the Lighthouse Bistro to get Vincent and Marcus.
Yes.
And again, you had no basis to question this is being deceitful, this may have been her reality.
Correct.
Now, you're the person who had to tell Mrs. Miller that law enforcement had found Vincent Miller, correct?
Yes.
And her response to you was simply just good, correct?
Yes.
And then she asked if he was okay, didn't she?
She did.
So as to imply that she didn't know whether he was alive or dead.
Sure.
But then she did question or relay to you, she questioned you whether he was with God.
She did.
All right, so as I wrap up with just the last couple of questions, would it be fair, Captain, to say that everything that Ruth Miller had told you during your interviews of her appeared to be truthful to you, correct?
Yes.
And you don't know, and it's someone else is going to make assessments later. Or I should ask you, do you have enough information as a result of your investigation to determine whether or not Ruth Miller suffered from a severe mental disease on August 23rd?
I do not. No.
And so, based upon your investigation, do you have enough evidence to form an opinion as to whether or not Ruth Miller could appreciate the wrongfulness of conduct on August 23rd?
Objection. Response.
It's based upon the investigation and going right to the mental state, and this is the question. Those are the two questions.
I'm allowed to give what I would call lay opinions. Someone says something, this struck me as odd or seemed kind of unusual. That goes to the very heart of whether someone is insane or not. Clearly, this witness is not qualified to make that decision, and I'm going to sustain the objection.
Thank you. And my final question, may I ask if there has been anything gathered by way of evidence in the investigation touching on that question? That's all.
Whether he's gathered information?
Whether there's been any information from anyone or any sources who have discussed the issue of whether or not she could appreciate the wrongfulness of conduct. That's all. Not what we've done.
No, not for me specifically.
Thank you very much for your time.
Reread. Thanks, Your Honor. So when you were asked, Detective, whether you agreed with the sheriff's statement that she was delusional, would you say she seemed delusional?
I would say she seemed delusional.
Okay. You're not offering expert opinion as to whether, in fact, she was, are you?
No, I'm not offering expert opinion.
Okay. And when you say, do you agree that she was truthful with regard to her concern for Marcus and her account of that, would you say she seemed truthful?
Yes, sir.
There's no question that she was making a lot of irrational, bizarre statements as to the whereabouts of her husband and her son, and how that came to be.
Correct, there was no question.
Okay. Whether she honestly believed those statements or not, do you think that has any impact on whether we can be assured that she wouldn't have a mental break again?
No, I don't think there's any assurance that a mental break would not occur again.
Okay. Thank you.
Your Honor, I have a brief question based on that very last question. Thank you. Captain, when Mrs. Miller was at Cleveland Clinic, well, you had formulated an opinion before about how she's doing here, and you said she's a model prisoner. You were just asked now if there's any assurances that she would have another break. How did she do when she was at the Cleveland Clinic?
I don't know that I can answer that respectfully. I think that information is in the medical records, but I don't know that I can answer that.
Okay, fair. Thank you.
And so I understand, you did not intend to call any further witnesses, is that correct?
That is correct. I have two exhibits I would offer to the court. They are on a class drive. She's willing to label that for identification at this point.
Call the drive exhibit A?
Okay.
And you said on it, is it the video you showed?
Two body cam footage files from Kate Neville's.
Any objection to that?
No objection.
And with that, Ian, you have at least a witness that you're going to call, if not more.
We have one witness, the sheriff.
All right. We are going to take a break then. Just 10 minutes. You need to stretch, you use the restroom, gives you an opportunity, and we'll
right. Well, while they take their little 10-minute break, I can fast forward. How about that? So this is the bond hearing. This is from September 29th. September 29th. So I'm going to fast forward until they come back from break. And just want to remind everybody, if you could take a moment and hit the like button, we would appreciate that. If you are not in chat and you can hear my voice, let's just take a moment and hit the like button for us. We're at 195 likes. Let's see if we can get up to 200 before they come back from their break. See if we can get up to 200. Can we get up to 200 likes? I know Super Ball is hoping everybody can get us up to 200 likes. We're up to 197. Oh, hold on. Here I am talking over then there. All right, here we go. Back on the record.
Miller was brought back into the courtroom. She is back at counsel table, and both her attorneys are present and seated at the counsel table as well. The state of Ohio is also back in the courtroom, and we are ready to proceed with our next witness. And just to confirm, Ryan, you had essentially rested your case as it relates to this motion, correct? Correct. Okay. The exhibit was admitted. I don't have the exhibit. I think they was working on getting a label on it. Is it still being utilized, Ian? No. Just to make sure. Hold on to that. You may be seated. There's some type of technology is going to be utilized for sure. No. Okay, I wasn't sure. Are we using? All right, I was swearing a witness. Please raise your hand. If you are there or affirm testimony you're about to give in this matter, the whole truth and nothing but the truth. So please indicate by stating I swear or affirm. Excellent.
Thank you, Sheriff Campbell, for being here. My questions today relate obviously to the matters versus Ruth Miller, present here in the courtroom. And Sheriff, if at any time my questions are not clear, you need me to clarify anything, just ask me to stop and repeat the question. I'll do that, okay? Yes, sir. Now, you are obviously a very experienced law enforcement official as it relates to case investigation, correct?
Okay. I mean, I've been doing it a long time.
And so let's talk about that. How long have you been a law enforcement officer?
I started with the sheriff's office in '93, so this is my 37th year.
And were you anywhere before the sheriff's office, or did you go directly begin your career with the sheriff's office?
I was a juvenile probation officer, one floor down, from the age of 18 until 21. So I worked at, then when I turned 21, I was hired by the sheriff.
Sheriff Campbell, can you tell me what sort of training you have with defendants who may suffer from mental health issues, crises, or interventions?
So most of our guys have gone through what's called crisis intervention training. Most of the training for law enforcement is more centered around trying to de-escalate someone when they're in any type of crisis, or whether they're just acting angrily or hostile or irrational in any way. We attempt to employ methods to just get them to calm down. Don't have any formal training in mental health as far as diagnosis or anything like that.
Okay. But you've got 30 plus years of experience in law enforcement, so you deal with mental health crises, I'm assuming, many times.
Sure.
Now, can you please tell the court what your involvement in this investigation, the Ruth Miller matter, was? What did it entail?
Sure. So it was a Saturday morning. I was contacted at home by our dispatch center. and advised of what was going on up at Atwood Lake. I was told the Rangers were handling it, but they just wanted me to be aware that there was a situation in which it was, at that point, very confusing, but that it reported that a child maybe had been put in the lake, and that there was also a husband missing. I made contact with, one of the Rangers, just telephone contact, and did that by calling one of my deputies on scene, Caden Edwards, asked him to put me in contact with the Ranger, and just offered him any type of help that they needed. At that point, there was a time later, I received another call from Caden Edwards, and he had told me that Ms. Miller had been taken to the hospital, and that we were in fact being requested to assist them because they had still not had any luck in finding the missing child or the husband. So I then asked the dispatch center to contact our detectives, and specifically spoke to Captain Fisher and asked him to respond. And then before he responded, I actually redirected him and asked him to go to Union Hospital to speak to Ruth, just trying to figure this thing out.
Did you take any witness statements in this case?
I did talk to a couple of people at the scene. I never spoke to Ruth. I spoke to some individuals. There was a man named Marcus Raber that had spoke to us on Sunday morning and indicated that he had seen Ruth's husband at the dock alone at 6:30. And then there were some other people that were just giving us facts after the fact, such as Chad Engstrom, who had reported that the Millers had approached him and asked him to give him a ride to the dock on Friday night, Saturday morning at after 1 in the morning. And then some other people that had witnessed the incident in which the golf cart went into the lake. I spoke to those people as well on Saturday, just trying to gather information as to what they saw and what was going on.
Okay. And as the Tuscarawas County Sheriff, were your deputies and or other representatives of the Sheriff's Department who may have been involved with this investigation, were they reporting to you what they were doing and what their findings were?
Yes.
And so would you say that you had a good understanding of the investigation as it was proceeding?
Yeah, so the debriefs when a case like this is ongoing, we don't have the time to sit down and debrief about the entire length of a conversation, but we do get the main points out, what somebody was able to offer, and then, we try to take those facts and formulate a plan on to what to do next.
Now, that was August 23rd, 2025, incident at Atwood Lake. Do you remember the date that you gave a press conference about this case?
Yeah, I think it was the very next Monday, so the 25th.
Okay. And at that press conference, you addressed a number of issues, the status of the investigation, and then also conveyed your beliefs and impressions of the matter, correct?
Sure, yes.
And do you recall what you said during that press conference?
I said a lot, but I tried to report, this investigation was different from many. It took place in a very public place. Atwood Lake was extremely busy that weekend, and there was a car show going on and lots of people coming up, and there was already media coverage. We had, as we were trying to recover the bodies, we had drones flying above us and different things like that. So I felt it was important, and trying to respond to the media, the numerous calls and emails that we were getting to just set up one press conference. During that, I tried to be as open and honest as I could about how difficult it was for us to piece together what took place that day. The facts came in, you'd hear one statement that, Ms. Miller had supposedly told one of the people on scene, and now it seems like they make a little more sense because we put a bigger picture together, but at that time, it just seemed very confusing as to what took place. I was trying to explain that at the beginning of the investigation, I think I never really spoke to the other investigators about this, but I really think most of us were hoping that the little boy and the husband were still okay in the park. And then later on, that as the hours went on, we started to lose hope for that. And then, of course, once we recovered Vincen's body, all over that went to the side. So I tried to explain everything as to why it was so difficult for us to give an exact update as to what took place, because we were still piecing together statement fragments.
Is there anything about what you said at that press conference that you disagree with today or was said differently?
I'm not sure I remember everything that I said, so I'm not sure I can answer that. If there's...
I can be specific.
Okay.
If that would help.
Sure.
You had talked about, based upon the investigation, you had opined that Mrs. Miller was suffering mental health issues.
Yeah, I think I'm usually very careful about that because I can't diagnose these, but I think I used the term mental health crisis.
And you alluded to the fact that she may have been suffering from spiritual or religious attachment or delusions.
Delusion. I think I used the word delusion.
And if you can please explain to us what that meant, what you meant by that.
Okay. So when I think of somebody who's operating delusion, I think of somebody who's just not operating within the facts, just operating off of, a belief that couldn't be factual. And it was very difficult for me, from the things that I'd learned, to think that the story that was being presented was factual. So I was calling it a delusion. I used the term spiritual because she kept stating that she was, to our investigators, to the Atwood Lake watershed investigators, that she was following, comments from God. So I stuck in the word spiritual, but basically I just meant that she was, I believed that she was making comments that suggested she was not operating with a factual command of what took place.
That's right. And Sheriff, that would be different than just someone who, you've had plenty of people over the course of your career under investigation lie to you, right?
Yes.
All right. That's not delusional, that's just lying.
Right.
Okay, so we're not talking about someone necessarily being dishonest, we're talking about someone whose mental capacity may be affected.
Could be, yes.
Now, you had interviewed family and a religious leader, particularly Robert Miller, Marcus's brother.
Yes, I did speak to Robert that day at the Atwood Welcome Center. I also briefly spoke to the teenage children.
And just to go through this as quickly as possible, you were told by Marcus's brother that Ruth had been suffering from mental illness and delusions for approximately 6 months, correct?
That is what I remember. He told me that they had become concerned with her thought process, yes.
And the family did have overall concerns as to Ruth's mental well-being, correct?
Yes.
And they also had concerns over Marcus, just in the days preceding Atwood Lake, calling family members in an unusual manner to tell them that he loved them, right?
Right. I remember specifically that Robert stated that Marcus called him to just tell him he loved him, and Marcus found that as extremely odd because their love was known. It wasn't something that was ever questioned, nor did they ever feel the need to call each other just to say that. And that was a bit of a red flag to him that there was something wrong.
Okay. And did Marcus have concerns, according to your investigation, or did you know in your investigation that Marcus had concerns about how long he would live?
About how long Marcus would live?
Yeah, how long he would have to live.
I seem to remember that, and I don't remember exactly who told me that, that I was told that Marcus had made comments that he might not be around for much longer, something like that. I don't remember the exact comment, but yes.
And if we heard in this courtroom earlier today that there's no belief that Ruth Miller had anything to do with Marcus Miller's death, would you agree or disagree with that?
I assume we mean, I'm not trying to, but I assume we mean physically, right? Like she didn't physically cause his death. Is that what you mean?
I'll ask it that way first.
Okay.
Appreciate you asking for the clarification. Yes.
Physically, no. I think that we were able to come to the conclusion after interviewing a witness on Sunday morning that we saw that Marcus Miller was seen at the docks alone about 6:30 in the morning, Saturday morning. I think at that point we began to believe that whatever action was taken, we noted that his clothes were on his boat, that we had assumed that whatever action he took himself.
And again, thank you for asking me to clarify. By inference, are you suggesting that she played a part in it in some mental or psychological way?
No, I don't mean to infer it. I just don't know what happened there. Two people ending up with some sort of, belief that leads them to these extreme actions. I just couldn't answer to the psychological part. I wanted to avoid that. Not infer anything, but definitely not answer for it either.
As a result of your investigation and kind of the entire investigation as you know it, can you point to any instances where Ruth Miller may have been potentially deceptive with you or intended to deceive or hinder the investigation in any way?
The only thing I can point to is that while it was not with me, I'm told that she fled from the Rangers for a short time, approximately a half an hour.
And do you know why she did that?
I do not.
Now, you had noted in your investigation that there was a family intervention prior to going to Atwood Lake, correct?
Yes, I learned that from Robert.
And it was described to you and noted by you that Ruth and Marcus seemed irrational and, quote, wild-eyed.
That is what I took from that conversation with Robert Miller, yes.
And Ruth, there was concern because Ruth was really obsessing about things, religion and so forth. But one of the things that they made note of was her focus on the importance of the number 40, right?
Yes.
Okay. And she talked about its importance in the Bible, right? The number 40?
That's what Robert told me. I mean, this whole line of question here is coming from Robert.
Correct. Okay. But this is what you noted as a result of your diet.
She had begun to obsess about the number 40, and she was turning 40 and the importance of that number in the Bible.
And the family was very concerned by this, correct?
Yes.
And did you learn at any point that Atwood Lake, the trip to Atwood Lake came at the last minute, but that originally there was a trip planned to go to Columbus for Ruth's 40th birthday?
I'm unaware. Okay. I don't recall hearing that.
Did you talk to Miss Miller's family or anyone that she knows about her sleep patterns leading up to Atwood Lake?
Miss Miller's family?
Yes, or anyone about how she may have been affected by lack of sleep?
No.
Okay. Was that an issue that was ever raised or ever came to your attention at any point?
The only time I can recall sleep entering into my mind was the night of the incident. It was reported to us that from her statements that she and her husband had gone out onto the lake to do some swimming tasks. We know they went out there shortly after 1 a.m. because they spoke to the neighboring camper. I can't say for how long exactly they were out there doing the swimming tasks, but then they walked all the way back to their camper. And then Mr. Miller then supposedly went back on his own, was seen alone. That tells me at least that night that they hadn't slept. I believe that Rob had also mentioned to me that potentially the night before that there was some level of concern and that they may not have slept out that night as well. But the night mostly that tells me they were not getting any sleep was that Friday night into Saturday morning.
And you had also learned that prior to Atwood, the church was considering getting Ruth mental health unit or counseling.
That is what Robert told me, yes.
Okay. And did you get any further meaning or intent on that?
No, specifically what Robert described to me was they had my word is an intervention, that they had a meeting, to try to explain to Ruth and Marcus that these Bible verses that they were interpreting were being interpreted correctly, that they were able to de-escalate them, that their whole demeanor changed, that they kind of calmed down and lost that wild eye, that was his terminology, that wild-eyed look, and he felt like he bought some time, like maybe they realized that the way they were thinking was not correct. Robert had told me that he felt that they knew they were not all the way out of the woods and that they would need to pursue some sort of ongoing help for Ruth.
You also spoke with Bishop Vincen Miller. Does that ring a bell?
I'm not sure if I ever did or not. I had another detective assigned to the bishop who we try to keep people having consistent contact so that they develop some rapport. I may have met him the first day, Saturday at the Atwood Lake Center. If I spoke to him, it was very brief. I remember meeting Robert. I remember meeting grandparents, and I'm not sure if I met the bishop or not.
Okay, and I could be wrong about that. Okay. Like piecing together the report, so thank you for letting me know that. Were you made aware that there may have been a history of mental health illness in Ruth's family, particularly father?
No.
And I'm thinking you're talking about another decade. Okay. Did you receive any information about the prior treatment that Ruth was undergoing for mental health?
No.
Sheriff, we know that Ruth was hospitalized after her arrest. You were aware of that, obviously.
Yes.
All right. And were you made aware by anyone in your department or from the hospital that she posed any problem or risk of harm while in the hospital setting?
No.
And as far as you know, were there any behavioral issues while Ruth was in the hospital? Behavioral meaning, let me be clear on that as I think about things. Any disruptive behavior by Ruth Miller?
No, I remember being told that she was singing loudly in the hospital, and outside of that, I don't recall really hearing about any behavior.
And while in your jail, would it be fair to describe her as somewhat of a model inmate?
Sure, she's been quiet and created no problems in that Tuscaloosa County jail.
And do you know if that was any different from her behavior at the Cleveland Clinic?
I did not. Honestly, I never spoke with any staff, and the hospitals they don't give us a lot of information anyway. Truthfully, they're pretty protective of patients' rights.
Now, as part of the investigation in this case, did you ever get any information as to Ms. Miller's character prior to August 23rd, 2025?
No, I think Robert had made a comment that, she had been a good family member and wife and mother up until several months ago when they felt she started to have problems. And I don't recall ever having a discussion with anyone else about her past.
And you had spoken to some of the family members. Is there anything, if I were to suggest to you that Ms. Miller's family ties in the region are strong, would you have any basis to refute that or contest that?
No.
And with the background that your department did, is it fair to say that she's lived in this area her entire life, kind of in the region?
I'm not sure we did that type of background. I do know that she has lived in the Holmes County area for quite some time, and that the family's well established there with the business.
And there was no evidence in this case or at all of any drug or alcohol abuse or use, correct?
I was not made aware of any.
Okay. And as far as you know, all of her past conduct, that predating August 23rd, 2025, that conduct could only be characterized as stellar or a contributing member of the community.
Prior to that, maybe that 6-month period, and Robert was estimating, but he said 5-6 months is when her behavior changed. But prior to that, he described her as, being a very stable person.
Did he describe how her conduct changed?
I'm using my words. The information I received made me believe that she was becoming paranoid in her interpretations of the Bible and the type of person she was. That's really the only type of description he gave me, was these, what he classified and I classified as misinterpretations of Bible verses.
To go back to the quick questions, we know that there's no criminal history, so we know that prior to August 23rd, 2025, she was not under any court supervision or probation or anything of that sort.
I'm unaware of anything previously. I think she's got no criminal record.
Let's suppose for the moment that her experience at the Cleveland Clinic could be replicated. Okay? Same treatment, same place, same providers. Do you have any reason to believe that would somehow be inadequate now?
Again, not attempting to be difficult, but that's a type of question I've become very uncomfortable giving an answer to. I don't even know what her condition is. I know she was up there for a short time and then released. That's about all I know.
You are aware, though, and I appreciate your response. You are aware, though, that she was at least treated for critical mental illness at the time. And critical is my word, and that just means critical in time.
I'm aware that she was treated. I know we picked her up from there. I know when she went there. As a matter of fact, the day she went there was the day of the press conference. It's when she was transferred, and I'm aware of when we went to pick her up. And I do know that when she was in there, it was a locked, treated facility, and that's really all I know.
Okay. But you don't know what sort of treatment regimen she was getting?
I do not.
Okay. What sort of treatment, mental health treatment, is she getting while in your job?
We have a couple of full-time people that work there. One is called a reentry coordinator, and one is a counselor, and they would talk to her if need be. I know they have talked to her, although I don't truthfully know the topic, and I believe she's on some medication.
All right, and she's doing fine here. Is she getting better care at your facility than she would at the Cleveland Clinic, or do you not know?
I do not know.
Sheriff, thank you for your time today.
Thank you. Sheriff, you were asked some questions about what Ruth's brother-in-law, Robert, had told you about a family intervention they had the morning before this happened. I'm sorry, the morning before they left for Atwood. Is that right?
Okay, yes.
Okay. Did Robert make it clear to you that they felt that that it was somewhat beneficial and that he did not foresee any self-harm or harm to others from Ruth or Marcus? Did he make that clear to you?
He did. Somewhat beneficial is probably a good phrase. He thought they made some headway. He felt they still had work to do. He told me that they even questioned whether or not they should have allowed them to go to Atwood, but they felt that the little vacation away would be good. That, Marcus worked a lot and was under stress, and they felt it might be a good respite.
Okay. But they didn't anticipate anything like this would happen?
Oh, certainly not.
Okay.
I had asked him specifically if, in her misinterpretations, did she ever say anything that would make them think that she had to offer up a child, or, and he said absolutely not. They would have intervened immediately had there been anything like that.
And on that morning of the 23rd, in terms of her statements, she seemed very unstable and irrational that morning. Do you know anything based on the investigation that could give this court some reasonable assurance that she would not destabilize again or have a mental break again?
I certainly couldn't comment on that. Clearly she's sitting here and she's well behaved now. And I don't know what took place to cause the incident to occur, so I'm not sure what I could say to assure anyone that it wouldn't take place again in the future.
Okay. Thank you. No further questions?
No further questions. Thank you, Sheriff.
Thank you.
We do not have any further witnesses, Your Honor.
Brian, this is the state's burden in this case. I'll allow if you have any type of closing argument, closing summation as it relates to the issue of bail.
Okay. Thank you. Beforehand, could I have a brief moment with one of the family members?
Sure. Brian, before you proceed, just so for everyone's benefit, what I intend to do is decide the issue of whether the state is correct that there should be no bail. If I ultimately disagree with the state's request for no bail, the issue of what is the appropriate bail then is still an issue. In your statements, if you could address both of those issues, I would appreciate it.
Okay, thank you, Your Honor. Under the statute that authorizes this court to deny bail in certain circumstances, and this would be one of those circumstances where a defendant is charged with aggravated murder. The main focus is on the safety of the community. In the context of the standard that you articulated earlier, that is, the state has the burden of proving by clear and convincing evidence that the proof is evident or the presumption great that Ruth Miller committed the crime of purposely killing Vincen Miller, her 4-year-old son. That she is a substantial risk of causing serious physical harm either to herself or others, and that no release conditions would reasonably assure this court of the safety of herself or others. And so, Your Honor, I began by saying this is not a whodunit, or even what did she do. This is a mother who had struggled with some stressors in her life, some mental health issues, reportedly, such that it had concerned her family and her church, and they had some intervention the morning before they left for Atwood, and felt that they had gained some headway, that it was somewhat beneficial, that it would be good for them to get away and decompress, and certainly had no idea that something like this would happen. It seems very clear that also they had a good day on the boat Friday, but that Friday night, when the kids were in bed in the camper, Ruth and her husband felt some inspiration to go out to the dock and do some tests of their faith, and they did that. And then later in the morning, they came back to the camper, that she reports that Marcus left again on his own volition to swim to the sandbar and never came back, is what she, and that was the last time she saw him, is what she said. She ends up going out to the pontoon. She says that she witnesses his clothes left on the pontoon. The same clothes that responding officers also saw on the pontoon. And the same clothes that Marcus Raber said at approximately 6:30 a.m. he saw Marcus Miller wearing when he confused him to be Bobby Miller. But when Ruth went out there, her husband was not there, is her report, and that she began to spiral. And she went back and she got her son Vincen, and she took him to the dock. And she's very clear in her statements to Adam Fisher at the hospital as to what she did. It may have been somewhat vague in the field to the initial responders, that I threw him in, that I gave him to God, but she was very clear with Adam at the hospital. And that is, she said that she felt she should throw him in the water, that she threw him in, that he came back up to the surface and looked at her, and that she questioned whether she should be doing this. And her statement to Adam at the hospital was that she felt that God was telling her to walk away, and she turned around and walked away. Now, then she went back and got her other children and brought them out, then performed some tests. That they were praying intently near the kayak dock, that they got into the golf cart and then raced down to the bistro and over the rock embankment and into the water. And that's when the 911 call came, and that's when we get involved. At the scene of where she wrecked the golf cart, it's very clear that she was uttering many things, such as her husband and son are in the water, that she gave them to God, and it was concerning. The Rangers directed her to show them where that was, and she began with the children to walk away from that area. But quickly that accelerated into a dead sprint, according to the ranger. And they essentially got away from the Rangers and the one deputy who had responded. And Ruth was missing for nearly 30 minutes and found eventually lying face down in high weeds. And when she is recovered, she continues to talk about these irrational thoughts about that she was doing the will of God, that she had given her husband and her child to God, that she threw her child off the dock, is what she said in her excited utterances when she was recovered from hiding or from lying down in high grass. But it's interesting that she's missing for a half hour, that she's has a lot to say to bystanders and to initial responders right after the crash, that she has a lot to say to initial responders and bystanders when she's recovered from the high weeds, but she's remarkably quiet and undetected for 30 minutes until she is found. There's no question who done it and what she did. And the defense has made some remark of whether she committed the act, as that word is construed in the law. I would urge the court to take into consideration the law as it relates to natural consequences. And juries are instructed on this in many cases. A defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant is responsible for the natural and foreseeable consequences that follow in the ordinary course of events from acts or failure to act. So her act was to throw her son off the dock, her 4-year-old son, who couldn't swim well if he could swim at all. That was an act, and there's a natural consequence to that act. Whether she was delusional or whether she was malingering, at this point it really doesn't matter. That will be determined later at another juncture, I presume, when we determine competency and sanity. But for purposes of this hearing, it doesn't matter whether she was honestly delusional or whether she was malingering. The natural consequences of throwing a 4-year-old into the water is that he'll drown if not saved. And then when he resurfaces and he looks at her, and then she decides, for whatever reason, to walk away, the natural consequence is that she acted, and she had an omission as well, that caused his death. And the natural consequence is that that's her purpose. She's imputed with that purpose. So that's why I say this is not a whodunit. I think the proof is overwhelming whodunit and what she did. The real question is whether there are any release conditions, if you were to release her into the community, that could assure this court that she's not a risk of serious physical harm to herself or others. Now, we have just received both the defense and the state medical records from Cleveland Clinic Hospital. And you've not heard anyone testify from Cleveland Clinic that they can assure you that there are some measures that can be put in place that would safeguard not only Ruth, but her family members and the community. You've not heard that. That's not on the record. In fact, I think I can say that the records are fairly voluminous at both Union and Marymount, that she said a lot of things to a lot of hospital personnel, a lot of things consistent with what's been said here today and what she said to investigators and even more. That while she was in hospital care, she was generally regarded as polite and compliant, if not pleasant at times. And that she expressed that she couldn't believe what she did. At one point she said, the devil got to me in the moment. So, but again, for the God made her do it, whether the devil made her do it, whether she's faking it, or whether she's honestly delusional. For purposes of today, it doesn't matter. What matters is there's nothing that can assure this court that she's not going to have some break again based on whatever, based on a lack of sleep, based on misinterpretations of the Bible, based on something beyond what we're even discussing here today. It doesn't matter. What matters is, can she give some assurance to the court that this isn't going to happen again? And, Your Honor, given the gravity of what happened here, there is no ankle monitor that's going to assure the court that she is not a harm to herself or her family members. And there's no secured facilities besides the jail and besides some state hospital that either competency or sanity might dictate that she has to go to. But that's a procedure for another day. Short of a state hospital to be determined another day, or the jail facility, there's nothing that can assure us that she will be safe in our community, to herself, her children, or others. And so, Your Honor, getting into issues of why she did this, I think gets beside the point. The point is that she did it. What she did was horrible. And if it can ever be determined by forensic psychologists and by finders of fact in this court why she did it, that will be an issue for another day. At this point, Your Honor, I would urge the court to deny bail because no reasonable assurance can be given to this court that she can be safe to herself or others in this community. Now, one thing that the no bail statute doesn't address, but that just general considerations of bail does address, is flight risk as well. So, Your Honor, if you were to set a reasonable bail, I would urge the court to set a very high cash bail, at least $1 million bail. Because in conversations with the family, they have resources, and they could make a moderately high bail. They might make a high bail. And I would say this. She has 3 surviving children who love her. And who want to be with her. I don't believe she could provide any assurance to this court that she could not just leave the jurisdiction of the court, especially given the high stress that she's under at this point. And just really disappear into obscurity. Yes, she has ties to this community, but we don't know where she might have extended family. So I think that Your Honor can reasonably take into consideration risk of flight. And I would also say this, that I want to be a little measured here, but for teenage children, okay, there is a counselor involved with them, with at least some of them. And without the input of a counselor as to a good plan for having some kind of contact, I think the most prudent course is for the court to order no contact with the surviving victims here until further order of the court, and mainly until some mental health therapist who is familiar with the situation can endorse such a track or such a plan. So, first request, Your Honor, is that you deny bail. That whatever made her did it, her stressors are even higher now, and she can, being under indictment for this, and she cannot give any reasonable assurance to the court, and there's not been made any, through testimony, any articulation of a reasonable assurance that she'll not be a harm to herself or others. Therefore, Your Honor, I'd ask that you deny bail, that you order no contact with the surviving victims, and in the alternative, a very high cash bail. Okay, thank you. You have your time.
Thank you. Thank you, Your Honor, for allowing us to explore the issues here today thoroughly. I would submit that if there were not instances where someone was charged with murder, if all people who are charged with murder, aggravated murder, should be held, then the statute would say shall. It's the fact that the shall provision, which we find so spread through all of our rules, but the fact that shall is not there means that there are instances where people commit these offenses where they still should get a bail. And as tragic as this is, today showed us that there were really circumstances here that point to the fact that we're not dealing with a cold-blooded murderer who poses a threat to those around her. And this would not have occurred, certainly, Your Honor, what we hear today is most likely. And I agree with the prosecutor that there will be further evaluations and so forth. But I think it's a safe statement to make that this would not have happened but for significant mental health issues. What they were, that'll be detailed on another day. But the fact that they existed, everyone, even in their career-based experience, felt that there were mental health issues present. And so the questions that arise when I look at Revised Code Section 2937.222, again, I hone in on the word committed. And I'm not going to get into you understand why I said that before. But I bring in all of the facts that we heard today about all of the mental health ailment, whatever the word may be, that's my word, which was undergoing. So where best to treat that? Would be at a facility that treats mental health illness. And I totally agree with the prosecutor that there's been no evidence to suggest that how she acted at the hospital. We heard about what was heard and so forth. But the burden being on the state is that they had to show that there is no other reason. Not that it had to be shown that there were alternatives, but it had to be shown by clear, convincing evidence that there were no release conditions that would reasonably assure the safety of that person in the community. There is nothing to state that she did not do well at the Cleveland Clinic. There's nothing to state that at all. That burden rests with the state to show that it did. She never posed a risk before. By all accounts, this was an isolated incident that came as a result of what was going on in her mind. I think to say that there are no release conditions, I think that's a little too far. Because she did do fine. There's nothing to suggest she didn't at the Cleveland Clinic. She's doing fine now. And so when she's getting the care, when she's getting the regimen, when she's getting medication, and if she were able to get the care of mental health professionals to the level that she's going to need. Because we're talking about conduct that quite likely constitutes that of not guilty by reason of insanity. And with all due respect, the jails in Ohio and throughout this country don't have the resources to treat that level of illness. The facilities do. So you would ask, Your Honor, what do we suggest? I don't suggest that Ruth be just released back to the public. I do not suggest that an ankle monitor is sufficient. I don't believe it is until Your Honor is supplied with additional information. That information would come from an inpatient facility, and an inpatient facility could include institutions like going back to, well, actually, what I'd like to do, Your Honor, is give you the general what we're seeking, and if the court is amenable to it, what I would ask to do is to notify the court under seal of exactly the places that she would go. It just makes more sense, because part of this is also, once it's determined appropriate by the inpatient treatment, and that's after they have substantiated medication and the counseling, that should be stepped down only by court order to release with home arrest, not just GPS monitoring. And also that in combination with outpatient treatment continue. So what this looks like, again, because I did say that rather confusingly, is going to inpatient treatment, whether that be the clinic, Recreate Ohio, Highland Springs, Sunrise Vista Behavioral, that can be done with an ankle monitor, if that needs to be. And then if there comes a point where the hospital says that she is stable, that she does not pose a threat, and we have the battery of documentation to support that, we would come back to the court to ask for movement from there to address with family members. Again, I'll disclose that the court right now, where I consider that put it under seal, but locally family members with house arrest and with continued outpatient treatment. As to the bond, I understand the magnitude of this offense. I would not be asking for a $100,000 bond or a $250,000 bond. Of course, I'm not going to join in a request for a high bond, but I also recognize that to have some semblance of credibility, I also have to be realistic and not suggest that a low bond is appropriate either. So what that does is that then vests the family, who she clearly cares about, and they clearly care about her. If they are invested in this, this is just another incentive for her to be present. And prosecutors are correct, we do have to look at the general principles of bond to protect the community. There were no, other than this, when there was a break that has been described as delusional and detached, there has been no other instance of any sort of misconduct or certainly violent behavior. The community would be protected in the supervisory role of an inpatient facility where she would stay unless and until Your Honor would have determined that she was an appropriate candidate for the home release with the monitoring. As far as the appearance is concerned, there's nothing to suggest that she would flee. The discussion of her running for 30 minutes, that was addressed 3 times today with the ranger and then both the sheriff and the captain. No one understood why she was running. This may very well have been nothing more than a continuation of her role in the delusion that she was living in at that time. And I had asked specifically of the ranger first, was she praying? Was she going to go to heaven? Nobody knows that. So it therefore should not be used against her as some evidence that she's going to pose a risk of flight. Certainly not with the precautions that we could put in place as far as monitoring and so forth. This is a really, just as all cases are, but this is a really important case where there needs to be constant communication between
client visits and something more than what can be done just by phone, even though I fully recognize that the court is giving private phones and so forth. But in our experience, Your Honor, one-on-one visits are critical. To have her at a place that's closer to where counsel is would be exceptionally helpful. And that would be a place that is safe for her and safe for others. So for all those reasons, Your Honor, given the outline, I would give the specific destinations upon request of Your Honor, put that in writing and proceed. Thank you.
I want to direct my comments to you. Been here 1 o'clock, almost 5 now. Heard a lot of evidence, sensed the tension in the room, cameras and people that are here. This is not your trial. It looks and it feels a lot like it's supposed to be a trial, but it's really just about the issue of whether or not bail is going to be denied to you in this case. And I am confined to a specific law in Ohio that specifically deals with this issue. And it's worth reiterating those factors that I mentioned earlier to you, because I have something I want to add to each one of those. The first consideration is whether or not the proof is evident or the presumption is great that the accused committed the offense with which the accused is charged. Now, I am to consider what you have been accused of in the indictment. That's what I reviewed with you at the time of the arraignment. And there's 7 different charges in the arraignment, but only a few of them really pertain to this statute. And we've heard the term aggravated murder thrown about a few different times in here, but that's not the only charge against you that could prompt you to be held without bail. It's the highest charge, but it's not the only charge that could trigger this. You have been charged with count 3, felonious assault. And that's a felony of the 2nd degree that could have prompted you to be held without bail as well. It's part of count 2, really, though, because count 2, which I'm going to direct my attention to, is the offense of murder. And in this form of murder that you are charged with, it alleges that on the date of August the 23rd, 2025, that you unlawfully did cause the death. And it says here, child, and we know it's Vincent from the testimony that's here, as a proximate result of the offender committing that offense of felonious assault. So essentially the state's saying, by committing felonious assault, he causes murder because he died as a result of that felonious assault. And there's different ways that people can be charged with felonious assault. The state is saying in this case that you knowingly caused serious physical harm to Vincent. Ruth, I'm not trying to make it more drama than is necessary. I'm just trying to go through and make it clear to you as to what my thinking is at this point. And that is, I am concluding that the state has presented clear and convincing evidence that the evidence, the proof is evident or the presumption is great that you committed the offense of murder at a minimum and felonious assault as a minimum, as you have been charged in the indictment. It's not lost on me that your attorney makes a good point, and that is when he talks about that issue of whether or not you were committing the offense if you in fact were insane at the time, as it is defined in Ohio. We've heard a lot of people in here talking about religious delusions, mental crisis, healthcare issue, mental health issue at the time. The truth is, we've all heard a bunch of lay opinions, is all we've heard. And a lay opinion is somebody who's not an expert. There's been an order in this case for you to have an expert weigh in as to whether or not you were insane, just as your attorneys have asked me to do. And that will take place. But it's not going to be a detective. It's not going to be the county sheriff. It's going to be an expert in this area who will tell us whether or not, in fact, you were insane at that time. So as for the first bullet point, I believe the state has met that burden. The next point, the question is whether or not the accused poses a substantial risk of serious physical harm to any person or the community. I'm going to talk about number 3 at the same time. It goes into whether or not there are no release conditions that will reasonably assure the safety of that person and the community. I have to be convinced by clear and convincing evidence that that the state met their burden, that you do pose that substantial risk and that there are no release conditions. To get to that point, the legislature in Ohio, they didn't just leave it up to Mike Ernest to use your best judgment on it. They didn't do that. They said, you have to consider the following. There's 4 of them. They're kind of long, but I think it's worth going through them. Number 1, the nature and circumstances of the offense charged, whether the offense is an offense of violence or involves alcohol or drugs. There's no indication here that alcohol or drugs were involved, but there is also no dispute that murder and felonious assault are offenses of violence. The weight of the evidence, number 2, against the accused in this case. I'm going to conclude that the weight is significant against you in this matter, that in fact you carried out the offense of felonious assault and in this case, at least for today's purposes, murder. 3, the history and characteristics of the accused, including but not limited to the following. I'm to consider these, and I have. Your character, to the extent that I can, at a bail hearing. Character, physical and mental condition, family ties, employment, financial resources, length of residence in the community, your community ties, past conduct, history related to drugs and alcohol, and criminal history of the accused. I know of no criminal history. I don't know of any reason to believe you don't have a strong connection to the community. I've taken that into consideration. I've taken into consideration the fact that a lot of people, well, I should say a number of people who have testified here today, they would at a minimum have raised an eyebrow as to your mental condition on the date in question. I am also to consider whether at the time of the offense, whether or not you were under supervision of any point in time. You clearly were not being supervised by another court at that time. So I've considered it. Lastly, the nature and seriousness of the danger to any person or the community that would be posed by the person's release. Those apply to whether or not you pose a substantial risk of serious physical harm, whether the state has met that burden. And Ruth, in my assessment in this matter, I am coming to the conclusion that the state has presented clear and convincing evidence that you do pose a substantial risk of serious physical harm to any other person or the community, and that there are no release conditions that will reasonably assure the safety of that person and the community. And I'm going to tell you why. In this case, you were told, at least by the evidence that I've heard so far, that there were people in the community who had concerns. The bishop was concerned. Your family was concerned. They tried to intervene. They tried to have you listen to reason with them. And I think by clear and convincing evidence, you did not listen to the bishop. You did not listen to your family. And Ruth, I don't think you'd listen to me if I put conditions upon you in the community. You listened in this case to what you believed God was telling you to do based upon the testimony that I've heard to this point in time. And that does not leave me assured that you will follow my conditions. For that reason, I am going to deny bail in this case. I'm going to have you held in the Tuscarawas County Jail while this matter is pending. The statute, though, it does, and regardless, the issue of bail is one that could be reviewed. And I don't mean to plant any type of false hope that I would somehow change my mind and have a personal recognizance. That's not what I'm trying to do here. But really for the first time, at the end of this hearing, I heard for the first time that there may be a place that you could go to other than the Tuscarawas County Jail for which the community could be assured of the safety of others and that you would not pose that substantial risk of harm to others. And I'm open to that idea. I simply know nothing about that idea at this time other than it was floated at the very end of the hearing. So that's my ruling at this time. But as I do in any case, regardless if it's aggravated murder or a low-level felony, I believe the issue of bail is always open to review. And if there is a suggestion, if there's more than a suggestion, there's a plan in place that would give me that confidence that I don't have right now, I would consider it. If there's nothing further. The issue of the no contact one. I'm sorry, we are just going to have to agree to disagree on this issue. I know you've asked before, but my opinion is this. When someone is being held without bail and on aggravated murder, I only want to put an order in place that I believe I can enforce. And if she were to make phone calls from the jail, I feel as if there's nothing more I can do to her. She's already being held without bail, facing life in prison. So I don't know what teeth, I could put into it if someone doesn't listen to me. If someone, though, persists in calling from the jail and you believe they are in some way interfering with this case in some way, I would consider that placing an order with the jail to not allow phone calls to be made in general. But at this point in time, I just simply don't believe a no contact order when there is no bail is enforceable. Anything further?
There's two issues. Your Honor, please just note our objection for the record.
Noted.
Secondly, as far as transcripts are concerned, how would you like us to?
Direct that.
Perfect. Thank you very much. Have a good week.
Okay. Thank you.
Thanks, Judge.
Yeah, I think that was a wise decision. I'm surprised he didn't say pose a threat to yourself as well, because she could be so distraught and so just down the rabbit hole of wherever it is she is that she could pose a threat to herself as well. I mean, her and her husband Marcus, they did go into the water together, according to her at one point. She tried to walk on water, according to her at one point. So, all right. So that was a hearing. So now we're going to get to a couple news clips and then a pretrial hearing, and then we're going to get to her trial, and then finally there's a few things after that. I don't want to spoil it. Let's just pretend we're watching this as it unfolded. I don't want to give any spoilers. I do want to give an update on Rashad and Sean, though. I see you guys are, we were talking about that. So there's rumors floating around that Sean Gathright and Rashad Murphy have been stabbed. Now, they're in separate locations. Rashad is in more or less his forever home, but Sean is still in, he's still in intake. So they're not together. They're not together. So unless they got attacked in separate incidences, they were not in the same location, right? So Rashad is up in Walton, which is over by closer to Tallahassee, and I think Sean's around. I think Sean's in. He's more in Central. I think he's like in Orlando still. Aaron would know that better than me, but. So rumors going around that both Sean and Rashad got attacked. Haven't seen anything more than just on Instagram, Facebook. Few YouTube channels are reporting it. But again, as far as we know, they're in separate locations. From the documents that we've been able to ascertain and look at, they're in two separate, with Rashad being put in his forever home. Do you want to say something or no?
Well,
I'm
going to call.
Okay.
This.
Okay, Aaron.
It's like the same language is being used over and over again, so it's like kind of false.
Yeah.
You know, they're not in the same place. And another rumor was that Fulio's brother did this, but he's not even near either one of them. So it's just
okay.
too much.
Can you guys hear Aaron? No. Well, you just talked. I don't know. So yeah, they're in two separate locations. So again, unless this was separate incidences, again, we're going to look around. Chris, Sean Gathright and Rashad Murphy, they were part of the Charles Jones Julio Fulio trial that we covered. Julio Fulio was a drill rapper out of Jacksonville. He traveled to Tampa Bay for his birthday, and he got taken out by members of the other rival gang. So anyway, Florida PI Sam was representing Davion Murphy. She was part of the team that was representing Davion Murphy. So that's how we were connected to the case. So I wanted to give you guys, I think Stacy, you're the one that brought that to my attention. I Googled it and everybody's talking about it, but like no local news stations are talking about it. No large outlets are talking about it. It's all, content creators, Instagram, Facebook, that kind of stuff. So to me right now, it just seems like a rumor, but we'll keep our eye out for it. But they're in two separate places. And also Rashad is in I think it's called closed custody, which means he's being monitored for this very reason, so that he doesn't get in trouble. So to me right now, it seems like it's not, we haven't been able to verify it other than through social media. So to me right now, I would say until it's verified, it is what it is. So that is the update. So now let's get back to Ruth Miller. All right, so I've got a couple news clips here.
Has been deemed competent to stand trial for the murder of her 4-year-old son. Miller is accused of drowning him in Atwood Lake in Tuscarawas County back in August. She pleaded not guilty by reason of insanity in September and remains in jail without bond. Her trial is scheduled to begin in March.
All right, so that's just them confirming that she was deemed competent to stand trial. All right, now we're going to go to, here's another news clip of a pretrial hearing. Actually, this is a news clip, and then we'll show the pretrial hearing. So let's watch the news clip first, and then we'll check out the actual hearing. And then this is a pretrial hearing. We'll get to the actual hearing. So don't...
An Amish mother is accused...
Don't worry about that.
Is accused in the death of her 4-year-old son at Atwood Lake, and she was in the courtroom today. Ruth Miller is facing multiple charges in connection to that death, as well as domestic violence charges in a golf cart crash with her 3 older children. Today, the judge says he'll make a decision by the end of the week regarding jury instructions. Miller is set to go to trial in March.
All right, so that was a little teaser of what we're going to watch. Excuse me. All right, so here's the hearing. Here's the actual hearing. Competence seems wrong if she thought she could walk on water. I agree, Wyatt. Yeah. Bing and Billy, you were born and raised in Chicago, but moved to Ohio to raise your 4 children. Just a girl in Cali, really enjoying this coverage. Thank you. Thank you. Appreciate that. Thank you, thank you. All right. All right, so here's the hearing. Now, this is from, do I have anything pinned? I just want to make sure I don't have anything pinned. All right, so this is from January 5th of this year. Then we're going to see another one from February, and then March is her actual trial. So it was a bench trial. There is no jury. Just that's maybe a little spoiler. Didn't mean to let that leak out, but it was a bench trial. All right, so here, this is from January 5th.
Second time? Yes. So we get all in. Everyone should have a seat. We are now reporting the case entitled State of Ohio versus Ruth Miller. It's case number 2025 CR 090285, and we are here today as the court had previously scheduled this hearing for the purpose, really the limited purpose of addressing a jury instructions in this matter, and more specifically the jury instruction pertaining to the issue of wrongfulness. And in this matter, Ruth Miller is present. She is seated at counsel table along with two of her attorneys in this matter, Lucas Trott and Madeline Grant, both seated at counsel table with her. State of Ohio is represented in this matter by the County Prosecutor Ryan Steyer and Assistant Prosecuting Attorney Fred Scott are all present for this hearing. And Ms. Miller, at this hearing, I'm mainly going to be listening. I'm going to be listening to what the attorneys have to say. They have already submitted to me, and I have reviewed, one, the initial request that had been made by the state pertaining to that jury instruction. An objection was filed by your attorneys, and that is dated December the 29th of 2025. I reviewed that as well, and then just today I was handed a copy of the reply filed by the state of Ohio as well. I've considered all of these items before we came in. Done even some additional research on my own. But I can tell you today, Ms. Miller, I'm not going to rule from the bench. I'm going to listen. And I'm not going to listen, I'm not going to have anybody submit more things to me in writing, but I'm going to go back and look at what they submitted again, because I know it's important to everyone involved. But I just wanted you to know, going in, that's what's going to happen. There's going to be a lot of talk by the attorneys, a lot of listening by me, and then I'll issue my decision in writing. I'm going to start in this case with the state of Ohio, and they're going to have the opportunity to be heard first. I'm going to allow one of your attorneys to respond on your behalf, and then if there's any rebuttal that needs to be made, I'm going to hear from the state on that issue as well. Before we go any further, though, I'm just going to ask the attorneys if there is anything beyond what I have put on the record here at the outset that they feel should be addressed as well today. And I'll start first with the state. Beyond what I have said, Ryan, is there anything else?
No, Your Honor.
Okay. And Madeline, anything on behalf of Ms. Miller?
No, Your Honor, thank you.
Okay. I just wanted to confirm that, Ruth, to make sure that we're all on the same page as to how we're going to proceed today. As we are, I'm going to hear from the state of Ohio. Ryan.
Thank you, Your Honor. I want to keep my initial remarks, relatively brief, because we have had the opportunity to brief this, and I appreciate that opportunity. And I believe at this point it's been thoroughly briefed. And, Your Honor, I think that what we can say is that we agree on a lot of things at this point. Having read the objection of the defendant, and three things we agree on. We agree that the term wrongfulness as used in the revised code does not fully contemplate the law as it relates to wrongfulness. Namely, that wrongfulness is broken into three categories in the literature and as taught in law schools. It's not exactly the rubric of case law, but it makes sense of the case law. And those three categories are legal wrongfulness, objective moral wrongfulness, and subjective moral wrongfulness. We further agree that subjective moral wrongfulness is not the standard in Ohio law. And the jury, the state's position needs to be made aware of that, and the forensic examiners need to know that is the ruling of the court as they do their work. And then last, and most significantly, we agree that the state's proposed jury instruction is a correct statement of Ohio law. Now, we can stop right there, and that would justify the court ordering that jury instruction forthwith. And I would urge the court to do that soon for the reason that the forensic examiners are doing their work at this point. The state examiner has already done his work. We have an independent examiner who has begun his work and will be interviewing Ruth this week. And I understand that the defense forensic examiner has already interviewed Ruth and is in the process of doing her work as well. Now, the defense argues that despite the fact that the proposed instruction is a correct statement of law, that it would be misleading to the jury. I strongly disagree. It's my experience that when juries are given clear and correct and accurate legal instructions, that is beneficial to those jurors. And to suggest that the juror would be misled by a clear, accurate statement of the law is really demeaning to the jury. Now, I would go further, and I would say to not give this instruction to the jury would be misleading to the jury. Because we agree that the term wrongfulness can be broken into three categories, only two of which are applicable in this case. If the jury doesn't know that, they are being misled. And furthermore, what a forensic examiner does is that they assess the facts, the objective facts in the evidence, the facts that gleaned from interviewing the defendant, and they apply that to the law. And so the forensic examiner also needs instruction on that law so that they can follow the precise instruction of the law. Now, one court of appeals in our state has limited that instruction to legal wrongfulness only. Most courts include subjective moral wrongfulness, and that is what the state is requesting here. So the forensic examiners need to know that because that's a predicate of the work they're doing. Their conclusion flows from their application of the facts to the law of insanity in Ohio. And so with that said, Your Honor, I think that we have shown that the instruction is warranted, that it is accurate. We agreed that it is a correct statement of law. And my request is that this court
make a ruling on that sooner rather than later, and ideally before the forensic examiners would author their reports, which really should be done by the end of this month.
Okay. Madam, on behalf of Ms. Miller, whoever was going to speak.
Thank you, Your Honor. I'd also like to keep our remarks somewhat brief and lean primarily on the filings. I agree with the state of Ohio. There is a lot which we agree on, specifically sort of the general propositions about what the Ohio Revised Code and the case law says about the definition of sanity. Now, there is one, I think, very foundational area on which we do disagree at this juncture, and that's whether or not simply whether a jury instruction is legally accurate is the end of that analysis as to whether or not the jury actually hears it. I would submit that that's not at all the case. There must be a factual nexus between that instruction and the facts of the case. Your Honor, at this juncture, we would submit that that factual nexus has not been established and that that remains to be seen whether or not this is a question that is ripe for decision at this point. Now, I could craft a very detailed and fleshed out jury instruction related to the issue of self-defense that is legally accurate. That does not mean at this point that that warrants giving that instruction to the jury. I don't anticipate that there will be such an instruction in this case because simply speaking, the facts don't reflect that, the necessity of that instruction. So at this point, Your Honor, I mean, there's no assertion by Ms. Miller that she's relying on her subjective moral code in the any day in question. Furthermore, the only report that we have at our disposal is one which relies only on legal wrongfulness and says without question that Ms. Miller was not appreciative of the legal wrongfulness of her conduct on the day in question. So the state certainly has the opportunity to re-raise this issue as this case proceeds up until the point where this jury receives the charge. But at this point, I think the court must ask itself, what is the rationale by which, from a jury perspective, this jury instruction is given? Because we certainly maintain that at this point, it would be inappropriate for a forensic examiner to receive this additional legal analysis, given the arguments we've raised previously that were since withdrawn, just on formality points. But as we've sort of argued previously, these forensic examiners rely on ORC, and ORC alone, typically when they're doing this, they understand what the legal standards are at play, and to then give them more information, I think asks them to sort of umpire these legal disagreements by the parties, which is really not in their wheelhouse to do. And so we would agree, yes, on the general definition of what is and is not sanity under Ohio law. I would note that while there is some disagreement, as the prosecutor indicates, between the 12th district and some of the other districts, what remains true is that there is, in all but that 12th district, room for an objective moral inquiry when you're talking about insanity. And I do think that to sort of raise that issue when stated by the facts of the case would mislead the jury to the point where it might insinuate, based upon how this proposed instruction is written, that any time that a defendant raises a sort of deific decree or hearkens to some sort of conversation with this perceived higher power, that automatically disqualifies a finding of sanity, which isn't Ohio law. And I'm not insinuating that's what Mr. Stiers is saying is Ohio law, but that is the risk that is run. And in our experience, there certainly is a risk when a jury is over-instructed. When under OJI, they're given sufficient instruction as to whether or not sanity can be found. And when you over-instruct that jury, you leave room for error, wiggle room, gray area, where they might be led astray. So, Your Honor, based upon that, we would rest on our motion and our objection. At this juncture, there is really no justification to give this instruction. It's an issue that can certainly be raised at a later date once this evidence has been fleshed out. But at this juncture, we would submit that it's not appropriate.
Brian, I know I said you had the opportunity for rebuttal, and I'll allow for that. After I've heard from both of you, I do have just maybe one inquiry, and that is, we're talking about jury instruction, and that I can easily wrap my head around as to what that is, the fact that we would need that, and that I would provide that to the jury. The part that I'm a little just confused about is because I guess I've never, that I can think of, ever having made some type of preliminary ruling that would in any way have guided the work of an expert, particularly in a question of competency or sanity. And I'm not saying it can't be done. I guess I'm just a little bit confused as to how will this ruling somehow impact the work of experts. I'm not saying it can be done. I've just never done that. That's all.
As you review this matter, Your Honor, I would refer you to my memorandum in opposition to the defendant's motion to exclude the sanity evaluation. Now, I know we've already settled that issue, but if you look at footnote 1,
do you know what page you have on it?
It's page 2. If you look at footnote 1 in there, it cites to the precise revised code, namely 2945-371 H and G, that sets forth in Ohio a forensic examiner's duty when they're evaluating sanity and competency, but sanity in this event. And it makes it clear that the forensic examiner's job is twofold. It is to draw a conclusion from fact-finding and then to apply that fact-finding to the law as it relates to sanity. Okay? So only when you have forensic psychologists testifying in court on issues of competency or sanity do you have this phenomenon where an expert needs to know the court's view of the law, if there's any dispute, as they do their work. It said that the forensic examiners should not be put in a position to umpire the legal disputes or disagreements of parties. That's true. It's the court's obligation to do that. And if the court can do that before the work is done, then we're not going to be in a situation where fact-finding has been done and that has been applied to an inappropriate legal standard, compromising the conclusion. I think we need a process that is as efficacious as possible, and it's very rare that even in the context of insanity evaluations, which this court has overseen hundreds of times, it's very rare that there is a legal dispute. And it's very rare that there is a deific decree in a case. But it's this deific decree, this claimed deific decree, that requires the definition of wrongfulness to be fleshed out. So it was also said that there are no facts, I didn't write it down, but there are no facts before this court justifying this at this point. I would point the court to the hearing that we had, the relatively long bail hearing that we had, where a lot of the facts did indeed come into evidence. And so it's, really undisputed, I believe, that Ruth Miller immediately claimed to bystanders and then first responders that she threw her son into the lake, and that she did that because she believed, she was compelled by a feeling that God wanted her to do that. That's undisputed. So we know where this is going. We've already had one forensic examiner's report offered to the court that has spelled that out. And I would also point the court to that hearing and the evidence adduced at that hearing that suggested that shortly after she was confronted by the Rangers, who were first responders, in Ranger Anderson's testimony, he indicated that she took off in a dead sprint and was lost. And that happens to be on the timeline for, I've been saying 30 minutes. That's very conservative. It's upward to 45 minutes. And that she's found lying face down quietly in high grass by the Welcome Center, almost a mile away from where she initially fled. And when she is found, almost 45 minutes later, she immediately says to the Rangers, and this is on body cam and the court saw this, I threw him into the lake, I gave him to God, and people are going to tell me I'm crazy, but he is real and he loves you. People are going to tell me I'm crazy. So you not only have, and I'm sure the interpretation of these facts will be argued, okay, but a fair interpretation might be that she fled because she perceived that this was legally wrong, or at least wrong according to an objective moral standard. And that her claims that she felt that God was talking to her was in her head only, and that was subjective. And it's important that these forensic examiners and that later the jury know that we have a standard that we need to use when we assess wrongfulness, and subjective moral wrongfulness is not part of that. So, is that responsive to your question?
It does.
Okay.
Is there any further rebuttal?
Only I would argue that our instruction is a very concise statement of the law. It's 2 sentences. Our additional instruction that we're requesting is 2 sentences, and it encompasses both the 2 categories that should apply, and it specifically indicates the rejection of the 3rd category that should not. That would not be over-instructing the jury. Juries need to know, forensic examiners need to know clear, preferably concise, and accurate law that they need to apply to a situation, and this is all of that. It's clear, it's concise, and we agree it's correct.
Thank you. I'm interested in knowing, even though I said I was going to give the state some rebuttal, I'm interested in knowing if there is any response directed to an attorney trial. My inquiry as to instruction given to an expert in this case, as I had said that I found it was a little unusual. I don't think I'm not saying it's not going to happen or it couldn't happen, but I did find it unusual that there would be that need for the instruction at this stage. The state has articulated its position as to why. I'm curious to know the defense position.
Certainly, Your Honor. I would agree with the court's instinct. I mean, it certainly struck us as unusual or irregular. I think that's because it is. That's what prompted us to file our initial objection to that letter and the motion to exclude the report. And we also posed this question to our own our own case evaluator, Dr. Hatters-Friedman. We also posed it to the head of the Summit County Forensic Clinic that deals with the Summit County Court of Common Pleas, both of whom had never received such a request before, had never received a packet from a prosecutor, from another party, which seeks to sort of clarify an element of law, which they deem to be worthy of clarification. So I think the court's correct to sort of look at this with some I don't want to say confusion or suspicion, but just wanting to know why this would be relevant or needed. And so I mean, for reasons that we've already raised, we would submit that it is not needed. Court evaluators across the state reach these conclusions, analyze these cases without the benefit of such extra analysis every day in every case that they confront. And so nothing about this case, while I would agree that the decree is, it's somewhat nuanced, it's irregular, it's not that common, I don't think anything about this case makes that general proposition any less true, that these professionals know how to do their job without the benefit of all this extra fluff. And they do it on a routine basis. And it's the same for juries, Your Honor. I mean, juries reach verdicts on sanity cases all the time across the state of Ohio without an instruction like this. This is a widely recognized area of the law, and I agree that it's nuanced. And that's exactly why you run a risk with a jury if you over-instruct them. Obviously, this is something that we're tangling with, and it's an element of the law which is, I would submit, somewhat unclear, and that's evidenced by I would agree with the thorough briefing that we've done on this issue.
Let me ask you this.
Sure.
I think that the state would say that they would agree that it's unusual, and that I think their opinion is, why not give guidance to forensic examiners? Why not be more specific when dealing with a jury? Can you tell me, while I'm considering this, what would be the harm in essentially doing it slightly different, doing it preemptively, giving this instruction now as opposed to waiting and potentially giving it later? What would be the harm?
Well, Your Honor, I think as can be gleaned from the authority as delineated in these motions, it's somewhat of an open question. I mean, the courts come down somewhat differently. Defendants in Ohio have a right to be treated, equally in cases like this, and I do think there is a risk if we're sort of putting it on the shoulders of parties and jurists to give these instructions, that one defendant in one district might be treated differently than another. Now, in terms of whether or not and the same goes for a forensic examiner, sanity is sanity no matter what district you're in, and I think this issue is ripe for Supreme Court clarification at some point, whether or not there's enough case law right now to actually manifest to a split. I think there is, but it's not extremely stark. The risk is that a jury or a forensic examiner hears this standard and they go off on a tangent that isn't necessarily supported by Ohio law. That's the risk you run when you give so much instruction. Correct, but when you over-instruct. So that's the harm. And is there a world in which this evidence develops in such a way, for instance, if the state's evaluator or a different evaluator comes forward and says that Ms. Miller was acting on the subjective moral wrongfulness standard, and then facts come from the witness stand and say, yeah, we also believe that there's facts here that submit that she understood the legal wrongfulness or the subjective moral wrongfulness, then yeah, there might be a world in which the state's jury instruction is appropriate. The primary argument we're putting forward today, Your Honor, is that is not today. And ultimately, the court's only going to give one set of instructions. And so I don't believe there's any harm in waiting, because if that evidentiary record is flushed out in such a way, then the jury hears it. And if not, they don't.
Thank you. I believe we covered all of the topics at this point in time. But I'll, just because we've got everybody here, Brian, aside from, again, anything further, not so much rehashing any of these arguments, anything else would need to be discussed while we have all the attorneys and Ms. Miller here.
The only reply I would make, limited to what Mr. Trott just argued, is that the suggestion it is an open question, I think, would suggest that the court should make a ruling on it. And the fact that we agree that it's an accurate statement of law should resolve any open question that may be.
Examinations, though, are not being held up by this. It sounds as if everyone's moving forward and we're still on pace to be having that trial soon. Correct?
We're planning on it. Yeah.
All right, I see that the state had an examiner in the Cincinnati area.
That's correct.
And you signed that order, right? And she's able to get that taken care of. I just wanted to make sure that we have everybody here, that we didn't have any outstanding issues that need to be addressed. From the defense standpoint, I don't know, Lucas, anything else? Again, even unrelated to this particular issue that you need the court's attention today.
Not at this time, Your Honor. Thank you.
Then, Ms. Miller, as I said before, I'm not going to make a decision from the bench. I'm going to make a decision now, and I'm going to make the decision in this case. I believe there will be a decision from the court by the end of the day on Friday. One way or the other, I'll make a decision in this case, and that way people can plan and move on. So if there's nothing further, we are adjourned.
Thank you. Thank you, Judge.
Yeah, I don't know. I guess she's on medication at this point because she's in therapy. She's in a hospital. She's got the Sarah Boone outfit there. All right. So we have that's a pretrial. So we have I guess we have another pretrial because that was from January 5th and this is from February 24th, and then we'll get to her bench trial, which is pretty short. You guys will be kind of surprised at how short it is. It's actually shorter than the bond hearing. The bond hearing was longer. The bond hearing seemed like the trial, but the bench trial is shorter than the bench trial is shorter than the bond hearing. All right, let me fast forward here. Okay, here we go.
Everyone may be seated. We are now recording in the case entitled The State of Ohio versus Ruth R. Miller. It's case number 2025 CR 090285. And we are here today for a final pretrial conference. Ruth Miller is seated at council table, and she is seated there along with her attorneys in this matter, Ian Friedman and Madeline Grant. The state of Ohio is represented by Assistant Prosecuting Attorney Fred Scott. And Ruth, we are here. I always schedule a final pretrial to meet with lawyers, to find out from them as to what has been taking place, and most importantly, how they anticipate that we are going to be proceeding in these matters. Ruth, they tell me that this is a case in which I should anticipate that this is going to be going in the way of a bench trial, which would mean I would be deciding the outcome as opposed to a jury. Right to a jury trial is a fundamental constitutional right that everyone would have in a felony case. So to get to that point of having a bench trial, it would require that we have a dialogue about waiving of that constitutional right. But before I launch into that discussion about right and waiving that right, I think it's best that I hear from the lawyers in this case to make sure I'm on the right page, and if I am, then we'll have that discussion. Ruth, I'm going to start with your side here first, and then I'll hear from from this side of the room next as to what their expectations are. So Ian, Madeline, whoever wishes to speak.
Thank you, Your Honor. Good afternoon. Your Honor, you are correct. There would be a waiver today making this proceeding a bench trial in response to what has been stipulated to by the parties and is being admitted to you for your consideration. That is a list of 5 exhibits which the state is providing to you. Exhibit 1, mostly made up of that discovery, police reports and the like. And then exhibits 2 through 4 are the mental status evaluations. The first by District 9, that which you called for and was performed by Dr. Rinko, H-R-I-N-K-O. The report from Dr. Hatters, H-A-T-T-E-R-S hyphen Friedman, F-R-I-E-D-M-A-N. There is no relation, just to be clear. And then third, the mental health evaluation by the expert, Dr. Merritt, M-A-R-E-T-T, that was engaged by the state of Ohio. Those 3 reports all concluded and opined that Ruth Miller was not guilty by reason of insanity at the time of the conduct in this case and could not appreciate the wrongfulness of her conduct at that time. Parties agreed to and stipulate to the authenticity of the reports, the content therein, and to the findings. And so we bring that to your attention along with Exhibit 5, which is a zip drive containing statements that were made by Ruth Miller to Captain Fisher at the date in question, the date of the incident. It is our expectation as we go forward. Attorney Grant and I, at this point, are not calling certain witnesses for the bench trial, as we'll be relying upon your evaluation of the records that are being submitted to you. That if you accept the stipulation by the parties that the hearing of Ruth Miller was, in fact, and just for brevity's sake, NGRI at the time, we will then move on to placement hearing at the time that Your Honor sets. So for all those reasons and for the findings that are contained in it, it was unanimous. There were no experts that opined differently. Because of that, the defense at this point is going to rely upon presentation-wise for the bench trial to that which is being submitted to you only. Thank you.
Thank you. Brett, on behalf of the state.
Yes, Your Honor. Mr. Friedman did accurately depict our discussions. As you know, I've taken over the case for Mr. Steyer, who's going to be taking the bench across the hall in a couple days. I did put together a list of the police reports that I believe, most of the supplements that I believe describe the conduct so that you have information to make a determination that Ms. Miller did indeed commit the acts with which she's accused. And that's about 42 pages. And then there are 3 mental status evaluations. One obviously conducted by the court's psychiatrist, one then conducted by the defense psychiatrist, and then one conducted by a psychiatrist hired by the state of Ohio. Given the findings, as all 3 opined for various reasons, that Ms. Miller did not appreciate the wrongfulness of her conduct and was suffering from a severe mental illness or defect at the time of the offense. Given that, we have decided to submit this case to you for a non-jury trial, for you to review those matters and make an appropriate finding. And as he indicated, I've also included a zip drive containing the 2 interviews that Ms. Miller gave to Captain Fisher, the Tuscarawas County Sheriff's Department. So we are in agreement that there's a stipulation as to the authenticity and the admissibility of all these documents, I believe. And with that stipulation, we would not plan on submitting any other evidence next week or whatever the trial date is. And we would just rest and wait for your conclusion.
All right, with that recitation then, Ruth, let me tell you what I believe, what I anticipate as far as how this case will proceed. And and then I'll have that discussion with you, so that you know so you know how this matter is proceeding before you would waive any type of fundamental right. So what they've said to me is that, and what I think they are anticipating, is that there are 5 exhibits that they want me to consider. A couple of police reports and 3 expert reports. One that I ordered, which I've already seen. One that you had acquired through your counsel that I have not read. And the report that was generated by the state that I have not read. And I don't know how long they are, but I know they're going to take a little bit of time to review, along with a lengthy police report. My expectation is that they want me to consider those, read through those. I'm not going to be admitting them. Today is not the trial, but they're essentially giving them to me as a preview to look at. We would then come back next week to conduct what I've referred to as a bench trial. It is a non-jury trial, as the state has called it. Bottom line is, Ruth, there wouldn't be 12 people sitting in those chairs over there listening to evidence, listening to argument of counsel. It would be decided by me, and it would be decided based upon those 5 exhibits that I'm going to be receiving from the attorneys in this case. Ruth, you have an absolute right to have this matter decided by 12 citizens. The way that would work is that the room would be filled up about 50 to 75 people. And from those people, we would pick 12 that would sit over there in those chairs. And your attorney and the state's counsel would have the opportunity to inquire of those 12 people to find out whether they can be fair and impartial. And ultimately, after going through however many people we have here, the court and counsel settle upon 12. And those 12 would listen, and at the end of the case, they would be given the opportunity to deliberate or go off in a separate room and consider what they've heard. It would require all 12 of those individuals to be unanimous in their opinion that you were guilty before you could be found guilty in this case. That's an absolute right that you have. But we all have constitutional rights, and we all can waive those constitutional rights. The key is that we make that decision knowingly, intelligently, and voluntarily. Ruth, have you had an opportunity to discuss this matter? And I'm not interested in what was said. I'm just interested in knowing, did you have a full and fair opportunity to discuss that matter with your attorneys? I just need you to answer out loud, Ruth. Okay. And you feel as if all of your questions and any concerns you may have with that right were answered by your attorneys? Okay. And you have confidence in their representation and any advice that they have given to you? Okay. You understand that, Ruth, that I'm asking you at this time if it is your intention to give up that right to having the matter decided by that jury or 12 individuals. Okay. And is it your intention to give that right to have the case decided by a jury? Okay. Then, Ruth, I'm going to provide you with this form, and it's just reflecting what we have discussed here today, but I want you to take a moment, if you need to discuss the matter further with your attorney, to make sure that you have all your questions answered. record should reflect then that the waiver of right to jury was signed by Ruth Miller here in the court, in which she indicates, I, Ruth Miller, defendant in the above referenced case hereby voluntarily waive my constitutional right to a trial by jury on the felony and criminal charges contained in the indictment in this case, and consent to the trial of the criminal charges to Judge Michael J. Ernest. I have not been forced or in any way coerced in the exercise of this waiver. And then just to confirm, Ruth, you signed this document, correct? Then I'm going to accept that waiver of the right to trial by jury. And we already have a date that is set for next Tuesday. I apologize, I don't have it in front of me.
It's March 3rd at 10.
Okay, March 3rd at 10, set for a status conference, and that's the date we were going to utilize now for the bench trial, correct?
Correct, Your Honor.
All right. Then what will happen is, Brett, if you could provide me with the exhibits that you want me to consider for the ruling bench trial.
Your Honor, if I may inquire, so we're to expect that day a verdict from you on that day, so absolutely. Tuesday. Okay.
That is the reason that rush through this and get a full understanding of what's in here, because like I said at the outset, I have not seen what your expert has generated or what the state of Ohio has generated in this case. I heard what they said, so it's not going to be a surprise as far as their conclusion. I heard Attorney Friedman, so I'm anticipating where this is going, but I want to actually read it. Understood? Do you have any questions for me, Ruth? Okay. Counsel, any questions?
No, thank you for your clarity.
Okay. Brett?
No, Your Honor.
All right. Then we will see everyone back here in approximately a week for that bench trial.
Thank you. Thank you, Your Honor.
Okay, so that was her basically just saying it's okay to do a bench trial and not a jury trial. All right, so now we're going to get to her actual bench trial. And again, this is short. It's only 17 minutes. So as long as that hearing was, this bench trial is going to be that long. So don't blink. It's going to be over before you guys know it. All right, let's take a moment to hit the like button. We're at 274. Let's see if we can get up to 280. Can we get up to 280 likes while I queue up this next segment? If you can hear my voice and you are not in chat, please take a moment and hit the like button. And we would appreciate that while I queue this up for the bench trial of Ruth Miller. 277, awesome. Got a couple more to go. A few more likes to go. Let's see, can we get to 280? 280, thank you. Thank you, guys. Thank you so much. Appreciate that. All right, so this is going to be the bench trial of Ruth Miller. And like I said, it's only 17 minutes, so don't blink because it's going to be over before you know it. Then after this, I have something more to show you, but we'll get there once we hear the outcome of this bench trial. So remember, she's going with not guilty, reason of insanity.
I'm going to start first with the state of Ohio and ask Fred, is there any form of opening statement that the state of Ohio intends to give?
Judge, I do not intend to give an opening statement. I would just like the record to reflect that prior to beginning today, the jury trial waiver, which we discussed last week, was there was a written waiver signed by Ms. Miller, and that was filed prior to beginning our proceedings today. Thank you. Thank you.
We do not have any opening statements. We will waive and move forward to the admissibility of our exhibits. Thank you, David.
With that, Fred, I have in front of me what I believe are the five. One, two, three. There are the 4 paper exhibits that I have I don't have in front of me, but they're simply on my desk, and I intend to bring out the videos today. But I have a collection of police reports from the Tuscarawas County Sheriff's Department, as well as there is one report, I believe, included from the Muskegon Watershed Conservancy ranger officer, correct?
Correct. There's also the coroner report.
For those reports, are you asking that all of those reports are admitted?
Yes, it's my understanding with the defense we're going to jointly move those exhibits in, stipulate to their authenticity and admissibility.
And before I hear from you, Ian, that would be also true then for the report from starting off from Forensic Diagnostic Center of District 9, Dr. Rinko. There is also the report from Dr. Haddon Friedman from University Hospitals, as well as the report that was provided from the University of Cincinnati, correct?
Correct. So Dr. Rinko, Dr. Haddon Friedman, and Dr. Merritt, all three of those reports, I understand we will stipulate the authenticity and admissibility of those, as well as the two statements by Ms. Miller. One was an audio statement conducted by Captain Fisher, and the other was a video, a statement captured on his body work.
Ian, I'm here from you on states exhibits 1, 2, 3, 4, and 5.
I think the state captured it correctly. We are stipulating, as was just described to you, Your Honor.
Okay, thank you. With that, then, Fred, is there any further evidence that the state of Ohio intends to present?
No, the state would rest based on those exhibits, if any.
Ian, I'll turn back to you for Ms. Miller. Any further evidence that the defense intends to present?
No, Your Honor, we rest upon the evidence which has been submitted thus far.
Okay, thank you. And the court, with those stipulations, will admit exhibits 1, 2, 3, 4, and 5. Keeping in mind, Exhibit 1 has multiple parts to it. That would include all of the police reports that were provided. Based upon those stipulations, the court makes the following findings. I've had the opportunity to review all of them, and I did review all of them before I came out here on the bench today. And I'm making the following findings, including that on or about August the 23rd of 2025 in Tuscarawas County, Ohio, that Ruth R. Miller did purposely cause the death of Vincen Miller, who was under the age of 13 years of age at the time of commission of the offense, and born on 10/12/2020, including that on or about August 23rd, 2025, Ruth R. Miller caused the death of Vincen Miller as a proximate result of the offender committing or attempting to commit the offense of felonious assault in violation of 2903.11A1. I'm concluding that on or about August the 23rd of 2025, that Ruth R. Miller did knowingly cause serious physical harm to Vincen Miller. And concluding that on or about August the 23rd of 2025, that Ruth R. Miller was a parent or a child under the age of 18 years of age, she created a substantial risk to health or safety, in this case of Amber Miller, by violating the duty of care, protection, and support. Including that on or about August 23rd, 2025, that Ruth R. Miller unlawfully did knowingly cause or attempt to cause physical harm to Amber Miller, any or household member. I'm also concluding that on or about August the 23rd of 2025, that Ruth R. Miller unlawfully did knowingly cause or attempt to cause physical harm to Joel Miller, family or household member. I'm also concluding that on or about August the 23rd of 2025, that Ruth R. Miller unlawfully did knowingly cause or attempt to cause physical harm to Jordan Miller, family or household member. Now, Ruth, I've also taken into consideration not only the police reports that were provided, but I've read through all of the forensic examinations that were conducted in this case, and there were 3 of them. And I think it might have been said earlier, whether it was out here or in chambers, it truly is unanimous. I ordered that a agency conduct an evaluation, forensic diagnostic 9. Your attorneys retained an individual to conduct an evaluation, and the city, all of us, had essentially our own evaluators conduct an evaluation. These are the findings that I have concluded, including that a mental status at the time the offense evaluation was conducted by Dr. Daniel Rinko of Forensic Diagnostic Center of District 9 was identified as a joint exhibit number 2, has been entered into evidence. In the report by Dr. Rinko, who is a board-certified forensic psychologist practicing with Forensic Diagnostic 9, he sets forth findings which the court finds persuasive as to the York state of mind at the time of the offense. Dr. Rinko opined that the defendant at the time of the offense charged did have a severe mental disease, but did not have a severe mental defect. His opinion states that as a result of the severe mental disease, the defendant did not know the wrongfulness of the act charged. And that would apply to all of the acts that is charged, not just one, but to all of them. The next evaluation that I reviewed was the evaluation of Dr. Susan Hatters-Friedman of the University Hospital's Cleveland Medical Center, Case Western Reserve University, was identified as Joint Exhibit 3, and he was also entered into evidence. Dr. Hatters-Friedman, the defendant at the time of the offense charge, also had severe mental disease and did not have a severe mental defect. In a report by Dr. Hatters-Friedman, she sets forth again certain findings which the court finds persuasive as to your state of mind at the time of the offense. Her opinion states that as a result of this severe mental disease, the defendant did not know the wrongfulness of the acts charged, and that would apply to all 7 counts of the indictment. Lastly, I considered the report that was submitted to me by the state of Ohio. The state of Ohio utilized Dr. Christopher Merritt of the University of Cincinnati. Dr. Merritt is a board-certified forensic psychiatrist who set forth certain findings which, again, the court finds persuasive as to the defendant's state of mind at the time of the offense. Dr. Merritt opines that the defendant at the time of the offense charge, again, has a severe mental disease, but did not have a severe mental defect. His opinion that he states is that as a result of this severe mental disease, the defendant did not know the wrongfulness of her acts as charged. Again, all 7 counts in the indictment. And while, curiously, there was maybe differences of opinion among the doctors as to what the mental disease was in this case, they all concluded that you suffered from some form of mental disease that prevented you from knowing the wrongfulness of your conduct. I would also note, and I'm just going to single out Dr. Merritt. I think they all have very, very thorough report, but some of these findings are worth noting as well, and that is, it's not just the 3 doctors who came to this conclusion that you did not recognize the wrongfulness of your acts. There are numerous witnesses who have contact with you on the days leading up to this event, that have contact with you on the day of the event, and also shortly thereafter. And some extent, their observations and opinions here, I think, are relevant as well. Specifically singling out, though, some of the summary that was noted by Dr. Merritt. He says Ms. Miller's described in the weeks leading up to the alleged offense having short and erratic sleep. She described having a euphoric mood at times, which felt like she was getting married all over again. Grandiose, distractible, and at times had racing thoughts. Ms. Miller described descriptions of her belief, particularly those about tests and her expected ability to reflect a grandiose and delusional thinking. She ordinarily did not believe she would have ever had the ability to walk on water, but she also believed that God had asked her to be swallowed by a fish, and she asked that her husband at one point in time to suffocate her. These reflect delusional and distorted thinking, which she did not otherwise have outside of mental health episodes. Talks about medical records supporting these same observations that you had made. He talks about eyewitnesses, law enforcement officers offering their observations that Ms. Miller's behavior was suggestive of a person experiencing an acute mental health crisis. For example, he says Officer Katie Edwards wrote in his initial report, while speaking with Ruth, it appeared that she was not in a correct mental state. Due to this, the Rangers and I determined that Ruth needed mental health evaluation. That same type of conduct, I think, is reflected by numerous witnesses in the police reports, both leading up to the events at issue and shortly thereafter until you receive proper care. Based upon these findings that I have made in this case, I am concluding that pursuant to Ohio Revised Code Section 2945-37, that the defendant, Ruth R. Miller, is not guilty by reason of insanity. I think that's the only conclusion that can be reached in this case based upon the evidence that's been presented to me. Ruth, after and concluding that you are not guilty by reason of insanity on all 7 counts, aggravated murder under 2903.01C, murder under 2903.02B, and felonious assault under 2903.11A1, endangering children, count 4 under 2919.22A and E, domestic violence, count 5, 6, and 7, all misdemeanors of the first degree under 2919.25A will have the conclusion that the evidence supports in this case, and that is not guilty by reason of insanity. Now that a determination has been made that you are not guilty by reason of insanity, the next step will be determining the final disposition regarding the least restrictive conditions that can be placed upon. Before I go into that, though, is there any further to state on the
Not from the state.
Nothing further. Thank you, Ryan.
And just confirm March 13th. That's what we agree on?
Yes, Your Honor, just briefly, though, for the court's consideration as well, we will submit today 2 additional reports for the court's review prior to the March 13th date that have already been provided to the state of Ohio, and we'll separately provide to the court via email the curriculum vitaes for both experts as they were significantly long. That'll be for Dr. Hatteras Freeman and Dr. Daniel Buffington. Thank you.
One thing I don't have on that is the time.
At 10 a.m.
It's at 10 a.m. All right, so what will happen, Miller, is we'll be back here on March 13th at 10. Each side will have the opportunity to present to me as to what their prospective positions are regarding essentially your placement going forward. And I heard that I know that you will be submitting that. I am afraid that you said that the state has its doctor, and I am going to reach out to District 9. I want to have their input as well as far as a recommendation. Don't be surprised. I'm guessing that they will be reaching out to you. I could be wrong on that, but I'm guessing they will have some contact with you. But I am going to Dr. Rinko to get an opinion as well. We're going to have you remanded back to the Tuscarawas County Jail. The law allows in Ohio for you to be confined during those 10 days leading up to that hearing. Is there anything further from the state?
No, Your Honor.
No, Your Honor. Thank you. Double check my notes here. Is there anything else you need? Ordering assessment to be completed. Talked about the hearing. And the last thing is this. The findings that I made here in open court, they'll be reduced to a judgment entry. It's a paper document reflecting what had taken place here at this bench trial today. It'll be sent to your attorneys. They can provide it to you as well as to the state of Ohio. We'll reconvene in this matter otherwise on the 13th. Nothing further? Nothing further. Thank you, Your Honor.
All right, so that was the bench trial. Now we get to her. Now I can say, now we get to her placement hearing. So now we're going to get to her placement hearing. So this one is going to be a little bit more comprehensive. And this one will take longer. I believe in this one we hear from some experts. I think this is the one where some experts come out. This one's almost 2 hours. So as short as the actual trial was, the placement hearing is just under 2 hours. Oh, actually, you know what? I just want to play this real quick. Let me play this real quick. Let me play this news clip. Before we get to that, I'll just play this news clip real quick.
Found Ruth Miller not guilty.
We'll just play this news clip real quick.
Today, a Tuscarawas County judge found Ruth Miller not guilty by reason of insanity on all 7 counts against her. The mother of 4 was on trial accused of murdering her 4-year-old son and endangering her 3 other children. Annabelle Childers explains what happened in the court and what today's judgment means.
Tuesday, Ruth Miller entered a Tuscarawas County courtroom, prepared for a judge to announce a verdict in her trial. The Amish mother of 4 was charged with murder after throwing her 4-year-old son into Atwood Lake this past August as what she called a sacrifice to God.
I gave him to God.
She also drove a golf cart carrying her 3 other kids into the water, but they survived after swimming to safety. In a hearing last week, Miller waived her right to a jury trial, and both legal teams submitted evidence for the judge to review. Police reports, body camera footage, and most importantly, 3 reports compiled by 3 separate experts on her mental status. The judge began the bench trial by saying he'd reviewed all the documents and confirmed each psychiatric expert reached a unanimous opinion.
The defendant, at the time of the offense charge, again, has a severe mental disease, but did not have a severe mental defect.
Because of that, Judge Michael Ernest said there was only one conclusion, finding Ruth Miller not guilty by reason of insanity on all counts. After the judge read the verdict, he set a March 13th date to discuss where Miller will be sent now. Outside the courtroom, prosecutor Fred Scott discussed why he and the defense were in agreement on the not guilty verdict.
When you have a unanimous decision that the defendant did not understand the wrongfulness of her conduct, was in a psychotic state, the decision kind of writes itself.
Defense attorney Ian Friedman shared how Ruth Miller is handling the weight of her actions.
She is mortified by the fact that she was involved in that situation on August 23rd, 2025. And had she been receiving the care that was necessary at that time, none of us would be standing here right now.
Because Miller was found not guilty by reason of insanity, the court will have jurisdiction over her for the rest of her life. And by law, every 2 years, they'll reevaluate where Miller should be held. At 5 o'clock, I'll share what the judge said about Miller's behavior leading up to this incident. Jay.
All right, look forward to that report. Annabelle Childers live from the newsroom. Annabelle, thank you.
All right, so now we'll get to our placement hearing. Welcome in, everybody. I appreciate you guys coming in, and thank you for getting us over to 300 likes. We have 303 likes, so appreciate that, you guys. Let's see. All right, so now we are going to end. Forrest, I just want, wow, 17 months. Forrest, thank you so much for that. Thank you so much for that. Dave, good to see you. Thank you. Forrest Nelson, 17 months as a member. Really appreciate that. Thank you so much for that. And Dave, Smoky, Oregon, are the fires still going? Wow, fires are still going. I'm assuming that's Canadian. Are the Canadian fires still affecting you? Carol, love this channel. Thank you for providing great cases. Thank you, Carol. Appreciate that. And Wyatt, yeah, Carlos Reales Dominguez. Definitely check that out of UC Davis outside of Sacramento. Definitely check that out. He took the stand in this first trial. He took the stand, and there were a lot of experts, at least 5 or 6 experts that testified on his behalf, and it was a really good case study on what happens. What happens when somebody has a psychotic break. All right, this one has a lot of this one has a lot of stuff going on at the beginning, but it does calms down a little bit. All right, you'll see this has a lot. this has a lot going on. All right, so I think it does calm down. I think the talking head goes away in a little bit, but this one has a lot. So just bear with me as we go through this. All right, so this is placement hearing, March 13th of 2026.
To their faith and to God. And so they went out to the lake with their children to perform certain acts to prove their faith. They tried to walk on water. When that didn't work, she ultimately threw her 4-year-old son in the lake and he drowned. She was found, and God will be home. That's
whole hearing is really spelled out.
So let's take you now live to the placement hearing of Ruth Miller.
Have scheduled it. The purpose is, I think, clearly spelled out in 2945.40A. It talks about the trial court shall conduct a full hearing to determine whether the person, meaning you, is a person with a mental illness subject to court order, or a person with an intellectual disability subject to institutionalization by court order. And for this hearing, many of the same rights apply that would apply at a criminal trial, in that clearly you're entitled to counsel, and you are certainly been well represented here in this matter by Attorney Friedman. You have the ability to call in witnesses, and if those witnesses would not come in, there's even subpoena powers that would allow for that. But I don't think any of that's necessary today as far as subpoenaing witnesses in. I think everyone's been able to secure the witnesses that they intended to have this hearing. But just to be sure on that point, Ian, has the defense been able to secure the necessary witnesses that they believe that would be needed for this proceeding?
We have, Your Honor, and we anticipate calling in order Dr. Dan Buffington and then Dr. Susan Hatters-Friedman here today, live there behind me.
Thank you. At this hearing, I know the state is also prepared to call in witnesses as well. And Dr. Merritt, is it? Correct.
But before we even hear from either the state's or the defendant's witness in this case, I believe also appearing by way of video is Dr. Renko. Dr. Renko, can you hear me okay?
Yes, I can. I just turned on my microphone, so I hope you can hear me.
I can hear you just fine. I'm going to confirm with the other folks in the room to make sure that they can hear you all right. Fred, are you able to hear him okay?
Yes, sir.
And Ian?
Yes, Your Honor.
Great. I thought so, but I just wanted to confirm that. I think for everyone's benefit, the order that we will be going in, well, Dr. Renko, Dr. Merritt, and then however the defense wishes to proceed with their witnesses, will be able to do so as well. And just so the record is clear also, before going out here onto the record, we had a very brief discussion in my chambers regarding having witnesses remain present throughout the proceedings. I think both the state and the defense had asked that if it possible, could their witnesses remain throughout the proceedings? And I'd indicated I have no opposition to that if that's what the parties would like to have done. Fred, is that correct?
That's correct, Your Honor.
And Ian?
That is, Your Honor.
All right. Then with that, I believe we are ready to proceed with our first witness. And Dr. Renko, just so that you know, if I might have left you out as far as one of those wanting to remain present throughout, you are certainly welcome to remain present if you want, but we're not going to be offended if you log out as well.
I understand.
I'm going to begin with the administration of the oath or affirmation at this time. Thank you. Dr. Renko, do you swear or affirm the testimony you are about to give in this matter is the truth, the whole truth, and nothing but the truth? If so, please indicate by stating either I swear or I affirm.
I affirm.
All right. I'm going to allow the state to proceed with any question that they would have for Dr. Renko first, followed by the defense.
Your Honor, at the beginning, at the outset, I just would note for the record that Dr. Renko had issued a report, a follow-up report for the court. It's, let's see. It is 8 pages in length. It was issued on March 10th after an evaluation on March 10th. It's my understanding we will be jointly admitting that with the parties.
Is that correct, Ian?
That is correct.
Okay, thank you. And I have a copy here as well that was provided to me.
Where would you like me to, where's easiest?
Good question.
So that he can see.
Yeah. Why don't you do this? I think there is a podium that's easily moved to your left. Maybe if you bring it out a little closer to the table, and
this podium.
Try that one. You definitely. Moving the Nomad would be a challenge.
Yeah, so, it's not a problem.
How about this, Doctor? The assistant prosecutor is to my left. Are you able to see him? Most importantly, I'm sure you'll be able to hear him, but can you see him at all?
I cannot. I see the defense attorney and Ms. Miller is in the very edge of the frame. I cannot see anything further around clockwise for that.
I think it might be best, if you just move the podium a little bit instead of rotating the camera at this point. That's good. How about that? Is that?
There we go.
Okay.
All right. That's what we'll do then.
Good morning, Doctor.
Good morning.
Could you state your name for the record and spell your last name?
My name is Daniel D. Horinko, spelled H-R-I-N-K-O.
And Dr. Horinko, where do you work and what do you do?
For the purposes of this evaluation, I am a forensic psychologist in independent practice, contracted with the Forensic Diagnostic Center for District 9 in Cambridge, Ohio, conducting evaluations for numerous counties in eastern and southeastern Ohio through the Department of Mental Health.
Now, what specific educational background do you have that allows you to hold that position?
I have a doctorate in clinical and I have a doctorate of professional psychology focusing on general clinical with the subspecialty of forensic work awarded in 1995. I've been licensed as a psychologist in Ohio since 1995, and I have been conducting forensic evaluations for 31 years, with the last 20 years being exclusively a forensic practice throughout the state of Ohio. I maintain ongoing continuing education units of at least 9 hours every year to remain affiliated with a certified forensic center in the state of Ohio.
This time I'd ask that Dr. Renko be qualified as an expert in forensic psychology.
No objection.
Okay, so noted.
Dr. Renko, you know we're here on the case of Ruth Miller.
That's correct.
And you've had 2 occasions to interview her.
That is correct. I met with her in late 2025 regarding, in response to orders from this court regarding an opinion pertaining to competence to stand trial, and if my initial impression was that she was likely to be competent, to then evaluate her regarding her mental status at the time of the offense. I produced 2 reports separately to the court addressing those 2 issues.
And you know that based on your reports and the reports of others, that Ms. Miller was found not guilty by reason of insanity last Tuesday by this court.
I was made aware of that when I was contacted by the Forensic Center indicating that the court had made this finding and assigned me to conduct this follow-up evaluation regarding the requirements set forth in 2945.40.
And your interview for that follow-up evaluation was on March 10th?
That's correct. I conducted that interview by way of video conferencing, and it was relatively short because I had previous history with Ms. Miller of getting history background, which was all conducted in person in late 2025.
Now, having conducted several, I'm sure, forensic evaluations, including commitment evaluations, what are the factors that you were looking for statutorily to determine what your opinion would be about Ruth Miller's placement?
Well, for purposes of this evaluation, I'm focusing on the first question is there a mental illness that has a substantial probability of impacting her ability to function in society? And if my opinion is that there is a mental illness, the next is to determine what the least restrictive setting would be to provide appropriate treatment for that mental illness, while also taking into consideration the safety of the community, which is somewhat different than the civil commitment statutes that prioritize individual functioning over the safety of the community.
And to make this determination, you based this upon your own 2 evaluations, and did you look at any other materials?
I was provided with copies of 2 evaluations conducted by other experts regarding her mental status at the time of the offense that were submitted to the court as part of the findings of not guilty by reason of insanity. Having access to that, it also provided me with reports from other records that I may not have been aware of, as well as the opinions of other knowledgeable experts regarding her current functioning, her functioning at the time, and whether or not she had a mental illness.
And those 2 reports that you reviewed would be the report of Dr. Susan Hatters-Freeman. And was that a report from February 17th of 2026?
That was one of the reports that I reviewed.
And the other expert report you reviewed would be a report by Dr. Christopher Merritt, issued January 28, 2026?
That is the other report I reviewed.
Based upon your review of those reports, the other materials that you mentioned that I believe are listed in your report from March 10th, and your evaluations, your individual impressions, did you determine whether Ruth Miller suffered from a mental illness?
There are clear indications that in recent months she has been experiencing debilitating symptoms often associated with mental illnesses. I typically do not go into the specifics of what a formal diagnosis may be, since a person's functioning is more the result of the impact of symptoms. In her case, she was specifically exhibiting delusional beliefs and following directions. There are also reports that suggest there were episodes of hallucinatory experiences, and that these debilitating symptoms of severe mental illness, clearly rooted in what could be considered a diagnosable mental illness for treatment purposes, severely impacted her ability to understand the nature of her actions. So the overwhelming evidence from the records as well as my observations is she does have a mental illness.
After making that determination, what factors did you consider in determining what would be a place for placement, the place of placement that is the least restrictive alternative available, consistent with public safety?
What I look for is the likelihood that this person is going to be able to be an active participant in managing their own mental illness. First and foremost is, are there indicators that medications, when appropriately prescribed, are helpful? I also look for indications of whether or not she is aware of the nature and extent of her mental illness. If she is aware and has insight regarding the nature of her actions when her mental illness is uncontrolled, the insight necessary to understand that she needs to be an active participant in managing her mental illness, and then looking at the supports that she needs from her surrounding environment to be able to maintain stability in that setting.
When you interviewed Ms. Miller on March 10th, was she medicated, and how was she doing?
She reported being medicated, and she appeared to be functioning well, and the medical records from the jail corroborated the fact that she appears to be functioning well within the jail environment with no behavior problems and no overt symptoms of mental illness that would be disruptive to her functioning in that environment.
With respect to insight into her mental illness, what did you discover?
I had concerns because her insight was very limited. Although she provided some basic factual evidence of understanding that she has a mental illness, she was unable to show an indication of being aware of what symptoms were associated with her mental illness, the impact these symptoms might have on her thinking and functioning. She was aware of the fact that she was taking medications, but had difficulty differentiating what the medications were for, and most importantly, she had difficulty providing a clear, logical, and rational explanation as to what the risks might be should she stop taking medications. So I would say her insight is very limited, and that she is responding to the external structure of the environment rather than being driven by an internal awareness or understanding about her mental illness that would allow her to be an active participant in corroborating with her treatment regime other than merely following directions.
When you talk about being an active participant in a treatment regime, would that include family support and a structure around her?
An active participant in their treatment regime is able to understand, in an abstract sense, the reason she's taking medications, the consequences of not taking medications, to be able to articulate the benefits of supportive environments and the services available, and see how all of that is leading towards the development of awareness, insight, and an independent ability to take responsibility for managing their mental illness with the supports. The environment provides the external structure, and at this time, her environment is very limited. It's safe, it's controlled, but there are no group therapies or individual therapies to help her develop these missing insights.
Thank you. Based on your evaluation of Ms. Miller, your review of the records, did you come to an opinion based on your training, education, and experience regarding the appropriate placement?
I did.
And what was that?
I am quite familiar with the state hospital system in Ohio, including Heartland Behavioral Health Care, and it's my understanding that they have extensive experience in providing evidence-based services to individuals, much as she is currently experiencing. They have individual therapy, they have group therapies, and they spend a lot of time helping individuals develop the necessary information, understanding, and insight into the nature of their mental illness, how it manifests itself, the importance of medications. They also work cooperatively with service providers in the community to help prepare for an eventual re-entry into the community, such as working with family members and community programs to prepare for that eventual supportive return.
Given the nature of the offense, did you have an opinion whether that should be a locked facility?
It should, because I would be concerned that with her limited insight, time away from a secure setting might put her in a position to make regrettable decisions about medications based upon her limited insight, which would then set the stage for a return of symptoms and the unpredictable, if not dangerous, behaviors associated with uncontrolled symptoms of mental illness.
Thank you. I have no further questions, Judge.
Attorney Friedman.
Thank you, Judge Nurse. Judge Nurse, I do have a question. I'm wondering if it would be okay to speak from the table. And the reason I ask is if I'm at the podium, I'm going to be right in front of the prosecutor, and he will not be able to see Dr. Renko.
You're more than welcome to question him from right there.
Very good. Thank you. Dr. Renko, good morning. My name is Ian Friedman, and I represent Ms. Ruth Miller. If at any time I ask you any questions that are not clear, just please don't answer. Ask me to repeat, okay?
I will do that.
All right, thank you. So, your determination when considering the best interest of Ruth and the community at large is to have Ruth Miller placed at Heartland Behavioral Health Care in Massillon, correct?
That is the facility that I believe is responsible for servicing individuals in her county who have this particular legal status.
Very good. And I'm going to just kind of go through a number of questions quickly that may just be an affirmation of what you just said, okay? All right. So, placing Ms. Miller at Heartland, I'll call it, you believe would benefit, she would benefit from further assessment there?
Yes, that is true.
Okay. And you believe that she would benefit at Heartland by making further adjustments in her treatment and also to her medications?
That is correct.
All right. And you would agree, just in general concept, that compliance with medication, compliance with the treatment regimen, and growth and understanding from that is aimed at eventually at reintegration into the community. Fair?
I believe that would be in her best interest to provide that path towards that eventual possibility.
Okay. Now, would you agree with me that prior to the tragic incident in this case, Ruth did try to get treatment on her own, trying to figure it out kind of on her own without great assistance?
It's my understanding that there was a meeting of friends and family where concerns were expressed and that she had agreed to seek services. And I also believe that there was some medications in the form of antidepressants from a family physician, not a psychiatric or mental health provider.
Okay. Did you look or study kind of that area of what medication she received, the efficacy of it, and how it may have impacted the incident in this case?
I'm a psychologist, not a physician or a pharmacologist, so I'm not really qualified in an expert sense to be able to evaluate the effects of medications, other than the fact that I reported what she was prescribed and I reported what she was taking and what she did. Whether or not there is a connection between that requires expertise beyond my training and license.
Very good, thank you. And I think that you had stated during the direct examination, and you would continue to agree with me, that Ms. Miller has been fully compliant with all direction in all of the facilities that she's been in, whether it's been Marymount Hospital, the initial hospital here, or the Tuscarawas County Jail.
The records indicate that she has been fully compliant and never exhibited any oppositional or problematic behaviors.
Now, when Ms. Miller was originally brought into the hospital on the date of this incident, would you agree that she was in a psychotic state based upon the records you've reviewed?
There were clear indications that she was exhibiting symptoms consistent with psychosis, such as delusional beliefs primarily, as well as possible hallucinatory experiences.
Right. And you've met with her and you've reviewed certain records in this case. Would it be fair, and I understand that your expertise is not with medications, but you've dealt with medicated people before, correct? You have a familiarity with it.
I do.
All right. And you would agree that her condition as of this date, where you and I are speaking now, her mental state has improved from where it was on the date that she made original entry into the system?
Well, I'm not aware about her functioning today, but when I saw her on the 10th, it was significantly improved from what was described in hospital records, and I would attribute that to a large extent to the fact that appropriate professionals have provided medications.
Very good, thank you. Now, you had talked about lack of awareness that Ruth may have. Do you know whether or not services have been provided, or more specifically, has anyone in the jail engaged in any discussion with Ruth Miller as to the medication she's on, what they are, their effects, and so forth, to give her that better insight that you were addressing during direct examination?
I saw no evidence in the records of any specific counseling focusing on that beyond what would be expected from the medical professional administering and providing the medications. There's no evidence of groups or other specified or targeted interactions to help with this.
And in your experience, you would expect that she would get that sort of attention at Heartland, fair?
I believe that is an essential part of their core programming.
Question for you, Doctor. As it relates to cases involving not guilty by reason of insanity, if you could estimate for me, how many cases have you dealt with NGRI findings in murder cases, or serious felonies for that matter?
Probably somewhere between 100 and 150 in my career.
Okay. And would you consider, prior to the incident in this case, so this is the incident that brings us to the court, would you consider Ruth to be untreated at that time?
There were no indications that she was receiving significant services, because I believe she had taken the antidepressants for a period of time, but had stopped taking them several months prior to the incident offense. So I would consider untreated at the time of the incident offense.
And we talked about no incidents with Ruth Miller, but to date, would you agree that all indications point to Ruth being receptive to her medical and mental health care while in the Tuscarawas County Jail, up until the point that you met with her?
I saw no evidence of her being resistive or questioning that.
Now, you did state during your direct examination that you did not make an official diagnosis, that's correct?
That is correct.
Would you agree that there was kind of a variety in diagnoses that were made between the mental health professionals, ranging from bipolar to schizophrenia?
Those are diagnoses of which I was aware, and I reported several of them in my report, because this cluster of symptoms falls under several diagnoses that are similar in many ways yet different than others.
Thank you, Doctor. Now, your conclusion on page 8 of your report, so the final page, includes reference to a lengthy process, quote, lengthy process. My question to you is, until someone is in treatment and we are able to determine how they've taken to it, how they've received it, how well they have responded to it, one cannot really know how long the person should be in that level of treatment. Fair?
That is true, and that is why there is a process in place for the treatment staff, such as exists at Heartland, to continually update, reassess, and to provide feedback to the courts on a person's progress, so that when they and their experts make a determination that maximum benefits may have been reached, then the court can then reconsider the question regarding placement.
Very good. And so I guess just your choice of words as to lengthy was just more so, obviously we're not saying a day or two, we're talking about the time necessary to ensure that Ruth is safe to herself and others. Fair? And whatever that time may be.
Yeah, the intention of using that word was to indicate that this is not something that will be done in several days, several weeks, or not even likely in several months. My past experiences with doing evaluations with people transitioning out of hospitals indicate that the necessary steps will likely take, a minimum of a year, if not many, many more, depending upon her situation, her progress, and all the variables that the hospital can speak to.
Very good. Doctor, thank you so much. Enjoy your weekend.
Fred, any redirect?
No redirect.
Okay. And Doctor, I don't have any questions for you either. Your testimony is complete at this time. Again, if you wish to remain a part of the hearing, that is your decision, but your testimony is complete at this time.
Thank you much.
Oh, and Doctor, I wanted to also let you, if you're still there, I wanted to let you know that your ability to turn around the report in such a rapid time period is greatly appreciated. I know you're busy, but with the short time frame that we're given, we needed it, and you provided it. So thank you.
Judge. Well, you hit me on a good day when I had a gap in my schedule, and the jail was very cooperative in getting this scheduled. So.
All right. Thanks again.
Judge, I think I'm blocking Attorney Friedman.
Okay.
So, is there any objection to me questioning from the table?
No,
as long as they
not
can
at
see
all.
Me?
Yeah. And they don't have to see you. It helps, but if you want to slide down another seat, Fred, however you want to do it.
If it works, we'll have Dr. Merritt.
Okay. Dr. Merritt? Hi, Dr. Merritt?
Good morning. Can you hear me okay?
We can hear you. I'm not sure okay what I'd put on it, but I can hear you. It sounds a little distant maybe?
Yes.
How about now?
A little better, yeah.
A little better.
Yeah. We'll give it a shot, Doctor. I think the bottom line is that we can hear him, though. So you can hear him, can't you, Fred?
I can.
Yeah.
Can you see me, Dr. Merritt?
You were a bit off screen.
Okay.
That might be as best we can get Fred for you.
Okay, that's fine. I can see you, so I apologize. We're doing the best we can. Can you state your name for the record and spell your last name?
Fred, before he starts stating anything, I need to swear him in.
Okay.
So one moment.
Good point,
Doctor, we're going to begin with the oath or affirmation. Dr. Merritt, do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth? If so, please indicate by stating either I swear or I affirm.
I affirm.
Thank you. Assistant Prosecuting Attorney Fred Scott is going to be starting off with the question.
Thank you, Judge. Before I start, Dr. Merritt did issue a 22-page report on January 28, 2026. I believe it's already been admitted, and he did have his opinion in that report regarding placement.
Agreed, Ian.
Thank you.
Yeah.
And then also I provided his CV to the court, to Ms. Hyall, and we've agreed to the admission of all the CVs.
Okay.
Thank you. Good morning, Dr. Merritt.
Good morning.
Could you state your name for the record and spell your last name, please?
Christopher Paul Merritt, M-A-R-E-T-T.
And you are the Director of Forensic Psychiatry at the University of Cincinnati?
Yes, I am.
And what is your educational background that allows you to hold that position?
I completed undergraduate studies at the University of Notre Dame. I completed medical school and graduate studies at the Ohio State University. And I have trained at the University of Cincinnati for a psychiatry residency and forensic psychiatry fellowship.
Do you hold any licenses and board certifications?
Yes, I am licensed in Ohio, Kentucky, West Virginia, and Oklahoma. And I have board certification in adult general psychiatry, forensic psychiatry, and addiction medicine.
Have you testified in courts throughout the state of Ohio?
Yes, I have.
And as an expert in forensic psychiatry?
Yes, I have.
And has that testimony been accepted?
Yes, it has.
Would move that Dr. Merritt be declared an expert in forensic psychiatry.
Without objection.
It'll be noted then.
Dr. Merritt, you were hired by my former boss, Ryan Steyer, to conduct an evaluation of Ms. Ruth Miller.
Yes, I was.
And that was to determine her mental status at the time of the offense, alleged in the indictment. And you did issue the report we discussed on January 28, 2026.
Yes, that is correct.
When you issued that report, did you have an occasion to meet Ms. Miller before that report?
I did. She met with me at my office in Cincinnati on January 7th, and we spoke for about 4.5 hours.
In addition to that meeting, did you review other items that you included in your report to help you with your assessment?
Yes, I reviewed materials related to her legal matters as I outlined in my report. I reviewed records from her emergency room visit and her hospitalization, and I reviewed jail treatment records.
Based on that review, do you have an opinion, based on your training, knowledge, and experience, if Ms. Miller suffers from a mental illness?
Yes, I do. It is my opinion that she suffers from bipolar disorder.
You also mentioned it's bipolar disorder with psychotic symptoms or attributes?
Yeah, that is correct.
Can you
at the time?
No, I was just going to ask if you could explain the reasons for your diagnosis or summarize them for the court.
Yes, at the time of the offense, I believe that she was in a psychotic episode. So that's the psychotic features, and I also believe she had severe mania. Anytime you have mania that leads to a psychiatric hospitalization, it's categorized as severe. And anytime you have delusions or hallucinations, that is the psychotic features part. But what she described to me was that for 1 to 2 weeks preceding the offenses, she had shortened and erratic sleep. There were some nights she had 2 or 3 hours of sleep. And she described in her own way what seemed to be a euphoric mood. For example, it was like getting married all over again. And so that's one of the hallmarks of bipolar disorder, is that there is a disturbance of the mood. Oftentimes there can be depression with that, and she described to me at times prior to that and after that having episodes of depression, but around the time of the offenses, a euphoric mood. She also had beliefs that I considered grandiose, belief that she could walk on water, suggestive of powers that she felt she had at the time that she wouldn't and didn't at the time that I interviewed her. She wouldn't ordinarily have that. She described having racing thoughts, and she described being distractible. So in my mind, I thought she met the criteria for bipolar disorder, Again, at the time, it was with mania and psychotic features.
Now, you've reviewed other reports, including reports issued by Dr. Parenko, and you saw his testimony earlier. He did not issue a diagnosis, and then there was two reports issued by Dr. Hatters-Friedman. Have you reviewed her report?
I did. I reviewed those after I submitted my report.
And to some extent, your diagnoses differ. Could you explain why that may not be uncommon to the court?
Yes. Well, I would first highlight how they are similar. Neither of us disagree that Ms. Miller has had episodes of depression and it's been severe and caused problems in her life. Neither of us, and none of the three experts would disagree that she's had symptoms of psychosis. Again, meaning delusional beliefs about reality that aren't true, hallucinations, hearing voices. None of us would disagree on those things. I think that the disagreement is whether there was the presence of mania, which again is a short 1 to 2 week period where you might not have sleep, you might have either elevation in your mood or irritability in your mood, and have the other symptoms that I described. We disagreed there, but at the essence, we both agreed that she had dysfunction related to her mental illness, depression, and psychotic features.
You heard Dr. Parenko's testimony regarding lack of insight into her own mental illness at this stage. Do you have an opinion based on your review of the records as to Ms. Miller's insight?
She had some insight. My opinion is that it was cursory. She's not had the education that I think she should have given the severity of her illness and what happened. But she had some insight. So, for example, when I interviewed her, she told me that I take olanzapine, a medication, and she said it was for bipolar disorder. She had some awareness that she had been diagnosed at the jail with bipolar disorder, and I believe her description of that, if I'm quoting it correctly, was that bipolar disorder can cause a lot of highs and lows. And so she has some awareness and some insight, but it's not to the extent that I would appreciate having to adequately mitigate the risks and to really understand her condition.
And Ms. Miller did have these insights actually that existed prior to this incident that brings us here, and she did seek treatment.
Yes, she did. And my awareness was both the same as Dr. Parenko, where her family and spiritual community members encouraged her to get treatment. She told me she had also spoken with a family member who had had her own treatment for depression, and I believe that was one of the things that prompted her to meet with her family doctor and be prescribed the antidepressant medication. So she had some awareness months before the offenses that she was having mental health issues.
On her own, with respect to treating her own mental health treatment, there's evidence that she went to a non-evidence-based treatment facility or had scheduled an appointment with that. Did you learn anything about that?
Yes, there were actually two. My understanding is she met with a chiropractor who had prescribed her treatment, such as special diets and supplements, and it wasn't exactly clear what that was to address. There was some notion that perhaps there were toxins from her house. There was some notion that perhaps she had infections, but that was part of the initial sort of treatment that she sought out. She told me she had also scheduled a, quote, brain scan with a facility called Gilead's Balm. And from what I've reviewed, the sort of treatments there would not be appropriate for the treatment of bipolar disorder.
Also, prior to this happening, she did receive warnings or an intervention of sorts from her faith community, yet her mental illness was so great, or her psychotic episode was so great, that psychotic episode overrode those warnings. Is that clear from your records?
Yes. Based
on your review of Dr. Branco's report Dr. Hatters-Friedman's reports and your own review, do you have an opinion regarding the placement Ms. Miller should have that provides adequate treatment, is the least, and is also the least restrictive to her with consideration of public safety?
Yes, it is my belief that the placement that would best provide that treatment and risk mitigation, as well as allow her the least restrictive settings, would be at Heartland Behavioral Health Care.
And why did you make that conclusion?
There were several factors I considered. Certainly the court needs to consider the public safety, and so I considered the magnitude of what's happened to lead us to this hearing. I also considered her need for psychoeducation, as I've described, having a greater understanding of bipolar disorder, what it is, how to manage it. I also believe that there is room to continue a diagnostic evaluation. I believe with a reasonable degree of certainty that she has bipolar disorder, but as you've laid out here, other experts may disagree. The hospital did not diagnose her with that, but the jail did. And so I think some time in the hospital to really get, really sort that out and have time to observe and meet with her in depth could help solidify that. I think there are other diagnostic things that may need to be performed as well. Both Dr. Hatters-Friedman and I had noticed the potential hormonal changes that she's had with her obstetrical and gynecological history. She also has several family members that have a genetic disorder that can cause psychiatric issues, and my understanding is Ms. Miller's not had testing for that. So there are things from a diagnostic and evaluation standpoint that she may need done while in the hospital. It's also important in the hospital setting, and there are experts at working with the support system, but there's a need to really mobilize the community support system for her to prepare her for eventual conditional release. Part of that is working with her family members, part of that is within her spiritual and cultural community, and part of that is within the mental health system outside of the hospital. But that all needs to be coordinated and worked on in a safe setting, and I believe that can be done at Heartland.
Thank you. I did want to touch on the genetic symptom that you mentioned in your report, the MAS syndrome. Can you explain that for the court, and can you explain why you believe that a screening is necessary?
MAS syndrome is a genetic disorder. It's otherwise known as autosomal recessive spastic paraplegia 21, which can lead to a variety of neurological issues. Some of them are psychiatric in nature. It can lead to cognitive decline, dementia, and some of them are motor neurological, so paralysis, spasticity, other sorts of motor neurological symptoms. Ms. Miller reported to me that she had numerous siblings that had been afflicted by that, and had said that usually her siblings had that in their 20s. From what I've read and know about MAS syndrome, though, some people have the onset in their early 40s. So I'm not by any means saying that Ms. Miller has that. On the other hand, I do believe that it would be important for her to meet with an expert in that, perhaps a geneticist, who could determine whether she needed further testing given her family's history of that, and given the fact that sometimes that could precipitate the sorts of psychiatric issues that we are seeing with her.
Thank you. I have no further questions, Judge.
Attorney Friedman.
I don't have any questions. Thank you very much.
Dan DeRose with 19 News. Sorry for the interruption. Some of you may experience our 11 o'clock news coming on. If that happens and you're streaming this, you can always go to our breaking news live stream channel on your app, and you'll be able to continue watch this. Some of you will experience, some won't. If you see all of a sudden our 11 o'clock news come on, switch over to our breaking news live stream channel.
Fred, just to confirm, the state did not intend to present any further experts, any other evidence, correct?
No.
All right. Then at this time, I'll turn to the defense and Ian.
Your Honor, I would call to the stand for testimony Dr. Daniel Buffington.
Okay, Dr. Buffington.
Here.
Come on.
Now, I don't know if you'll be able to see that much of the back.
That would be typically where the questioning would take place. But I guess the overriding rule is wherever you're comfortable, I'm fine with.
I'm fine back there.
Dr. Buffington, I will administer that oath. If you please raise your right hand. Dr. Buffington, do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth? If so, please indicate by stating either I swear or I affirm.
I affirm.
Thank you.
Good morning, Doctor.
Good morning.
If you would please state your full name, spell your last name for the record.
Yes, sir. Dr. Daniel E. Buffington, Buffington.
Dr. Buffington, what is your professional title?
I'm a clinical pharmacologist and toxicologist.
And where are you located? Where do you practice?
I practice in Tampa, Florida. I'm on faculty with the University of South Florida's Colleges of Medicine and Pharmacy, and I have and manage a specialty practice called Clinical Pharmacology Services in Tampa.
Can you tell us what is a forensic pharmacologist?
So pharmacology is the study of medications, substances, natural substances, synthetic, even biologic agents, chemicals, hormones, proteins, substances that the body produces as therapeutic agents. But we also study and have to be fully acclimated to the adverse side effects, the toxicities, the complications, interactions. So forensic is the application or bringing those answers or explanations into the court.
And if you could, please tell me about your education that brought you to being a pharmacologist.
Yes, sir. I did my undergraduate studies at the University of South Florida in Tampa, a native of the Tampa Bay area, in biology and biochemistry. I did a Doctor of Pharmacy or PharmD degree at Mercer University in Atlanta, Georgia. Subsequent to that, I did postgraduate specialization in residency and fellowship in clinical pharmacology, and I've also completed an MBA with a healthcare focus.
And what sorts of certifications, licenses, so forth do you carry?
I'm licensed in both Florida and Georgia.
And your practice, obviously, you're here in Ohio, is not just limited to Florida and Georgia, but if you could tell the judge about your practice as far as breach is concerned.
Yes, sir. So I've done testimonies in federal, state, court, plaintiff, defense, criminal, civil, family court. Pharmacology finds its way into all those settings. And it's been all around the country and a few international locations as well.
Do you hold any degrees for any other types of specialties beyond pharmacology?
No, sir.
And have you been a lecturer or an author on subjects regarding forensic pharmacology?
Yes, sir. Since graduating in '87 and residency and fellowship by '89, and teaching, I've authored numerous textbook chapters, publications, research, and the research results.
And if you could estimate in the course of your career, how many cases that you've dealt with regarding pharmacology? More than 1,000, less than 1,000?
I don't have an exact count, but I'm sure it's been 40-some years between 500 and 1,000.
And you had provided a report previously dated February 24th, 2026, regarding the matter of State of Ohio versus Ruth Miller, correct?
Yes, sir, and I've got a copy with me.
Okay. And you had previously provided a curriculum vitae with that report, correct?
Yes, sir.
Right. And everything that's stated in that CV is accurate?
Yes, sir.
Okay. And up to date?
Getting ready to produce a next version, working on that right now.
Your Honor, I would ask that Dr. Buffington be recognized as an expert in the area of forensic pharmacology.
No objection to such recognition, no objection to his report or his CV.
Okay. It will be recognized then.
All right, so Dr. Buffington, if you could, please tell us how you became involved in this case.
Yes, sir. I was contacted by your office specifically to provide insight and background into Ms. Miller's case. From my perspective, looking at her past medications, past history leading to a period of treatment. I saw a period from about 2020 to 2025 where there was progressive development and presentation of mental health symptoms, ultimately receiving therapy from, as we've heard today, a family practice location. I want to say it was around March of 25 up to May of 25, different office interventions, different medication. A specific medication that was utilized then was sertraline or Zoloft, a very common introductory starting point for the treatment of basic depressive disorders. So I was looking at medications, but then also how those medications performed or complications or reactions, and then ultimately what her condition would have been at the time of the incident in August of 25, and then as additional insight, her response to more appropriate therapy following the incident.
Now, we'll get to your opinions and conclusions shortly, but you did make some, and you did include those in your report. My question to you is, what did you do in this case, and what did you review to allow you to formulate those opinions and conclusions?
Yes, sir. There was an abundance of personal information about Ms. Miller and her past. There were medical records. There were sheriff's reports. There was video of her appearance and presentation during questioning following the incident. And then additional medical records from corrections department as well.
Okay. And you were able to speak with Ms. Miller?
Yes, sir. I did an interview with her.
Okay. And can you please let the court know approximately when that was and how long that discussion was, please? That interview, I should say.
Yes, sir. I'm having to recall for the date.
It's in your report?
It is, yes, sir.
And do you recall approximately how long that interview was?
It was approximately an hour and a half.
Were you able to, based upon everything that you reviewed in this case, based upon your discussion with Ms. Miller, did you formulate any opinion related to a diagnosis of Ruth prior to the incident that is the subject of this case, State of Ohio versus Ruth Miller?
Yes, sir.
Okay, and what was that?
That was that she had progressive and debilitating mental health symptoms that culminated in her seeking medical care, and that was the care provided in terms of the medication would have been an incorrect or an insufficient approach to treating those symptoms. We have additional insight on that by seeing how she's responded and having greater level of specialty evaluation subsequent to the incident. But that was insightful. The other issue around the use of sertraline as a single or monotherapy for her condition is it's actually known to potentially worsen the condition. So sometimes in general practice we see this when a medication, psychiatric medication, so antidepressant, anti-anxiety, antipsychotic, when a medication that affects the brain's chemistry is added, it's about a 2 to 3 month window where the receptors in the brain, the chemicals called neurotransmitters, are disrupted. So it takes, many times we see, and we saw it in this case even, is there's a period of the patient having to adjust to, become acclimated, and encouraged to be compliant through those side effects before the therapeutic benefit appears or manifests. So that same principle of disrupting the receptors is true when you start a medication. When we do a dose change, we reset that clock of 2 to 3 months. And when you discontinue a medication, it takes up to 2 to 3 months for the brain to reacclimate. So in this case, if you've taken away, so somewhere in late May, June, there was termination. There was a couple of attempts at dose adjusting the sertraline, and then it was discontinued due to complications or side effects or her condition at the time. That is almost textbook to the time frame when this incident occurred. So the selection, the handling of that first medication actually set up the conditions for something like this, and we see this in clinical practice routinely. So it was that incident where the symptoms, her mental health symptoms, had progressed and graduated to a point of greater psychotic symptoms and the mania. It was not until after the incident when she was in a more formal care setting. We heard that she was in the hospital. We heard that she was also treated more regularly in a controlled setting with corrections, medical, that a more appropriate regimen, more consistent for treating what she has in terms of mental health presentation. That was Zyprexa and Buspar. Those are two medications that work well together and work good for her chief mental health complaints. So what we see pharmacologically is the early medication approach may have worsened the condition. Timing-wise, it's consistent with what we saw. But then post-incident, she's in a better situation in terms of medications. We heard this morning about the understanding what each medication does, understanding the mental health symptoms and condition. We frequently refer to that as mental literacy, or medical literacy, or medication literacy. Does the patient actually understand what they're taking things for and how to take them properly? And in this case, what would happen if you independently discontinued? And I do think that that's an important part of this case and the opinion, is that that's a critical role for Ms. Miller.
Thank you. So you're talking about clinical roles and so forth, and I'd like to know your opinion on whether or not there was a proper interpretation of the clinical picture leading up to, if you could tell the court what that is, and then talk about whether it was proper prior to the incident. If not, why?
So it was clearly not proper. As I mentioned before, attempting to use a product like Zoloft, which is in a category called an SSRI, a serotonin receptor uptake inhibitor. That is a known potential trigger because it's not helping to control all of the areas, all of the chemicals and receptors in the brain needed for the type of condition, the bipolar disorder. As we just heard with Dr. Mammer, it's very important is that bipolar can represent or present itself with very low, deep phases of depression or very accelerated, disorganized thought of mania. In both those cases, it's important before making a medication selection to really properly work that patient up to look for those symptoms. And in fact, between the time that the Zoloft was discontinued and the time of the incident, it appears that those symptoms actually worsened and became more obvious. So there was a lack of proper mental health diagnosis and treatment prior to the incident.
And would that also, the proper picture in what you were just discussing now, if the diagnosis were schizophrenia accompanied by some other conditions, what was the picture then?
It does appear to be present as the symptoms we would look for to be hallmark for that would be the disorganized thought, the hallucinations, both auditory and visual. Those are things more detachment from reality and misperceptions of your surroundings would be more consistent with psychosis or schizophrenia.
All right. So now I preface this question with a statement, and I think you'll agree with me, that no one knows for sure. But my question is, had Ruth been receiving different medication, different treatment regimen, medication regimen, that would have better fit her mental health condition prior to this incident, would that have affected the likelihood of what occurred, or even the likelihood of it occurring at Atwood Lake?
Yes, I would couch that as more likely than not we would not be here for this issue today.
Right. Now, after Ms. Miller was arrested, she was treated with various medications, and you had just named the two medications that you said seem to be working certainly better at this point. Were there other medications that were given her early on into her custody?
Yes.
Okay. Do you recall what those were and how she responded to those?
Not as well. I don't have the list in front of me of what each sequence, but I would concur that the combination of Zyprexa and Buspar are certainly more appropriate given their applications and where in the brain that they affect. But that that's not the whole picture, is that seeing the clinical improvement on this combination, there could be additional benefits from either dose modification or adding or modifying one of those with another medication. That comes with ongoing therapy and the obvious benefit of counseling and working through those disorders.
Very good. Do you have an opinion now as to what medications Ruth should be taking, or dosages may be different from what she's doing?
That would come from sequential visits and being able to see the individual from appointment to appointment. But clearly, compared to both what I saw in other experts' reports with what I also was able to ascertain during the clinical interview, that she is in a much better place now than prior to the incident, but highly encourage the enhanced therapy that would accompany additional care.
And Dr. Buffington, what would be your recommendation for kind of the ideal future care and pharmacological management?
I do think that a residential scenario like we heard discussed in terms of a state facility would be optimal. I don't think there's an ideal prediction. I think Dr. Horenko's statement of I don't think we're talking about weeks to months, because what you want to see is the increase in that patient's literacy or understanding of their condition, of support networks, of compliance with medication as a critical part of that. But even if dose modifications, changing to a different medication are necessary, I would think that you're at least looking at a year, but there's no way to predict. The ultimate depends on those who are treating her and see her level of improvement with the combination of medication and therapy.
Very good. And when you say a year before what? Because you're not suggesting that there's treatment, then everything's solved, and there's nothing following that. What are you making reference to? I'm
making reference to both the time it would take to continue to evaluate if there's need for modifications. Once you have reached the point of stability, then there's time to see how that is doing from assessment to assessment. So I think it's assuring stability and her level of literacy on both the medications and her condition.
Okay. Now you heard the testimony of the recommendations regarding Heartland Behavioral Health Care.
Yes, sir.
Very good. And this is just all it is. Okay. That's all it is. May I approach the witness, John?
Okay. This is just the way. There's two. Oh, all right. There you go.
The same report.
No, it is not. This is actually not important. This is nothing more than just a printout for Heartland. And I just wanted to ask him a question. Okay. Handing you Defense Exhibit C, if you would just take a quick look at that.
Yes, sir.
And I'd ask you to look at the services provided by Heartland Behavioral.
Yes, sir.
So we heard the testimony, the recommendations that would be placed at Heartland. And what I've handed you is the printout from Heartland as to the services that they provide there. Are those the sorts of services that you feel would best benefit Ruth Miller?
Yes, sir. And just to elaborate is that there's a lot of mental health care takes place in primary care offices, but it's for very basic or introductory issues. The scope of what I'm seeing here would define specialty psychiatric care, and yes, sir, it would be an appropriate facility.
So, assuming that the community remains safe in that sort of setting, do you feel that a more restrictive setting is necessary than that which you heard today, Heartland Behavioral?
No, sir. It does appear to provide an array of specialty psychiatric services which can get to each of those issues adequately that we discussed.
And so would your recommendation, with a reasonable degree of certainty, be that she should be placed at Heartland Behavioral?
Yes, sir. It would appear appropriate.
And I'm going to ask a question that comes a little bit down the road, but while I have you here from Florida, if the court would allow, just have two questions on the issue of this. How can we ensure compliance with medications, both in that sort of setting and then once a lesser restrictive setting is put into play?
Okay, so very good question, because this does come up in clinical practice routinely. Not always emanating from the court, but sometimes in clinical scenarios as well. There's a combination of things. One is there's devices and instruments that we can give to patients that documents times of administrations. And you say, well, a patient could open the cap on a bottle and put the cap back on. There's some that document that with a photo and with a timestamp that's documenting that. That's one method. So there's delivery or packaging instruments that can do that. There's another level, and that's what I would refer to as therapeutic drug monitoring. So in our practice and many others around the country, we have to help to make sure, whether it's for psychiatric care or pain management or addiction therapy, that individuals are being compliant, both with taking and in some cases not taking other substances. So there's blood levels can be obtained to look for. So if a patient says, oh, I take that every day, and it's not in their system, we know otherwise. The other issue is the advent in the last probably 10 years has been with that helps tremendously with this, and that is the injectable long-acting medications, which means a patient can come to an office, have it administered by a practitioner, and then that medication is in their system with a sustained release system for a period of time. So there's a variety of ways for the court, should the court have an interest in that, to have a consultation with a practice like ours that looks at these options, continues to monitor in concert with, or provides guidance on different test or lab test or medication formulations that can help with that.
Thank you, Dr. Buffington. My last question for you is, having been involved with cases similar to this, in NGRI cases, I say this, my question is, assuming that someone is compliant with their medications, they've responded well to the mental health treatment regimen and so forth, how quickly can someone like Ruth be treated before you would suggest that a less restrictive setting be considered?
Could be months to a year, but I would just say that that's something left up to the practitioners who are evaluating the individuals sequentially. But months to a year would be an optimal.
Very good. I have nothing further.
No questions, Judge. No? Doctor, you may step down.
Thank you, Your Honor.
Ian, your next witness.
Yeah, thank you. Your Honor, I call Dr. Susan Hadders-Friedman.
Okay. Doctor, you may come up. With that oath or affirmation. Doctor, do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth? If so, please indicate by stating either I swear or I affirm.
I affirm.
Okay. Thank you.
Doctor, how do you prefer to be addressed? Dr. Hadders-Friedman, Dr. Hadders, or Dr. Friedman?
Dr. Hadders-Friedman or Dr. Friedman is fine.
Dr. Hadders-Friedman. And I think, importantly, one question we do have to get out of the way is, you would agree with me that we are not related and we've never met before this case?
Absolutely.
Right? Okay. Dr. Hadders-Friedman, if you would, please state what your professional title is.
Sure. So I'm a medical doctor, a physician, and I specialize in forensic psychiatry and reproductive psychiatry. As far as my position at Case Western Reserve University, I serve as the Philip Resnick Professor of Forensic Psychiatry. I'm also a professor in general psychiatry there, in reproductive biology, in pediatrics, and at the law school there as well. I also am director of the Division of Forensic Psychiatry at University Hospitals of Cleveland. As part of that work, I also do evaluations at North Coast Behavioral Healthcare, which is a forensic hospital in the Cleveland area. And then I also work at the Cuyahoga County Court of Common Pleas Court Psychiatric Clinic doing evaluations there.
Very good. And I appreciate you offering all of that, because I'm going to ask you just very general questions, so they are calling for kind of an explanation that fully captures your experience, okay?
Sure.
All right. If you could tell us, please, about your training that has brought you to your degree and level of profession.
Sure. So first, to become a physician, you attend college. I studied. I majored in chemistry in college. Then I went to medical school at Case Western Reserve University School of Medicine. Graduated from there in 1999. Did 4 years of psychiatry residency training, where you're working in the hospital under other physicians learning psychiatry at University Hospitals of Cleveland, Case Western. Then I did a fellowship in reproductive psychiatry, women's mental health research. After that, a forensic psychiatry fellowship at University Hospitals of Cleveland, Case Western as well.
And you've testified before?
Yes.
Okay. And you testified from a position of or in the capacity of what?
As an expert witness?
Is concerned.
You mean in
type of specialty?
Oh, as a forensic psychiatrist expert, yes.
Okay. Can you approximate for us how many times you've testified as a forensic psychiatrist?
Dozens.
And just kind of tell the court about your experience as a forensic psychiatrist. You've kind of talked about your training and so forth, but just as if you were going down your CV, I'm basically just asking you to address it. So
okay, sure.
Quite a bit there, and if I ask all the questions, we'll be here until late this afternoon.
Okay, so I've worked in different capacities in forensic psychiatry, but always with some reproductive psychiatry there as well. So a lot of what I've done is work with women, pregnant or postpartum women, and women and offending. I've worked for some years, in addition to being at Case Western, at North Coast Behavioral Health Care, running a women's unit, running psychiatric treatment unit for women, and for a period of time for men as well. I have also worked in community mental health in the Cleveland area with pregnant and postpartum women. My family moved overseas to New Zealand for about 7 years, where I also worked in forensic psychiatry and working with women. While there, I ran a women's unit for a while. I worked at the women's correctional facility, seeing and evaluating and treating women and writing forensic reports. I also worked during that time at the University of Auckland, where I did teaching and research as well. And also have continued to work at the Court Psychiatric Clinic in Cuyahoga County, doing evaluations of people who are charged with crimes for competency to stand trial, for sanity at the time of the act, for things similar to what we're here for today about their need for treatment after being found insane. And I also do research and teaching through my roles at Case Western. So I teach a course at the law school. I teach the psychiatry trainees and the forensic psychiatry trainees, and do some research. So I've done research over the course of years of mothers who have killed their children, as well as other types of research in our field. And I also do a lot of writing and teaching locally, nationally, internationally about that topic.
Thank you. And that topic is referred to as filicide?
Yes.
Okay. And if you could just give us a basic definition of filicide, please.
Sure. So filicide is when either parent kills their child or children. Usually it's children under age 18 who are still living at home who are killed.
And on the specific issue of filicide, you have not only taught, but you've lectured and you've written extensively on that?
Yes.
Your Honor, I would ask that Dr. Hatters-Friedman be acknowledged as an expert in the field of forensic psychiatry.
No objection.
So noted then.
How did you become involved in this case, Doctor?
Your office had contacted me.
And you're here today to determine whether Ruth has a mental illness which should be subject to court monitoring placement is what we're talking about, correct?
Yes.
And you did not find that there was any intellectual disability, did you?
No.
If you could, please let us know, discuss what you looked at to form any ultimate conclusions and opinions that we'll be talking about throughout this hearing here today.
Sure. So I met with Ms. Miller in November, in December, and in February for about 6.5 hours altogether. I also conducted interviews with various family members who had known her and who were able to give information about her functioning and mental health before the offending. Also, the legal information and the information from the police I reviewed, and I reviewed records from Marymount Hospital, from the Tuscarawas Jail, from Union Hospital, as well as the other reports in the case.
Okay. Now, you just made reference to the family, and you spoke to the family. Can you describe for the court your opinion of Ruth's level of family support at the current date?
Yes.
What is the time of your interview?
Sure. So I spoke with her sister, and I spoke with her father-in-law and her mother-in-law, and they were all very supportive of her, which, considering the losses that they had in their family, both of her son and her husband, seemed like very strong family support, even in the face of those losses.
Now, you spoke to Ruth while she was at the Tuscarawas County Jail.
Correct.
And just the two of you speaking in a small room?
So I spoke with Ruth at the jail in a small room. Also present was a forensic psychiatry fellow in training with me for that. Then I also, the second time I spoke with her on Zoom, and the third time the trainee and I spoke with her on Zoom. But the bulk of it was, yes, in a small room at the Tuscarawas County Jail.
Okay. And was Ruth engaged in the discussion with you and cooperative during the discussions with you?
Throughout, yes.
Now, you had set forth, you had authored a report on February 17th of this year, and in there you talked about Ruth's medical history.
Yes.
Correct? And what was, if you could talk about for a moment, the medical history that you captured in your report that you feel is relevant to placement hearing today?
Sure. As far as medical history, she had, around the time that she was pregnant with her son Vincent, she had experienced some physical symptoms, and she had to have gynecological surgery, and she also had been noted to report in some medical records that since around that time of the surgery, 2022, she wasn't feeling like herself. So that's one piece of things. Another piece of the stresses that is reflected in her medical history was the concern about mold in the home, and so she had mold, like MOLD. She had been having some physical symptoms, but as well some symptoms which could be mental health related, such as about sleeping, etc., which we've seen throughout her getting more mental health symptoms later. The sleep has consistently been a concern and an issue, and we can see lack of sleep can be a symptom of depression. It can also be like a warning sign that other mental health struggles like psychosis are going to get worse. So she had these physical symptoms, which some of which may have been psychological around that time as well, related to the mold. This was something that, when I talked with her family, was a huge issue in their life, and the house needed to be taken down. She needed to move her family of 6 into various different locations while the house was being taken care of, while a new house was being put up, and this was a big stressor as well. So that's in the medical history, but it's also in the stressors and thinking about mental health. And then, as Dr. Merritt mentioned, also she had this strong family history of this MAST syndrome, which she had also told me she hadn't been tested for herself.
Thank you. Were you able to obviously discuss the incident at Atwood Lake with Ruth Miller to help formulate your opinions?
Yes.
Were you able to make a determination as to what her psychiatric state was or her mental state was at the time of the tragic incident?
Yes.
And what was that and why?
Sure. So it's my opinion that she had both a psychotic disorder as well as mood symptoms. So psychosis is being out of touch with reality, and that includes, for example, hallucinations, hearing things that aren't there, sometimes seeing things that aren't there can be symptoms. Delusions are a symptom of psychosis. Delusions are fixed, false beliefs that are not consistent with the beliefs of one's culture. And there are a whole host of other symptoms we can see with psychosis as well. Ruth Miller at the time was truly believing that she was getting special messages from God about tasks that she needed to do to prove her devotion. She thought that there were miracles going on. She thought that the number 40 was important, and it had been important in the Bible, but she took a special meaning that it was her 40th birthday at the time of the alleged offending and leading up to it. She believed that the world was going to end in a delusional way, that she had been given these special tasks to do by God, like walking on water, and she actually tried to do that, believing that she was meant to by God. And then that the actual offending itself, there was the belief that these were tasks that God had told her to do, from keeping her foot on the pedal of the golf cart, driving it into the water. She believed that God told her not to take her foot off that pedal and wanted her to do that. She believed that all of these things were because of God in a delusional way. And hallucinations, the special messages that she was getting. Now, there was a notation in the hospital records after where she told a nurse that she had been hearing things for a year. So, and we also know that Ruth and her family were very private people. She had been trying to get help for a long period of time, but we don't know exactly when these symptoms all exactly started. But that was one indication that things had been going on for some time as well. The indication in a Holmes family medical record indicated that she hadn't felt like herself since 2022. So these psychotic symptoms going on for a period of time, and then the depressive symptoms that we know about going on for a long period of time. And so the diagnoses then that I made were other specified schizophrenia spectrum and other psychotic disorder, which is a very long name, but it is in the Diagnostic and Statistical Manual, the DSM of psychiatry, how this is best called, in my opinion, because we've seen this psychosis and psychotic symptoms. There could be, as Dr. Merritt discussed, some underlying genetic disease that we don't know about, but what we're seeing as far as the symptoms in front of us are these psychotic symptoms overlaid on this history of depression which she had.
Thank you. Now, you had made reference to the fact that, and you had heard Dr. Buffington talk about
Ruth trying to get care before the incident in this case. Were you able to discuss that and address that with Ruth?
Yes, she was someone who she recognized that there was something going on. She didn't have the words or the understanding to know exactly what was going on, but she was trying to get help. So she had gone to the family medicine doctor and gotten medication, which she had some problems with. That was one thing she had done. She had gone to the chiropractor and the holistic treatment folks to try and get some help for it as well. She had also tried to arrange for this brain scan. This is what she called it. There's not a clear indication of what this actually would mean, but she was trying. She said she was on a waiting list for the month after the offending in order to get this scan, which she hoped would answer what was going on and get her treatment. In addition to those things, she had sought a therapist, a counselor, but she had gone for an appointment and the person knew her family. And so she felt uncomfortable with that and didn't return, which is completely understandable. But she said during that session, the person said that they knew her father, and that felt uncomfortable for mental health treatment.
Sure. Okay, thank you. Now, how has the care for Ruth that she's received post-incident differed from that which was offered her prior to the incident, that which you just talked about?
Sure. So I think as we heard a little bit earlier, previously the family medicine doctor, based on what their understanding of the situation was, had prescribed the antidepressant Zoloft, which she had taken for a brief period of time, and which would not treat the diagnosis that whether one thinks it's bipolar disorder or whether one thinks it's a schizophrenia spectrum disorder, that would not be the treatment that she would receive afterwards, because that would not be the treatment for that diagnosis. So afterwards, she went to Union Hospital, and then she went to Marymount Hospital, and then in the Tuscarawas County Jail. So when she went to Union Hospital, they evaluated her. They gave her medications to help calm the agitation that she was having, and they also gave her an antipsychotic medication, Risperdal, which is certainly in the class of medication that's indicated when someone has a psychotic disorder. So she got that at Union Hospital. Then when she went to Marymount Hospital, they were more focused on treating her sleep. And then when she came to the Tuscarawas County Jail, they did some screening tests, and she met with a staff member on occasion, and they started Zyprexa, which is an antipsychotic medication, as well as the Buspar, which helps with anxiety. Of those, the Zyprexa is the important one because it's the antipsychotic medication which is treating the psychotic disorder which she has.
Thank you. We know that Ruth is housed in the Tuscarawas County Jail. We know that she's being treated well in the county jail. With that said, is she receiving, in your estimate as a professional in forensic psychiatry, is she receiving the best care that she can for her current conditions?
So no, jails don't have the ability to have the multidisciplinary treatment team like you would have in a forensic hospital. So she's getting medication, and she's met with someone on some occasions, but that's not everything that we would want someone to have in their recovery for the future.
Okay. And what's your diagnostic impression of Ruth at this present time?
So yes, she still has a psychotic disorder as well as the mood disorder. So it's this other specified schizophrenia spectrum disorder as well as the major depression, which she has.
Okay, Dr. Hedrick-Friedman, with the proper care, including medication, is Ruth's condition maintainable?
Yes.
Okay. Can you talk about the importance of medications? You have to have both components. You can't just have the therapy without the medication without the therapy. Talk about the importance of having both in Ruth's case.
Sure. Well, even stepping back a little, you want to be certain about, is there any medical cause or anything else we should be treating? And so that's where, like when Dr. Merritt was mentioning testing for, could this be related to the mast cell issues? So once you have an appropriate workup and diagnosis, then yes, you want this multidisciplinary treatment. So the psychiatrist figuring out the medication. She's been started on the Zyprexa. She has been at the same dose throughout the jail. It has certainly helped from where she was before, but is it the right dose? Does she need an adjusting of the dose? Is it the best antipsychotic medication for her condition? Is it something where you want to be on a long-acting injectable that you know someone's got in their system because you know that the doctor or nurse gave them the injection? Those are things that can be adjusted and should be looked at for optimal treatment and optimal response. So as well as that piece of it, it's the multidisciplinary treatment, right? So for example, I do evaluations for when someone's appropriate to be released on conditional release into the community, and when some of the things that we are looking at then, the treatments that we want them to have gotten in the hospital, are things aimed at their understanding, their insight, like we were hearing about this morning already as well. So once the diagnosis has been well established, giving her the psychiatric education so that she has the language to understand what the symptoms are, what the diagnosis is, and what her early warning signs are, that she's slipping into having mental health symptoms again, so that she can tell the doctor and the treatment team so that her medications can be adjusted. That's one piece of it. Another piece of it is psychotherapy, working with a psychologist. She has lost her husband, she has lost her son, and she was very mentally unwell at the time of that, and that's all stuff that should be worked through for mental health as well. So it's this different, so on the one side you're trying to get rid of the symptoms with the medication, on the other side you're trying to work on understanding and healing and getting better insight. And she's been doing everything that she's been asked to do, right? She's been taking the medication, she answers all the questions of the evaluators, but she hasn't yet had that opportunity for the psychotherapy, for further understanding about her mental illness, because it hasn't been something that she's had access to yet.
So, if you could put pen to paper and kind of write out the perfect beginning for treatment of Ruth Miller. She walks out of this courtroom and enters into X treatment. What does that look like?
So a secure forensic hospital, Heartland, which is for this area of Ohio, and upon getting there, meeting with her psychiatrist, her psychologist, social workers, nursing, other members of the treatment team who do therapy groups, etc. Getting further evaluated in the hospital. They're observing 24/7, right? So I've seen her for 6.5 hours, give or take, but they would be observing with multiple professionals 24/7, noticing, is she still having symptoms? And as I said before, she's a private person, and sometimes with people like that, when they get in the hospital, sometimes the close observation, you might see symptoms that they might not even notice in themselves. So that's one piece. And then getting further evaluation about the specific diagnosis, if there could be any underlying medical condition contributing to it. Then getting the medications optimized. It occasionally occurs that the first dose of the first medicine that someone tries is the thing that works, but a lot of times there need to be dose adjustments and medication changes. So that all getting assessed. Meanwhile, in the hospital, there's group therapies going on every day, meeting with a psychologist, getting that understanding and insight and literacy about her mental health condition. And I think something that bears remembering, I said she's been following through on everything that she's been asked to do since the offending, but also she comes to this with an 8th grade education, like people in her community have, and so it needs a lot of understanding about mental health conditions that many people with the high school diploma don't have unless they've had someone in their family with a mental illness. So really a lot of learning about this and recognition of it in herself, and then the ability to think about prevention. Now, while she is out of facility, they should be encouraging further interaction with family and reintegration with family. As I said, her parents-in-law and her sister were very supportive when I spoke to them. They'll need education about her mental health condition as well, so that when the work is being done about reintegrating into the family, into the community, so that there's good understanding there. A strong family support can be a huge preventative factor in the future. And the family tried to help before, and the religious leaders tried to help before, but there just wasn't full understanding back then about the condition and about the symptoms, the psychosis and the mood symptoms that she was having. Whereas in the future there would be if they're provided education about it.
If Ruth were subjected to, let's say, a more restrictive setting than that in Hartland, could that actually work to her detriment under these circumstances?
Correct. I mean, we're always trying to think about what's the least restrictive setting for her safety and healing and the community's safety, and there doesn't seem to be any indication for a more secure setting.
And what you testified to here today, do you believe that placement at Heartland Healthcare would best ensure that Ruth will be treated most effectively, that Ruth will be best led to conformity with law, and that the community will be best protected to a reasonable degree of certainty in forensic psychiatry?
Yes, I do.
Is there anything I did not ask you that you think is relevant that the judge should know when making a determination as to placement?
I think these are the important things that at some place like at Heartland itself, she can get the medication treatment, and then as well the therapy that she needs.
Very good. Thank you, Dr. Haddish-Friedman.
Thank you.
No questions, Judge.
Okay. Doctor, that means there are no further questions for you, and you may step down.
Thank you.
Your Honor, on behalf of Ms. Miller, we rest subject to the admission of just simple defense exhibit C and the joint exhibits that were placed on by prosecutor. Thank you.
Okay. Just make sure that I have copies. There have been copies supplied to me before the hearing. Are there marked exhibits as far as a joint exhibit that you would want me to use? Otherwise, I will, if they're already labeled, I would use those. If not, I will utilize what I have.
These are labeled. I guess we should just make sure that you do have, I have labeled as Defense Exhibit A, the report from Dr. Haddish-Friedman. I believe you have that.
Have that.
Very good. Then I have as marked as Defense Exhibit B, the report from dated February 24th, 2026 from Dr. Buffington, Clinical Pharmacology Services, to have that. And then you received our C today. And then I know that the joint from our prosecutor related to Dr. Rinko and Dr. Merritt were provided today, and that was joint.
Well, you've already had the Dr. Merritt one, correct? January 28th, and you do have Dr. Rinko's, which is March 10th.
Okay, that's what
if you want to mark those as joint exhibits, I have no objection. And you should have Dr. Merritt's CV as well.
That's correct. That has been provided. So, with that then, the report from Forensic Diagnostic Center of District 9 that is from Dr. Renko, that is from an evaluation of March the 10th of 2026. The report is also March the 10th of 2026, will be admitted. Defendants exhibits A, B, and C, A being the report from February the 17th from Dr. Hatters-Friedman will be admitted. The February 24th, 2026 report from Dr. Daniel Buffington will be admitted, as well as today's Exhibit C, which essentially is a overview of the Ohio Department of Behavioral Health report involving Heartland Behavioral. That will all be admitted. I'm going to turn one last time to the state. Fred, is there any form of closing summation that you intended to preside or to present regarding this matter, if you wish?
Judge, it's just that you've heard from 4 separate experts today. They all agree that Ms. Miller suffers from a mental illness. I think Dr. Buffington summed it up best. The events of August 25th were the result of years-long untreated severe mental illness. Her history from 2022 through 2025 was a period of escalating symptoms that were exacerbated by stressors, including grief, medical issues, housing instability. All the experts agree that there's much work to be done with respect to insight and education with respect to that mental illness, and all agree that for the protection of the community and as the least restrictive setting, that Heartland Behavioral Health Care is the least restrictive setting, and the state would ask you to follow their recommendations.
Thank you. Ian, if you wish.
Thank you. Very briefly, I had asked Dr. Buffington about the likelihood of whether or not Ruth would have been involved in that tragic day at Atwood Lake, and he said it would have been unlikely had she been receiving the care and medication and so forth that we trust that she will now get, and he believed that we wouldn't be here but for the mental illness that Ruth struggled with and that Ruth tried her best to get help with. Unfortunately, she was unable to get that despite her best efforts, and we're here for really something that is the biggest nightmare, the most tragic thing one could think of. It's an unbelievable situation. So I'm very pleased that all of the experts have agreed that what is in Ruth's best interest, what will give her the best care while also protecting the community, is available, and that they all feel it's available at Heartland Behavioral Health Care. So it's kind of beyond question at this point when you have 4 top experts all saying the same thing after looking into Ruth's history and speaking with her and based upon their best experience. So I also join the state in asking the court to adopt the recommendations that you heard here today.
Thank you. Ruth, I have reviewed the exhibits that are here. I reviewed all of them, other than the report from Heartland, which I'm already familiar with, Heartland Behavioral Health Care. And from those reports, from the testimony that has been presented here today, I think certain things are clear. I think that the evidence has been established, and I would find by clear and convincing evidence that Ruth Miller is a person with a mental illness. There may be some differences of opinion as to what that specific mental illness is, but the statute does not require that there be a unanimous decision as to what that specific illness is. It's clear from everyone who has testified here that you do suffer from a mental illness. I'm then to consider the proper placement for you, and in this case, considering the need to consider the least restrictive setting, as well as keeping in mind public safety, that is also an important consideration here. It is my opinion that committing you into the Department of Mental Health and Addiction Services, specifically to the Heartland Behavioral Health Care Center, is the appropriate placement here that will do really all that's expected, and that is to provide you that medical and mental health component that is needed, as well as to provide security to the community. It is a secured hospital from which individuals cannot just come and go as they please. It is a facility for which you will be confined there. I am going to make that order then from the court that is the least restrictive, proper placement for you going forward. A couple of things to keep in mind. One, the Heartland Behavioral Health Care Center is a facility that treats different types of individuals, different situations come up. Bottom line is they have a waiting list to go into that facility. I'm uncertain as to how quickly you will be able to be moved into that facility. I am going to order that you're held in the jail until that bed is available, but we will contact them today to make sure that is expedited. Second thing is, Ruth, this will not be the last time that you're here. There are review hearings that I know was suggested by others because it makes sense to have review hearings. They're designated by statute in Ohio, and there will be a review hearing in approximately 6 months, and after that every 2 years. Going forward, as to what will happen at those review hearings, we'll have to wait and see. I don't know until we have any type of feedback from those at the hospital. Fred, from the state of Ohio's standpoint, anything further?
Judge, we talked to the victim representative of the family and the children, and they just simply wanted Ms. Miller to know that her children are doing well.
Okay.
Thank
you. Ian, anything further?
No, thank you.
All right. Then, Ms. Miller, I'm going to have you remanded back to the jail. But I certainly recognize the state of the where we find ourselves right now in this case, and I assure you that I will be contacting them to see that they will expedite your placement there as soon as possible. If nothing further, we are adjourned.
Thank you, Judge.
Dan DeRose with 19 News. You've been watching the placement hearing for Ruth Miller, found not guilty by reason of insanity.
All right. Okay, so she's sentenced to Heartland Behavioral Health in Massillon, Ohio. There's going to be status checks on her, status hearings every 2 years. First one is in 6 months, and then after that, every 2 years. I've got one more little thing to play for you guys. So it all depends on how she does in this, and she has to wait because there's no beds available
today. A judge.
There's no beds available, so I don't know. Again, this was in March, so I don't know where she is currently. That I don't know. I'm not sure where she is currently, because this was March, so this was just a few short months ago. I don't know if that bed has opened up or not. All right, let me just check this out real quick.
Ordered Ruth Miller, the woman found not guilty by reason of insanity last week and the death of her 4-year-old son, to be committed to a behavioral health care center.
But this morning, experts shared some new information as to why the tragedy could have been prevented. Annabelle Childers has the details there.
The reason Ruth Miller now wears handcuffs dates back to August 2025, when Tuscarawas County Sheriff's deputies arrived at Atwood Lake and discovered she'd thrown her 4-year-old son into the water.
I gave him to God.
Officials quickly described Ruth Miller's state as one of spiritual delusion. But over the last 6 months, the extent of her mental health issues has become clear as her case went to a bench trial. Last week, Judge Michael Ernest found Miller not guilty by reason of insanity. Friday morning, Ernest listened to testimony from forensic experts to decide where he would send Miller for treatment.
It's my opinion that she had both a psychotic disorder as well as mood symptoms.
All 4 experts agreed Miller has a mental illness, though some believe she has bipolar disorder, others schizophrenia.
Ruth Miller at the time was truly believing that she was getting special messages from God about tasks that she needed to do to prove her devotion.
Experts testified that Miller did seek help leading up to the August incident from a family doctor, but the doctor prescribed her an antidepressant, an inadequate medication for her specific symptoms that ultimately escalated her mental health challenges.
The handling of that first medication actually set up the conditions for something like this, and we see this in clinical practice routinely.
Taking in all the testimony, the judge sided with expert opinions that Ruth Miller should be committed to Heartland Behavioral Health in Massillon. There, Miller will receive a combination of proper medication and solo and group therapy.
And this is not the last time that Ruth Miller will be in court. In 6 months, there's going to be another hearing for the judge to review Miller's progress in healing. And then after that, there will be hearings every 2 years for reassessment. And that's for life. This is an ongoing process.
Wow. All right. Annabelle, thank you very much.
All right. So there you have it. It's going to be an ongoing process for her. I'll put myself here. So just to, it's really interesting. Like, obviously Lindsay Clancy's going on right now. We're not covering that trial. We did the one recap, but we're not going to do another one because YouTube decided that it wasn't meant for us to cover that trial. So we're not going to cover it anymore. But it's really interesting. The little moments that we did cover it. Zoloft was the medication that apparently set Lindsay off, and then here it seems like Zoloft may have been the medication that set Ruth off. You know, both are mothers, both took out their children, both were on Zoloft for a period of time, both heard voices in their heads. It's interesting. It's interesting how that works out. We're not covering Lindsay, but here we are covering a trial that is very similar to Lindsay. So, yeah, YouTube was YouTubing. That is true. All right, so that is going to be a wrap here, you guys. So, really appreciate you spending your afternoon with us. I hope, I don't know if enjoy is the right word to say, but I hope that you found some kind of value out of today's stream. Let us know in the comments. Definitely hit the like button. We have 331 likes, so really appreciate that. Thank you for that support. Thank you for the super chats and the memberships that you guys gave us throughout, and the gifts that you guys gave us throughout the day. Definitely appreciate that. Thank you to our mods. Thank you to Aaron. Aaron just posted something about the rumor of, I hate to air quotes, the rumor about Sean and Rashad getting assaulted. So Aaron just posted about that. There's no verifiable sources that say, or at this point, they are just rumors. So if you guys want to go check that out, she posted that. And then a programming note, tomorrow and Friday, we're going to be doing the road to sentencing for Courtney Clenny, because she's going to be sentenced on Monday. So we have like 17 hours of pretrial hearings and news reports and all kinds of stuff. So we're going to be doing a deep dive into Miss Courtney Clenny and her road to sentencing. So I hope you guys joined us for that. And with that, I will say have a fantastic evening again. Grampy, if you are watching us, I got your girl right here, swishing her tail. This is what I have to deal with. Swishing her little tail. Just grab it. Gotcha. Yeah, I gotcha. Doink. Yeah, I gotcha. Oh, she didn't like that. Oh, I got your little tail. Boink. Oh, it's my good girl. Yeah, it's my good girl. Yeah, I know. Oh, I know. Oh, I know. Oh, I know. You must suffer me. Yes, you must suffer me in my love. I know. You must suffer me in my love. That's a good girl. Yeah, it's a good girl. So, all right, you guys. I know. I'm so torturous to you. I know. I so torture you. I torture you so much. All right, you guys. Thank you so much for joining us. And again, thank you to our mods. Thank you to Aaron. And with that, join us tomorrow. The road to sentencing for Courtney Cunny will begin. And I will see you guys then. In the meantime, take care of yourselves. I know we watch a lot of pretty intense trials, and we tend to get emotional, and just want to make sure that we're all cool with each other. You guys have your opinions, and it's fine. Just make sure you remain respectful and just be cool. I hate to be like that, but literally just be cool with each other. All right. So with that being said, have a fantastic evening, and we'll see you tomorrow. Bye.